Keith, you gonna get them? Huh?
Yeah.
We're back up to the, hey, what's up this way?
Okay, we'll get that out now. All right.
It's yours. Up here for Coop. Coop's here. Call this case.
Just this morning. Just this morning.
All rise. The Fourth Judicial Circuit Court Division CRB in and for Duval County, Florida is now in session. The Honorable Judge Michael Weatherby presiding. You may be seated.
begin, I want to put a couple of matters on the record that have been of some concern to me. Perhaps to explain how we got here today, as well as to make some notations about our process. During the summer of 2005, I want to say late July, I was assigned 4 defendants and their murder cases: Michael Jackson, Tiffany Cole, Alan Wade, and Bruce Nixon. Under our system, and I have to admit, I'm not sure whether it's rule or custom by common sense or something else, but our custom is that once a case is assigned to a judge, it remains with that judge, period. There are some variations to that, of course, but for the most part, once assigned, it remains with that judge. Sometime in 2007, I want to say maybe April or May, I'm not really sure, I went through Bruce Nixon's plea dialogue with him, including a multi-page written agreement and the specifics and detailed terms of his agreement to testify. I then heard him testify in the trial of each of the co-defendants 3 separate times. And after all that was said and done, he was sentenced to 45 years. It is my understanding that under the present system, Nixon's non-compliance, if that's what happens, will return to me at some point in the future. I want to put this on the record in light of the defense's strident objections that I was interjecting myself into the system, into the process, and you can only point out that I may have been injected into it, but not because I particularly want to be here. It's just the way we do things. Weeks ago, if not months, we were all notified by the state attorney that Mr. Nixon was refusing to take the stand. Last week or the week before, I entered an order compelling him to be present before the court for me to determine whether or not he was unavailable in accordance with the terms of certain statute and rules on witnesses and their production. So far as I know, the only reason they brought him here was my order. There were no subpoenas. Mr. Nixon appeared last Thursday morning and was placed under oath. The defense almost immediately objected that I had no right to do so because there was no scenario in which I could interview him, that he was a convict, and essentially that he had no rights. And that he was under sentence. So Mr. Nixon came in, was placed under oath, and apparently changed what he had told the state from "I will not testify" to "I will testify." He was returned to the holding area, and we proceeded with the trial. He came back early afternoon, I don't remember exactly when, but after a lunch break. Mr. Nixon was called to the stand. At the sidebar over here, I asked Mr. Johnson and Mr. Mizrahi to come up. I didn't ask anybody else because I'm just concerned with the number of people over here at the sidebar, and it was a simple question. And my question was if I needed to talk to Mr. Nixon about the probability of him giving conflicting statements. Mr. Mizrahi said he had been briefly touched on that in the back. Mr. Johnson did not answer my question. He simply said we needed to talk about the number of prior felony convictions, which Mr. Mizrahi told him the number. Mr. Nixon, again under oath, took the stand, testified to some parts of his participation in these homicides, and very quickly into the direct examination began to tell the jury and myself and everyone here in the courtroom that he had lied all the other times and that he had been told to do that, and the words had been put in his mouth by his lawyer at the time. Mr. Mizrahi appropriately asked for a break, which I was about to do anyway. My concern, twofold, was that Mr. Nixon was about to commit perjury and expose himself to a possible death penalty in the event that his plea agreement was set aside. and he could be sentenced to death or life. I was also concerned for Mr. Wade, that what Mr. Nixon was going to say in front of the jury might in some way be backwashed on Mr. Wade, even if his attorneys called Mr. Nixon as a witness. Now, of course, the jury left the courtroom. During the conversation I had with Mr. Nixon on the stand, to which the defense objected, I could not say that I believe that Mr. Nixon understood what he was doing and that he was in need of someone other than myself or anybody in this courtroom to tell him what he was exposing himself to. And that he still had the right to testify if he wanted to. The defense, at some point, I will assume that they were talking simply about the system and not about me, suggested that there was some manipulation of the evidence going on and that he should be forced to come in and tell his story to the jury because he had already started to tell it. And I, of course, said that's not going to happen. There was a 10-minute break that I declared because I needed time to calm down. And during the course of that, it occurred to me that I really did need to find someone who was capable with the experience to talk to Mr. Nixon in private as counsel. Mr. Donald Mayer's name came up. I do not recall whether I suggested it or I think perhaps Ms. Abel may have suggested him. In any event, the consensus was that Mr. Mayers, who is well known to the court and counsel in this proceeding as a competent, skilled person, an expert in defense of capital cases, would be an appropriate appointment. One, because of his professional expertise, and two, because he had not had any connection with this case or these defendants in any way during the course of the matter. We took counsel, all participating in this, all agreed that Mr. Mayers was an appropriate choice. We took a recess until Monday. I immediately called Mr. Mayers, who graciously accepted the appointment. I will tell you that I do not, to this moment, even though Mr. Mayers is in here today, I have studiously not asked him what the process is. I will wait for him to tell me and you at the same time as to what Mr. Nixon is. So at this point, I have no clue as to what Mr. Mayers and Mr. Nixon talked about. I am compelled to put on the record, and I do this simply because I'm putting it on the record, that after we left, unbeknownst to me, and I'm not saying that there was an obligation, I'm just saying after we left, I learned that one or more members of the defense team, in private, after he had been brought here by a court order, after he had been placed under oath, someone went back and talked to Mr. Nixon without notice to the state, without the presence of the state. And as I said, I did not learn that until we had left that afternoon. So, that said.
That is not true. Your last assertion is factually untrue. No one talked to Bruce Nixon after that whole thing that happened. Did not happen. I spoke to Bruce Nixon before he ever got on the stand. Alan Mizrahi and I walked back there together. Alan Mizrahi told him he is subject to the death penalty.
Then if that is to be the case, Mr. Johnson, I stand corrected. As I said, I was only putting it on the record because staff had told me that that's what had happened. Now is not the time to discuss it.
I just want to finish what I'm saying because I want to set that story. After Mr. Mizrahi and I spoke with Mr. Nixon, I then walked back there for maybe 15 seconds, which I have a right to do. He was my listed witness. That is when I walked back there. It was very brief, and and that's what happened. No one talked to him after any of that.
Mr. Johnson, as I have said,
Court staff, and I
I
did
only
in
put it on the
full view of
record because, if nothing else, the appearance of impropriety. I have no idea what transpired. I do not want to know. It's just that the appearance is such that you were back there without the state. And I will leave it at that. I have made no aspersions. I've simply put it on the record that that's what I was told, for what it's worth in the future. End of conversation. Mr. Maris. And by the way, Mr. Nixon is in the back. Would you like him to come out now, or would you?
I think we can deal with the issue of whether he can testify
Without him present?
Well, I think I'd like him here.
Okay, he is here. All right. Go ahead, bring him up.
Your Honor, I'm going to provide an order that would appoint me to represent Mr. Nixon. I'll sort out and see what they think the representation entails.
All right.
I feel like it's appropriate given what I understand occurred. There's any possibility that he would be vacated and facing charges. So I'll hand it around for that.
All right, I will, as I indicated to you when we first talked, I'd be more than happy to sign whatever documentation that you think was appropriate. I had not, go ahead, Mr. Mayor.
So after the court actually, I have met with Nixon 4 times. So Thursday, and discuss a variety of things. At this point, it's Mr. Nixon's decision to serve as defendant, right? He feels that it would subject him to possible perjury. Also, as I understood it, possibility that his plea would be vacated as the terms of the agreement describe. So his position today is time to testify further in this matter.
Mr. Nixon, I remind you, you were still under oath. Did you have enough time to talk to Mr. Maris about that?
Yes, sir.
Is that in fact your decision?
Yes, sir.
Have you had enough time to consider everything that Mr. Maris told you? All right, Mr. Nixon, you may step in the back. Thank you for your time, Mr. Maris.
Thank you, Your Honor.
Mr. Mizrahi and/or Mr. Johnson.
Yes, sir. Pursuant to this invitation, state's request is that the court will instruct the jury to disregard testimony of Mr. Nixon in this matter as given in the right to remain silent. Pursuant to his unavailability, the state intends to read in his prior perpetuated testimony of the defense that in addition to the trial testimony, which the state intends to defense wanted to introduce a film-based testimony of Mr. Nixon, the redirect of Mr. Nixon in the Michael Jackson case, and the 3851 testimony of Mr. Nixon, not the
Mr. Johnson, I'm not sure that I'm prepared to tell this jury to disregard what they saw on Thursday, particularly if Mr. Mizrahi is going to continue with the transcripts from the...
Yes, sir. I would agree with that. We would strenuously object to the court button and disregard what they saw on the stand. I also have a number of objections which we are reducing to writing regarding the admissibility of the prior testimony of Mr. Jackson. I'm not prepared to...
Tell me briefly what those would be.
Well, there are a couple issues here. First of all, Mr. Mizrahi rested. He said, then I have no more questions. It would be on the cross. That was it. Another issue is this. Mr. Mizrahi does not get to decide what version he believes is true. If we have an ethical rule that bars us from presenting testimony, perjured testimony to the court, we cannot do that. It is just as if I had a client that said, I'm going to lie up there. I don't get to say, well, I don't think you're lying. You go up there. What we have is Bruce Nixon standing up and saying that I perjured my last testimony. Mr. Mizrahi wasn't present when all this happened, and no one else was. The declarant himself said that testimony is perjured testimony. And so by offering it, it is just as if I offered my client up there who said, I'm about to go lie, and said, no, I don't think he's lying, and putting him up there. It is in fact perjured testimony because the declarant says it's perjured. That is his last statement, and that's where it's been left. That is a standalone issue. I believe it's, we can't put it up there for that reason. Additionally, we have Florida Statute 90.804, which addresses when a witness is unavailable for purposes of hearsay at a trial. And among them, indeed, is the taking of the Fifth Amendment. However, there is also a rule that, and it's 90.804(1)(e), that the declarant is not unavailable under the statute if the exemption, refusal, claim of lack of memory, inability to be present, or absence is due to the procurement or wrongdoing. And I'm not accusing wrongdoing, but I am alleging procurement of the party who is the proponent of his or her statement in preventing the witness from attending or testifying. I would cite Moore v. State, 102, Florida 1135, 1931 case, and it says a prosecuting attorney should not intimidate witnesses by threatening to have them arrested for perjury if they do not tell the truth. Gordon v. State, 104 Southern 2nd, 524, Supreme Court of Florida, 1958, finding that the sworn oath by the witness is enough to put him on notice of perjury, and the state need not advise the witness of the risk for perjury. In the instant matter, the unavailability was clearly the procurement of the state. Bruce Nixon got up on the stand, and the part that bothered me the most is in a capital murder trial where the state is seeking to have this man executed. The main witness stood up on the witness stand and said, I want to tell the truth. The jury was sent out. Mr. Mizrahi jumped up, threatened him with execution if he went on. And I would say that it is a dark day in an American courtroom when a man tries to correct his prior testimony and is shut down with the threat of execution, carted off, given a lawyer, and it takes a bit, and here we are today. And now they want to put in his prior testimony, and there is something inherently wrong. I object under the 6th, 8th, 14th Amendment to the Constitution, and I don't believe this court should let it in.
I find that Mr. Nixon is unavailable because he has exercised his Fifth Amendment right to remain silent. I will also instruct the jury that they do not get to talk or consider the testimony. Mr. Mizrahi, if you will prepare a proposed instruction for me to give the jury at the appropriate time.
Yes, sir. One of the instructions that was given, this is just about his unavailability, I'll have to include the testimony. It says, and this is from Favor v. State 3, 377. It says that the court said that the counsel requested jury instruction stating the witness was not available to prove his argument, and that the jury should draw no inference from his absence. Such an instruction would be required.
I will do that.
I'm not going to spend a lot of time responding to what I just heard, other than to say that the only one in this courtroom that knew what was going to happen was this man. He knew dang well what was going to happen. And
You're talking about Mr. Johnson or Mr.?
I'm talking about Mr. Johnson. I'm tired of being accused of things. They disclosed a letter that Mr. Nixon wrote through the game in 2008 election. They had listed it on the discovery, yet they had never provided it. I had a thumb drive full of discovery, but I never received that letter, which I received on Friday. The other thing that's very interesting is that 15-minute conversation with Mr. Johnson, Mr. Nixon in the back, that he never told anyone about, which I agree is his right. When the court brings Mr. Johnson up to the bench and asks both of us if there's any reason to believe that a man is about to commit perjury, and he knows our prior conversation, Mr. Nixon did not indicate he was going to. I have no idea what went on there in the back. I sit here in the
Because I would only find that I have an absolute right to discuss a witness. He was a listed defense witness. In fact, there's a jury instruction that said there is nothing improper. Now, if he's accusing me of something improper, I would like him to do it explicitly.
I'll do it.
Okay?
If I may, what is improper is when the court asks lawyers and officers of the court if there's anything to worry about a witness, and those officers of the court do not disclose what they know is going to happen, I have a problem. Is that explicit enough?
Alan Lyndell looked at him and said, "You plan on testifying? Yes. What are you going to do? Tell the truth." And that's what he got up and did. And nothing unethical happened between myself and Bruce Nixon, and no one else and Bruce Nixon. And I take great offense at the allegation that anything less than above board happened with him.
As I have said, I declare Mr. Nixon unavailable as a witness because he has exercised his Fifth Amendment right to remain silent. I will hear no further pointing fingers between the two of you. I don't know what happened, but it needs to be part of the record. And I will also point out, unless I am completely wrong, I have received from Ms. Miller a written motion to prohibit the introduction of Mr. Nixon's prior testimony, which I've already read up here on the bench, believe it or not. Sorry?
I have a different motion for Your Honor, if I will interrupt.
Different.
Yes, sir. This reduces in writing what Mr. Johnson just articulated. I wanted to correct on the record that the court had represented that the direct examination of Mr. Nixon was brief, and that's where we took the time to count it.
I said it was brief. It was brief and compared to what I had heard before, Ms. Miller,
Understood.
which was hours of,
Totally understood.
No.
But Mr. Mizrahi did have the opportunity to ask Mr. Nixon over 40 questions.
yeah.
And then Mr. Mizrahi, at the conclusion of the interchange, indicated that he had no more questions for the witness, which our position would be it's time for cross. We have no cross, and therefore his testimony is complete. Therefore, there need be no readback of prior trial testimony. Mr. Nixon is finished. I have a different motion in limiting for Your Honor than the one that's filed. Given the exchange, the defendant is moving in limiting to remove the state from introducing evidence that Mr. Johnson spoke with Mr. Nixon for approximately 15 seconds to correct, not 15 minutes.
I am sure that Mr. Mizrahi has no intention of making reference to that.
Just want to make sure, given the interchange, that obviously there's nothing improper about it.
I started this out by telling you there were things that I think needed to be put on the record. I take no personal side one way or the other. I'm not saying that for a moment, please. And I know Mr. Mizrahi is not going to do that because, of course, there are circumstances in which everybody has a chance to talk to a witness who has been brought in. All right. Mr. Wade was represented by counsel at the last trial, and he had full access to cross-examination of Mr. Nixon at the last trial. That's all that's necessary. So I am not going to prohibit the state from using the prior testimony of Mr. Nixon. That said, I don't know, certainly the defense has the right to whatever cross there is or whatever other consistent or inconsistent statements that Mr. Nixon may have made. I'm open for suggestions on that, Mr. Johnson.
Well, Judge, I believe that this court is ruling that the prior testimony comes in, then the testimony, the sworn testimony that occurred after the jury was brought out of the courtroom, his words, words to the effect that I lied before, it was because I was coached, I committed perjury previously, I want to tell the truth now. Clearly that is admissible if the reading comes in.
I have decided that it is not. He exercised his Fifth Amendment right, and under the circumstances of this whole thing, I am not going to let this jury hear about that. You can add whatever arguments you may want to about the trial transcript, but I am going to instruct the jury that they are not to consider anything that Mr. Nixon said on Thursday.
If we would request proper testimony, we have it in writing, we'll make it part of the record of Bruce Nixon's testimony on
right in front of the record. What are you talking about? It's right here.
And Judge, specifically, one, the statement should be admissible because they are statements against his penal interest, clearly.
I have ruled, Mr. Johnson.
Judge, I would just like to have my objection fully.
You objected. I don't need to hear what your grounds are or the law. I understand what you're saying. You don't want him.
I need to articulate the grounds for certain, Judge. It's a statement against his penal interest.
It is.
Two, it clearly goes to his credibility. Three, it is a prior inconsistent statement, prior being that it was made before the statements are published. The evidence code does not contemplate a future inconsistent statement because that would be impossible. It's prior to the statements being proffered for fully in front of the jury.
I understand. Nevertheless, that is my ruling.
And I have one question.
I may not answer it, but you can ask.
The court's prior ruling, I was confused by when the court ruled that the jury is not going to be told to disregard his prior testimony.
Yes.
It is?
Yes.
The court ruled
What I've just said.
at first that
I changed my mind. After having heard your argument and being concerned about, I changed my mind. All of that said, now, Ms. Rahi, we remain in the state's case as far as I'm concerned. Who will be or what will be the next step?
The next step will be Mr. Kalinowski, who's graciously agreed to Nixon's testimony. As I mentioned previously, we will be doing not only his testimony in the trial, pursuant to counsel's request, defense counsel's request, we'll be doing the penalty phase and the 3851 pursuant to that.
By Mr. Nixon.
Mr. Nixon.
Okay. There is one housekeeping matter, counsel, I forgot before you. Blake.
Judge, we talked about the 3851. I'm not sure about the penalty phase. Read it. I just need
I will have to trust whatever, that's not what I wanted to talk to you about.
Okay.
The last thing that we talked about on Thursday was Ms. Campbell. I think her name is Campbell, the juror.
Yes, sir.
We would just strike at this point.
Our request is the same. Generally, I would have objections. She's at the ultimate case of the trial. It's prudent to keep her on. But the instructions that should not discuss the case, obviously, given, and we can make sure we have an insurance back on her, sure that we're all on objections. There has been no evidence to show that she's not.
Well, my concern, I'm not, this is what I would suggest. I'm not prepared to strike her at this point without knowing more. I mean, there was not enough questions at all. I have told you that I have been told that it's likely that Ms. Campbell knows nothing of Judge Carbula's participation as an assistant attorney general in this case. That came from Judge Carbula. I am willing to bring Mrs. Campbell, or, it is Campbell, isn't it? Yeah. I'm willing to bring her out and ask her if what she may or might not know about, whether or not she even knew that Judge Carbula was involved in this. And if she said yes, fine. And if not, would that in any way affect her participation in the trial? I don't think I can just summarily excuse her because of what, the information we received was. I will agree that bringing her out and asking her about that question may, point out.
How did Judge Carbula know she was a juror in this case?
I don't know. I just know that the general counsel came, actually she came the day before and said, and she came in and she said, I don't remember what she said, but apparently Judge Carbula had sent word to her that she had seen the list or something like that, and that so-and-so was in the jury panel. Well, but, let me finish. But, and I looked at the name, that name was not here. She was not part of the panel. Right. So I didn't ask any further questions. Then Thursday, General Counsel Burke comes back in, Court Counsel Burke comes back in and says, well, turns out that she changed her name. I do not know whether it was divorce or marriage or what, but I looked, and in fact, there is a Mrs. Campbell in our box.
My concern is obviously I wish that had been brought to our attention prior to selecting the jury, but the court had that information.
I shared with you exactly what I had.
I know, but we didn't know that until after the jury was already seated and sworn.
Neither did I.
No, I believe the staff attorney came in prior to us.
You did not. I did not know that Ms. Campbell was Judge Carbula's person until the jury had already been sworn.
So my concern is.
This was Thursday afternoon.
Okay, so my concern is, of course, that Judge Carbula knew somehow, right, that this person who she's friends with enough so to bring it to your honor's attention is on this jury, which I don't know if that was.
Ms. Wilson, for all I know, Ms. Miller, for all I know, Judge Carbula did the jury qualification. I don't know. I will be glad to ask.
Well, then that's even more, so here's my concern, right, is that Ms. Campbell may not have drawn any connection between Ms. Carbula and this case. We then asked Ms. Campbell about her relationship.
Okay, that's fine.
We then asked Ms. Campbell, so right, Ms. Campbell may not have drawn any connection between her relationship with Ms. Carbula and this case. If we asked Ms. Campbell, we are now suggesting.
Yes, I agree. I understand.
So, I mean, I'm certainly going to accept the court's offer to speak with Ms. Campbell, but I think the appropriate, more appropriate, or safest remedy would be to strike her. I have no objection to Mr. Mizrahi's suggestion that perhaps we should substitute Ms. Campbell for an alternate, and the first alternate, Mr. Barber.
You guys get together on this, please.
I think the state and defense are in agreement on this. I mean, Mr. Mizrahi, correct me if I'm wrong, but that was my understanding that we were.
We discussed that Thursday,
Okay.
and the parting comment from the court is, this is what we're going to do about this. Nothing. And that's what we did. Speaking of court counsel, who just walked in the back.
I'm sure she's pretty about to be honest.
I did not bring her. She's just here. No.
I'm going to question Ms. Campbell without suggesting that Ms. Carbula was involved in this case at one point as an assistant attorney general. Obviously, Ms. Carbula's role would have been trying to uphold the death sentence on this case. If they're friends to the extent that Ms. Carbula felt the need to bring it to your honor's attention, certainly this juror would know what her friend did for a living. And so then there's a whole host of issues.
I don't know that. I know that when this happened 20 years ago, or whatever it was, 15, Judge Carbula lived in Tallahassee. She did not live in Jacksonville. She was an assistant attorney general. This case may have been my first exposure to her. Since that time, she moved to Jacksonville, became a county judge and then a circuit judge, and now she's sitting on the, actually she came in, went to work for the state attorney's office here in Jacksonville, and then went on to the bench. So it's certainly possible.
No, she was the assistant attorney general and the prosecutor.
Yes.
And so would have been seeking to uphold the death sentence.
Yes, I
And
know.
so obviously we agree that a juror is not entitled to know that Mr. Wade was previously sentenced to die. We now have a woman on our jury who has a relationship with a prosecutor who is seeking to uphold a prior death sentence. You certainly should be able to.
That nobody knew about. You all asked about participation in trials and law, the system. It never came up. There was nobody, no one ever asked, do you know any circuit judges? Do you know anybody that is criminal prosecutors? None of that came up. It came up just because, I will tell you that I have seen friends' names on jury. We frequently get the list of jurors. And I have shared with other judges, people that I thought may be on the list. I just need to know what's appropriate under the circumstances. This is Monday. Mr. Johnson, I expect you're going to go through to Wednesday anyway. That was the plan, was it not? This was on this. Well, I'm just saying, and if Ms. Campbell is released, that still gives us one alternate.
That's what we're. asking to make a ruling that she be substituted as an alternate juror to regardless serve on the jury. Yeah, I'm not suggesting anything untoward happened, but it's at this point.
All right, but how about this? How about this? I think we talked about this, and this may be what you're talking about. Amongst us, Ms. Campbell becomes alternate 2.
Yes, we agree.
And if it gets to the point, then we ask her about the problem.
Totally agree.
And so that would mean that whoever was alternate 1 now becomes part of the family. What is it? Barbara? Okay. Does that work for you, Ms. Ron?
Works, Your Honor.
All right, so Ms. Campbell is now alternate 2.
Thanks, sir.
All right.
Your Honor, just for the record, we did make, I know you already ruled this, Your Honor, about reducing any writing. We did make 2 motions for Your Honor to disqualify himself from this, and they were denied, so we're reducing that to writing, Your Honor. And also, I will renew that motion based on the fact that, Your Honor, your statement was, you believe would be commenting on that, on those motions. It's not allowed by the rule, Your Honor.
What?
You said you commented on our motion for you to recuse yourself because you interjected yourself in the proceedings. You made a statement commenting on that, Your Honor, basically. So that's basically, I would argue, Your Honor, that's you commenting on our motion.
You made the objection that I was interjecting myself.
That's correct, Your Honor. I moved to disqualify.
And I overruled it.
There wasn't an objection, Your Honor, to the motion to disqualify you. So my argument, just for the record, Your Honor, I understand, is basically that you commenting on the motion to disqualify.
All right, well, the record will speak for itself. The motion is denied. Mr. Mizrahi.
Your Honor, Mr. Cooper's preparing an instruction. Reading the record, we're emailing it to all the parties now. Instruction. The state is requesting, Your Honor, reading Bruce Nixon is not available to either side as a witness, and the jury should draw no inference from his absence. The jury should also disregard Bruce Nixon's limited testimony that took place on Thursday, July 9, 2000. June 9, 2001.
And I understand there's an objection.
Objective, and of course, I ruled that objected. I think that the language needs to be, because it's asserting
Not going to do it. Would you send a copy to the clerk so that she can print it out, please? And I will, actually, I think I will do that before.
We were asking this, that the state has read an instruction that says he's unavailable, and so to me, it lends itself to, did he die, did something happen to him, and so really what's most proper and most informative and not misleading would be to say Mr. Nixon is now unavailable because he's asserted his right against self-incrimination.
I'm not going to do that, Ms. Miller.
So we're just going to let the jury
Tell him, he is, I have declared, I don't care what, I'm just not going to say that he's asserted his Fifth Amendment rights, because the jury's not going to say, I don't want them going off. Well, what did that mean? What did he, is he about to be crowned? Ain't going to happen. That's not for that jury to decide. I will be happy to say that I have declared him unavailable, or that I've forbidden the I don't,
They get to decide if he's a credible witness, and so they're
No,
going
they don't.
Yes, that's 100% in the foray of the fact finder.
Based on the testimony that they're going to hear.
Right, but they're being told he's unavailable. It's not because
What
he's
would you
not
like me to,
here.
I'm not going to tell them that he exercised the constitutional right. It's not going to happen. What else would you like me to tell them?
I think what-
Standard instruction simply says he's unavailable.
That's not the standard instruction.
The instruction we took in part from the case laws that they gave before in favor. And I think it's, although Satan had no problem if the court said, I have declared him unavailable to do that.
That puts me in an audience. I'm not going to do that either.
Yeah, I think it's better to just say he's unavailable and not to draw any inference from him.
All right.
So I think it's accomplished.
To be clear, that's not a standard instruction.
Okay, that's fine. I understand. All right, if you'll send that to my clerk for printing. And I will read that to the jury, I think, when that was the last thing that happened to them.
The first thing Your Honor should do is read that instruction and say, Your Honor, this time we would be entering in Mr. Nixon's perpetual testimony. I'll wait to hear from the defense about whether or not they want penalty for this testimony. I think it's best if we do the 3851, which probably becomes
I need just.
I'm sorry, I'm
There
not,
were, I'm sorry, there were three different testimonies. One that Mr. Kalinowski is not, which is the redirect of Mr. Nixon, Jackson, which the state was agreeing about.
Mr. Smith, do you need me?
No, sir.
We have another brief
I'm sorry?
I have a brief matter.
Okay.
I have a motion to eliminate. That I briefly discussed with the state of Everett, and it deals with, so several days ago, we happened to see while Mr. Rodney was flipping through his PowerPoint, it was displayed on all our screens, it was a picture of Mr. Wade and a female and a small child. We are moving to limit to prohibit the state from making unproven allegations that Mr. Wade somehow fathered a child from death row. They are salacious internet.
Didn't we argue this already, Frank? I thought what I said is that it's not coming in until Mr. Mizrahi can establish that it's relevant.
That's correct, Your Honor, that's what I've agreed with, it's not for the jury, I will call
I
for
don't disagree, Mr. Johnson.
And Judge, and I would only just add to that, that I would assert that there is no way that it could become relevant because it is an unproven allegation. There is no proof anywhere.
Mr. Johnson, in the same continuing conversation, I have told you that I believe it is Mr. Wade's right to allocute to the jury. We will talk about how that happens later. I agree. But I also understand Mr. Mizrahi's that depending on what Mr. Wade says or doesn't say, I'm not committing to this, but I'm probably not going to let it in. It's going to take a fairly high burden for Mr. Mizrahi for me to let that sort of thing in this circumstance, because right now, it just,
Additionally, I can advise the court that you will be calling a witness that will talk about Mr. Wade's prison behavior, good behavior, lack of disciplinary report.
I understand.
There is not a disciplinary report that has anything to do with any of what we're talking about today. And I think I would just ask the court for a rule. That's what he intends will open to, where he expressed that verbally. There's nothing in any of these disciplinary records that would even suggest that it would be anything of the sort. And I would just ask the court to consider that.
I did. You told me the same thing last week, Blake. I agree. Yes, you're right.
Additionally, Judge, I have
Mizrahi, do you understand that you will not mention anything about that until I have said you can?
Absolutely. I have one additional motion in limine. It is similar. It deals with Mr. Wade's marriage. It is not relevant. It is a statutory aggravator. The inmate has a constitutional right to marry, and we believe that Mr. Robbins tried to bring this up in his effort to present a non-statutory aggravator. It's similar to the argument regarding the child. We said that there's just no relevance in this. I know that the state intends to bring it up. It's not bad behavior. It doesn't cut against the good prison behavior, and there's just no relevance in this proceeding.
Same. I'm not going to use either one of those factors until I have, one, I believe the door has been opened, I believe the door has been opened, I will properly outside of this.
All right, that's fair. Did you resolve the matter of,
I think we need a few minutes for them to get.
well, the jury's not even here yet.
We started.
They're not, what I was going to say is, have you resolved the matter of whatever transcripts are going to be read, anything like that? You're talking about, okay.
I'm just waiting here.
I'm sorry. I didn't hear the court.
I'm just asking if you would resolve the matter, whatever transcripts are going to be used. We don't have a jury here yet, Mr. Johnson.
I'm gonna need a minute.
My clerk has indicated that there are some exhibits that we may need to discuss marking. You want to do that now or just later on?
I've already provided them to the clerk, and the statement stipulated to the court.
Oh, okay, okay, so we don't need to do that on it.
Yes, sir, that's taken care of.
Judge, I think we fired it out.
I'm sorry?
We fired it out.
Okay. Then, since we don't have, by the way, apparently we did correct the plumbing problem. I say we. So the jury will be using, I guess, this room over here. All right, are there any other administrative matters that we, need to discuss before the jury gets here? Because if not, I propose to take a short recess.
We need a short recess.
Can I just need a moment? I believe Mr. Cooper, Mr. Mizrahi sent Mr. Johnson the proposed instruction. Mr. Mizrahi's kind of providing a case, so I just need a moment for review all that.
Well, that's fine. I mean, the jury's going to be in the jury room when we resume anyway, so we can address it when we get back. Okay. All right, we'll be in a recess until we have a jury.
is Jackson.
Yeah. Yeah.
Now they're 15 and 8 years old.
Sorry, everyone's okay. It's hard to lose people with the internet, right? With the Facebook. With the Facebook. Yeah, you don't have to work with it. He's allowed to. He's allowed to Instagram. Tweet. All right, so once we're done with Bruce's stuff, then we'll be able to. Once you're done, I'll say thank you. Sumner, and then we'll get back.
right, we are in the courtroom. Mr. Wade is present. I understand we have all of our juries in the jury room. Are we ready to proceed? Ms. Miller, you had, I'm sorry.
Obviously, we're disagreeing, or we're continuously objecting to the construction, and we're asking to be told the nature of the unavailability. But
Okay.
given the court's ruling, the only objection I have is to the word limited. So the construction reads, Bruce Nixon is not available to either side as a witness, and the jury should draw no inference from his absence, which I would agree is supported by the Faber case, if the court's given the instruction over our objection. The second sentence is the jury should also disregard Bruce Nixon's limited testimony that took place on Thursday, June 9th, 2022. Again, that is characterization that the statements made, the defense would vehemently disagree with.
So you're suggesting I simply drop the word limited?
Yes, if, again, we're objecting to the
I understand.
instruction in its entirety.
I understand.
All right.
I have no problems with that. It is only limited in my mind because I know, well, as I pointed out before, the length of others. Are we otherwise ready to proceed then, Mr. Mizrahi? Mr. Johnson?
Yes, sir.
All right, if you'll have the jury join us, please.
Jurors are entered in courtroom.
All right, our jury has returned. Please seated, ladies and gentlemen. Good morning. We remain in the state's case. I have a preliminary matter that I want to address with you before Mr. Mizrahi proceeds. And I will point out to you that Mr. Nixon, that was the last witness that you heard on Thursday, is not available to either side as a witness, and you should draw no inference at all from his absence. You should also disregard Mr. Nixon's testimony that took place Thursday afternoon. Okay? Mr. Mizrahi.
Around this time, the state would be introducing Mr. Nixon's prior testimony in this matter. Have Mr. Kalinowski from our office.
Mr. Kalinowski, if you'd come up and take the stand, please. Ladies and gentlemen, this will be pretty much as we did last week with the one witness. This is testimony from a prior proceeding. Mr. Mizrahi will ask the questions on direct, and Mr. Kalinowski will answer, and one of defense counsel will pose cross-examination questions from the same transcript. Mr. Mizrahi.
And may it please the court. Just making sure the witness is ready. You ready? Very
Yes,
good.
thank you.
Please state your name for the record.
Bruce Kent Nixon, Jr.,
What is your date of birth?
May 9th, 1987.
How old are you today?
I'm 20,
How old were you back in July of 2005?
18.
Back in July of 2005, what were your plans for the fall of 2005?
I was going to go back to school, play basketball or something.
What school was that?
Baker County.
What grade would you have been in Baker County High School?
12th.
Where have you been living since July 15th of 2005?
Duval County Jail.
Now tell the jury about your size when you were arrested on June 15th, 2005.
About 5'11", weighed about 160, about 155.
And what is your size today?
I'm about 6'2", I weigh about 185, 190 somewhere.
Why have you been living in jail since July 15th, 2005?
I participated in the murder of the Sumners.
Of who?
Sumners.
Was that Carol and Reggie Sumner?
Yes, sir.
Are you guilty of participating in that murder?
Yes, sir.
Are you guilty of kidnapping Carol and Reggie Sumner?
Yes, sir.
Are you guilty of robbing them?
Yes, sir.
Are you guilty of killing them?
Yes, sir.
Are you guilty of killing them?
Yes, sir.
Have you pled guilty to those charges?
Yes, sir.
Who participated in that crime with you?
Me, Alan Wade, Tiffany Cole, and Michael Jackson.
And do you see Alan Wade here in court?
Yes, sir.
Would you please point to him and say where he's seated?
Right there.
Your Honor, may the record indicate the witness has identified the defendant. And the court says it may. Showing what's been entered into evidence is State's Exhibit 125. Who is this?
Tiffany Cole,
State's 124.
Michael Jackson.
State's 126.
That's Alan.
State's 127.
That's me.
Please tell the jury how you first became involved in the plot to kill Carol and Reggie Sumner.
Alan came over with the RX-8, came over to my house, and he asked me about robbing somebody.
Describe the Mazda RX-8 for the jury.
It's like brownish gray, like silver color.
Was Alan Wade alone when he came and discussed this plot with you?
Yes, sir.
In relation to when the Sumners were abducted, how long before, approximately, did you have that conversation with Alan Wade?
About 2 weeks, somewhere around there.
Do you know for sure that it was 2 weeks?
No, I don't really know how long it was, but it was a couple weeks before that.
Did he give you any details about killing at that time or the robbery at that time?
No, sir.
At that time, did you know it was going to be a murder?
No, sir.
Did he tell you anything about the Sumners or how old they were or anything like that?
No, sir.
Did you tell Alan Wade at that point that you wanted to be involved in the robbery?
No, sir.
It wasn't discussed anything further than Alan Wade had planned to rob people?
No, sir.
What was the next thing that happened that got you involved in the case?
He called me one night and asked me if I wanted to go with them and help them dig a hole.
Who called you?
Alan.
And how did Alan Wade call you?
He called me and asked me if I wanted to dig a hole.
Did he call you on your cell phone?
Yes, sir.
And tell the jury what words the defendant used, if you can remember.
What do you mean?
Well, what did he say to you? If you specifically, what words did he say to you about digging a hole?
He said we're going to dig a hole and rob somebody.
What did you say to that?
I said, yeah.
When Alan Wade told you those words, did you know who Michael Jackson was?
No, sir.
Did you know who Tiffany Cole was?
No, sir.
Have you ever met either of them? Have you ever met either of them in your life?
No, sir.
So what did you do in preparation for digging this hole with Alan Wade?
I went and got shovels.
Tell the jury about that.
I went around the neighborhood looking for shovels and stuff, like looking for sheds and stuff, and I seen it leaning up against the shed, so I grabbed it. I grabbed 4 of them.
When did Alan Wade get to your house to pick you up?
About 20 minutes later.
What time of the day was this approximately?
At night.
It was late?
Yes, sir.
When he picked you up, what car was he driving or what was he in?
RX-8.
The same Mazda RX-8 that you were in 2 weeks earlier?
Yes, sir.
Tell the jury who was with the defendant, Alan Wade.
Tiffany Cole and Michael Jackson.
Is this the first time you met Michael Jackson and Tiffany Cole?
Yes, sir.
Tell the jury how many shovels you had.
4 of them.
Showing you what's been entered into evidence is State 665. Are these the 4 shovels you took?
Yes, sir.
Where did you and those 4 shovels, Tiffany Cole, Alan Wade, and Michael Jackson, go?
Go looking for a hole, somewhere to dig a hole.
Tell the jury where y'all went.
We went over to where I used to stay in Georgia. We went down the road, and it wasn't a good spot. So we went across the street and down the road, and it looked like some woods. So we went in there and looked for it.
When y'all were deciding what place to dig this hole, was everyone participating in the decision as to where to dig it?
Yeah. Yes, sir.
Where were you seated in the Mazda?
Back seat.
Who was sitting next to you?
Alan,
Who was in the front seat?
Michael Jackson, and Tiffany Cole.
Tell the jury what happened when you finally found a place to dig this hole.
After we found a hole, we started digging a hole. Tiffany was holding a light while we was digging a hole.
Tiffany Cole held what?
She held the light while I was digging the hole.
A flashlight?
Yes, sir.
And who dug the hole?
Me, Alan Wade, and Tiffany, Michael Jackson.
All right, the 3 of y'all did?
Yes, sir.
What shovels did you use?
The 2 middle ones.
This one, and this one?
Yes, sir.
And how did the 3 of y'all use 2 shovels?
We took turns.
Who did the majority of the digging?
Me and Alan.
And why was that?
We were strong.
Now, Bruce, at this point, do you know what Alan Wade, Tiffany Cole, and Michael Jackson had discussed in reference to this crime?
No, sir.
And all you know is that all you know is what Alan Wade has told you.
Yes, sir.
Tell the jury at this point, when you're digging the hole, what is your knowledge about what's going to happen?
That a robbery going to be taking place?
And how was the hole going to be related to the robbery?
How? I didn't know then.
Did you know the hole was related to the robbery?
Yes, sir.
In some fashion?
Yes, sir.
How long did it take you to dig the hole?
About 30 minutes.
How big was the hole approximately?
About 6 foot long by 4 foot deep.
And when you're done digging the hole, what do you do with the shovels?
We keep them there.
Where was the Mazda while you were digging the hole?
Out at the gate?
So the Mazda couldn't get back to the actual hole?
No. No, sir.
That's a no?
No, sir.
And you left the shovels at the hole?
Yes, sir.
What happened when you went back into the Mazda?
We started driving back to my house.
And then what was the next step in this plot?
Well, Alan asked if I can go with him. Alan asked Michael Jackson.
What do you mean, go with him? Explain that to the jury.
Go with them. He asked him if I could go with them to help them do it.
He asked Michael Jackson?
Yes, sir.
He being Alan Wade?
Yes, sir.
What did Michael Jackson say?
Michael Jackson said, yeah. He said he can go, talking about me.
Now tell the jury what you soon after that learned about what the actual plot was.
It was, we were trying to figure out if we were going to wait on them to come home, or if we were going to be there, wait on them to come home, or go in there while they're home.
Okay, so who are you talking about?
The Sumners.
So there was a discussion as to whether or not you could actually be inside the home waiting for them to come in before you took them,
Yes, sir.
or whether or not you would actually go into the home when they were there.
Yes, sir.
What was your knowledge about whether or not the Sumners were going to be killed?
Michael Jackson was going to do it.
Michael Jackson was going to kill the Sumners?
Yes, sir.
And when did you know that?
We were talking about it, when we were having a conversation about it, it came up. He said he was going to do it with a shot.
A shot?
Yes, sir.
Who was having these conversations with you and Michael Jackson about how you were going to commit this crime and how the Sumners were going to die?
All of us.
All of you? Please tell the jury what names.
Tiffany, Alan Wade, Michael Jackson, everybody.
Everybody was participating in these conversations?
Yes, sir.
At what point did you know what the hole you had just dug was for?
Yes, sir.
And what was the hole for?
For the Sumners.
For the Sumners?
Yes, sir.
And you knew this before you ever went into their house?
Yes, sir.
Tell the jury what other preparations were made to commit this crime.
They had gloves, and they had a gun, a toy gun.
Tell the jury about this toy gun.
It was one of them little It's not no BB gun, but it's got a little plastic pellets, I think.
Like little yellow pellets?
Yes, sir.
Now, we talked about a shot. I want to make sure the jury understands. What kind of shot are you talking about? Are you talking about with a gun?
What do you mean?
When you say Michael Jackson was going to kill the Sumners, explain that.
No, shot with medicine, a needle.
Like a needle, not a gun.
Yes, sir.
So there was a plastic gun, gloves. Were there any preparations made in casing the house or calling the Sumners? Tell the jury about that.
We were driving around the house looking at the houses and how we were going to do it and stuff.
And who was driving?
Tiffany Cole,
And who else was in the Mazda with her?
me, Michael Jackson, and Alan.
And in relation to when you pre-dug the grave, when are you riding by the house?
The day later, next day?
The next day, and it was in the daytime?
Yes, sir.
Was Tiffany Cole calling the Sumners?
Yes, sir.
Who had cell phones at that particular time?
Me, Tiffany, Michael Jackson.
And did you have each other's numbers programmed in your cell phone?
Yes, sir.
Do you know if Michael Jackson had two phones or one phone?
No, sir.
Now, why are you doing this? Why are you participating in this plan?
For money.
Tell the jury why you would do something like that for money.
Because I ain't really have nobody to support me, so the only way I thought to get money was to do this.
How much money was discussed?
$200,000.
How much?
$200,000?
200,000?
Yes, sir.
In preparation for this crime, did you, Alan Wade, Tiffany Cole, and Michael Jackson ever go to an office depot?
Yes, sir.
And what were you doing in that office depot?
Walking around the store.
What was Alan Wade doing?
He was walking around the store with me.
What was purchased at the office depot?
All I seen was they got saran wrap. I don't know what else they got. That's the only main thing that I seen.
Did it look something like States 80?
Yes, sir.
So you saw this?
Yes, sir.
Because it was so big. Who bought it?
Tiffany and Michael Jackson.
Tiffany and Michael did?
Yes, sir.
After they went to Office Depot, how long before you went over to the Sumner house?
I'm not sure.
When you went to the Sumner house, were you supplied duct tape to use?
Yes, sir.
Who actually carried the duct tape?
Alan.
The defendant, Alan Wade?
Yes, sir.
What did you have when you went over to the Sumner house?
I had a gun.
You had the plastic gun?
Yes, sir.
What time of day did y'all go over to commit this crime?
About 10 o'clock at night.
Did you ever reach the decision as to whether or not you would wait for them inside the home or whether you would just go in?
Yes, sir. We decided that we were going to go in while they were at home.
How did y'all get to the Sumner home?
Tiffany Cole drove.
Who was in the car when you drove over there?
Me, Alan, and Michael Jackson.
Who decided who would go into the house?
Decided me and Alan was going to go in.
Where were you dropped off in relation to the home?
At the park right by the house?
It's not far?
No, sir.
Tell the jury what you and Alan Wade did next.
After that, we got out of the car, walked up to the house. We got the gloves on, and we knocked on the door, and Miss Sumner came to the door. We asked to use the phone.
Who knocked on the door?
Me and Alan,
Who asked Carol Sumner to use the phone?
both of us.
Y'all were standing right next to each other?
Yes, sir.
And you both had gloves on?
Yes, sir.
Where was the gun at this point?
I had it in my belt right here.
Where was the duct tape at this point?
Alan had it in his belt.
Where was Tiffany Cole and Michael Jackson?
They're out in the car.
What was the plan in relation to where Michael Jackson would be during this process?
He was going to be out in the car until we covered up their eyes so the Sumners couldn't see him.
So the plan was to cover up their eyes so they couldn't see,
Yes, sir.
and then Michael Jackson would come in.
He was going to come in, yes, sir.
Now, why would you have to cover up people's eyes so they couldn't see if the plan was to give them a shot and bury them in this grave?
Mike said it was a mind thing, that when he killed them, he didn't want them to see him or something like that.
Okay, that's what Michael Jackson told you?
Yes, sir.
And Michael Jackson often referred to psychological things and mind things like that?
Yes, sir.
Was Michael Jackson calling the shots in this case?
Yes, sir.
Are you fully participating?
Yes, sir.
Is Tiffany Cole fully participating?
Yes, sir.
And is this defendant, Alan Wade, fully participating?
Yes, sir.
Now, what happens when that door opens up and you ask to use the phone, you and Alan Wade?
We walk in the house. We walk in the house and pulled out the phone, and then we were walking in. Alan grabbed Mr. Sumner and sat him down in the chair. Then I pulled out the gun. That's when we said, you know what I'm saying, we need your bank cards and stuff.
Was the plan to rob the Sumners of jewelry and cash?
No, sir. For the credit card, for the card.
Tell the jury who pulled out the phone line.
Sir?
Who pulled out that phone line?
Alan Wade.
And what were you doing when Alan Wade, right after he pulls out the phone line?
I had the gun on Mr. and Mrs. Sumner.
Describe the gun a little bit more. Did it look real?
Yes, sir. It looked real, but it wasn't real.
What were the Sumners doing after Alan Wade grabbed Mr. Sumner around the neck and put him on the couch?
What'd they do?
What were they doing?
Miss Sumner crying, and she was just saying, don't hurt me, and stuff like that.
What did you say in response to that?
I told them everything was going to be all right. You know what I'm saying? Just try to calm them down.
And did you have the gun out and pointed towards them?
Yes, sir.
What happened next with the duct tape?
I brought Mr. and Mrs. Sumner in the room, and I duct taped their legs and their hands together, and I stood in the room with them.
Did you duct tape any other parts of their bodies?
Yes, sir, on their eyes, so Michael Jackson could come in, and so they can't see him.
Did you cover their mouths
Yes, sir, I covered their mouths.
so they couldn't scream?
Yes, sir.
Now, at that point, how did y'all get Michael Jackson into the house?
He beeped me and said, you ready? I said, yeah, you can come in. He came in.
On your Nextels?
Yes, sir.
Showing the jury what's been entered into evidence as State's Exhibit 46, does this appear to be the type of duct tape that you used to bind the Sumners?
Yes, sir.
Showing what's been entered as State's 48, does this appear to be the door that Alan Wade knocked on?
Yes, sir.
And State's Exhibit 56, is this the spare bedroom where you kept Carol and Reggie Sumner in bed with a gun and had duct tape on?
Yes, sir.
And who was in the room in State's 56 with you and the Sumners? Who else was there? Was anyone else there?
No, sir.
Tell the jury what was happening while you were guarding the Sumners.
Michael Jackson and Alan were going around looking for bank statements and stuff.
Did they know where the bank statements specifically were?
No, sir.
Was a large pile of mail and statements actually taken from the home?
Yes, sir.
And who were the two people that were looking for those bank statements?
Michael and Alan.
What was the next thing that happened after they found what they were looking for?
Michael Jackson went out to the car and told us to bring Mr. and Mrs. Sumner into the Lincoln.
And did you do that?
Yes, sir.
What happened when you got there?
When we got to the Lincoln,
Yes, sir.
we were helping them in the car. We put them in the trunk.
Did you give anyone any water or anything like that?
Yes, sir.
Tell the jury about that.
Miss Sumner said she was thirsty, so I walked over to the refrigerator and got her a bottled water.
How did she drink the bottled water if she had tape on her mouth?
I took the tape off of her mouth.
Did you put it back on?
Yes, sir.
Tell the jury how the Sumners were able to get into the trunk.
We helped them in there. Me and Alan helped them.
Where are the Sumners doing at this point?
Laying in the back of the trunk.
What was the plan once they were inside the trunk?
We were going to drive to the hole.
Before you ever went in that house, did y'all describe or discuss how you were going to avoid police contact?
Yes, sir. Michael Jackson said that while we were driving the car, if the police stop us, that he was going to drive ahead and make it look like, to make them chase them, make a diversion.
What happened when you got into the Lincoln?
We drove out to the hole.
Who drove?
Alan Wade.
Who was in the passenger seat?
I was.
Where did you go before you went to the hole?
Sir?
Did you go somewhere before you went to the hole?
Yes, sir. We went to the gas station.
Tell the jury about that.
The gas needle was on empty, so we went and filled up the car.
Did you go to the gas station that was near the home?
Yes, sir.
Near the house?
A little bit down the road.
And who filled the Lincoln with gas?
It was me or Alan. I don't really remember which one it was.
Who paid for it?
Michael Jackson.
And was Michael Jackson and Tiffany Cole there?
Yes, sir.
What car were they driving?
The RX-8.
After you got the gas and paid for it, is that when you headed out to the hole?
Yes, sir.
I'm going to show you Stage 47, Mr. Nixon, just to show the jury the path you took. The Sumner house was on Reed Avenue?
Yes, sir.
And Reed Avenue is where on this map?
Reed Avenue?
Yeah, where the Sumners are. Is that indicated by a dot on the map? I know you can't see it specifically.
No, I don't really know my way around Jacksonville.
Okay, when you drove, did you drive interstate out west on I-10?
I'm not really sure.
Well, what road did you use to get to the gravesite? Is that road the road that goes north from McClinney?
Yes, sir.
Okay.
I know that.
And do you know if you dug the grave in Florida or in Georgia?
It was in Georgia.
Was it like 20 miles into Georgia, or was it closer to the border?
Close to the border.
When you went to the same hole that you had dug 2 days before?
Yes, sir.
Is there a discussion on Nextels between y'all and Michael Jackson about what was going to happen on the way out there?
Sir?
Are you able to communicate with Michael Jackson in the Mazda by your Nextels?
Yes, sir. We are, but we ain't really say nothing. We weren't talking.
You're not calling each other?
No, sir.
But you did have that beep, beep capability.
Yes, sir, but we weren't talking.
All right, tell the jury what happens when you get out there.
When we get out there, we pull up to the grave site. Michael Jackson went up to the car and popped the trunk and seen that the duct tape was off of them and started screaming, started talking about putting duct tape back on them. So I walked around and put duct tape back on them because I didn't put it on real tight. I just put it on there so...
I'm sorry, Mr. Nixon, keep going.
So I put on the duct tape, put it back over their eyes and stuff and over their arms and their feet because they got all the way out of it.
You didn't put the duct tape on very tight back at the house?
No, sir.
And how long had the Sumners been in the trunk before y'all popped it?
The ride from Jacksonville to Georgia.
So it took a while to get there, right?
Yes, sir.
Now, what were the Sumners doing in the back of the trunk when they had gotten out of their duct tape?
They were hugging.
And you saw that?
Yes, sir.
Again, why did Michael Jackson get so upset about their duct tape being on?
Because he didn't want them to see him.
And he didn't want them to see Michael Jackson?
No, sir.
And again, why was that?
Because he said that when he killed them that he didn't want them to see him because it was a mind thing.
Showing you what's been entered as States 30, Mr. Nixon, is this the road y'all drove down to get to the burial site?
Yes, sir.
Can you show the jury, I know it's just off the map, but where you used to live in relation to this site?
On the bottom right here?
Towards the bottom there?
Yes, sir.
And what is that building picture at the bottom?
That's the fire station.
Showing stage 31. Is this the gravesite?
Yes, sir.
Can you show the jury what gate you're talking about?
Where that first van is going up that road.
Right here?
Yes, sir.
Is this where the gravesite is?
Yes, sir.
Show the jury on this map where you pop the trunk to find the Sumners hugging each other.
Right here where that van is.
Where was the Mazda when you popped the trunk and the Lincoln was right here?
2 vans behind it.
Here?
Yes, sir.
And you got them re-duct taped, what happened next?
After I re-duct taped them, Alan tried to back it up into the hole, but he couldn't, so I jumped in and backed it up into the hole.
Is that the only time you ever drove the Lincoln?
Yes, sir.
Did you ever have control of the Lincoln car keys other than that time you backed it up to the hole?
No, sir.
Who had control of the Lincoln car keys?
Michael Jackson. Alan Wade was driving. He had the keys, but he had the keys after Alan had them.
Where was Tiffany Cole while you were backing up the Lincoln?
Tiffany Cole was on the road right by the RX-8,
Show the jury on the map where that is.
right here.
Tell the jury what happened when you finally get the Lincoln to the gravesite.
Popped the trunk. They popped the trunk. After they popped the trunk, Michael Jackson told me to go stand with Tiffany on the road. He said, go watch Tiffany.
Now, who was in the trunk when you popped it at the gravesite?
The Sumners.
Now, did the trunk face the grave or did the car face the grave?
Yes, sir, face the grave.
Trunk did?
Like right beside it, yes, sir.
So you actually backed in.
Yes, sir.
Who was in the trunk when you popped it?
The Sumners.
Were they still duct taped?
Yes, sir, because I just duct taped them back.
Now, when you popped that trunk and Michael told you to go back to wait with Tiffany, did you know what was going to happen to the Sumners?
Yes, sir.
What was going to happen to the Sumners?
They were about to die.
And you knew that.
Yes, sir.
When you left the gravesite, who was still at the gravesite?
Alan and Michael.
Do you know what happened at the gravesite when you weren't there?
No, sir.
Do you know that the Sumners were killed there?
Yes, sir.
How did the Lincoln get back from the gravesite to the road?
I'm not real sure. I don't know.
Someone drove it back out.
Yes, sir. Somebody drove it out.
And they were able to drive it backwards
Yes, sir.
and frontwards?
Yes, sir.
Who got into what car to leave the gravesite?
Me and Alan got in the Lincoln, and then they got in the RX-8.
And who drove the Lincoln?
Alan,
Where were the shovels?
in the trunk.
Of what?
The Lincoln. I didn't know till I came to jail that they were in the trunk.
They weren't left at the gravesite because you've seen them in the trunk.
No, sir.
So you were in the passenger seat and Alan was driving.
Yes, sir.
Where did y'all drive to?
We drove to Sanderson
And why did you drive there?
to drop the car off.
Who followed you to Sanderson?
Michael Jackson, and Tiffany.
And they're in the Mazda still?
Yes, sir.
And Tiffany was driving?
Yes, sir.
What happened when you got to the Sanderson side?
We got out of the car and we wiped it down and stuff.
Who's we?
Me, Michael Jackson, Alan Wade.
And did you leave the car there?
Yes, sir.
Did you leave the shovels in the trunk?
Yes, sir.
Did you take anything else out of the car?
No, sir.
Where did you and Alan Wade and the defendant go?
We went to the RX-8 where Tiffany and Michael Jackson were.
And where did you sit?
We both sat in the back seat.
You and Alan Wade sat in the back seat?
Yes, sir.
Where did y'all go?
We went to the hotel after that. No, we went straight to the ATM.
Did you go to the ATM late at night?
Yes, sir.
Did y'all go to Walmart late at night?
Yes, sir.
Did you also go back to the hotel room and go through the property y'all had found?
Yes, sir.
Tell the jury what was taken out of the house when you, Michael Jackson, and Alan Wade were there the first time.
Coins and bank statements and stuff like that.
And the ATM card?
Yes, sir.
Now, going back to the gravesite, did you notice Michael Jackson with any pads?
Yes, sir. He had a yellow pad like them right there.
Just like what the jury has?
Yes, sir.
What did Michael Jackson tell you about what was on that pad?
Numbers, ATM numbers.
PIN numbers?
Yes, sir.
Did anyone ever go back to the Sumner home?
Yes, sir. Tiffany and Alan did.
And when was that?
When I was at the hotel with Michael, I was in the bathtub. My knee was messed up. I was soaking my knee. I got out, and he said they went back to the Sumners' house.
And who is he?
Michael Jackson said that.
Is that when the computer was taken
Yes, sir.
and the computer was later pawned?
Not sure.
Now, did you get money for your involvement in this case?
Yes, sir.
How much money did you get approximately?
About $200. That's all you could get at the time.
That was all you could get out of the ATM?
Yes, sir.
How long do you stay with this group?
Like a day later,
And then what happened a day later?
I went home. They dropped me off at my house.
Did you ever go to South Carolina?
No, sir.
Did you know they were going to South Carolina?
Yes, sir.
That was part of the plan, that they were going to go to South Carolina?
Yes, sir. They had rented a car or something. They rented a car they had to get took back.
Did you receive a call from Alan a couple days later?
Yes, sir.
Tell the jury about that.
He said that the car got found in Sanderson.
Why did he call and tell you that?
Why did he call? He called to tell me. He just called and told me.
Did he tell you to be cool, don't worry about it?
Yeah, be cool. Don't worry about it.
During this period of time, after you got dropped off, but before you got arrested, did you go to a party and get wasted?
Yes, sir.
Tell the jury about how you got so inebriated.
I was on pills and I was drinking beer out of a keg.
Where did you get all these pills from?
The Sumner's house, and I had some because I had pills too.
Do you remember everything that happened that night?
No, sir.
Is it possible you may have talked about this case that night and you just don't remember?
It's possible I could have talked about it.
I want to talk to you a little bit about your relationship with Alan Wade. When did you first become friends with Alan Wade?
When I was 13,
And did you remain friends from the time you were 13 till the time you were 18?
yes, sir.
Did y'all play basketball together?
Yes, sir.
Did you consider him one of your best friends?
Yes, sir.
What was your relationship with Frida Wade Gainey, his mother?
She's like my mama. When I got in trouble or I ran away from home, I used to go to his house and stay with him.
Tell the jury about how she treated you.
She treated me like her son.
Did you love her?
Yes, sir.
Did you actually have contact with her after you were arrested?
Yes, sir.
Did y'all discuss your predicament in this case?
No, sir.
Did she provide any counsel or support for you during this time?
Yes, sir.
What was your relationship with Michael Jackson?
My co-defendant.
Did you know him any more than the 2 days you spent with him?
No, sir.
How about Tiffany Cole?
No, sir.
Was she ever your girlfriend?
No, sir.
Did you know her any more than the 2 days you spent with her?
No, sir.
Why do you know Michael Jackson and Tiffany Cole?
Because we did this robbery and stuff.
Did Alan Wade know either Tiffany Cole or Michael Jackson, to your knowledge?
Yes, sir. He knew Michael Jackson.
Did Alan seem to know Michael Jackson fairly well?
Yes, sir.
Now tell the jury about when you were arrested, when you were interviewed by the police.
Yes, sir.
Did you cooperate with the police?
Yes, sir.
Now initially, did you tell the police the truth?
No, sir.
And why not?
Because I didn't want to get in trouble, and I was afraid of getting in trouble.
Did you eventually tell the police the complete truth?
Part of it, after I done found out that my other two co-defendants was saying stuff.
Did you deny or tell the police that you did not know the Sumners were going to die?
Yes, sir.
Why did you lie to the police and tell them you did not know the Sumners were going to die?
Because I was afraid of getting in trouble.
But you did know the Sumners were going to die.
Yes, sir.
Did you take the police to the gravesite?
Yes, sir.
And what were you feeling or thinking when you were at the gravesite?
I felt bad, but at the same time, I thought it would help me. That's why I did it, so both of them. I ain't gonna sit here and lie and say I felt bad. I would be lying. That's what I'm saying, both. It's a mix of both of them.
A mix of both? You felt remorse and you were scared you were going to get in trouble?
Yes, sir.
You also thought it would help you?
Yes, sir.
Now, how were you acting at the scene?
I was on methadone and I was on pills and stuff. I was crying. I was out of my mind.
Have you seen the video of that taking the police to the gravesite?
Yes, sir.
And tell the jury how you were acting in that video.
I was crying the whole time.
And were you putting your head on someone's shoulder?
Yes, sir. Officer Dobson, he's the sheriff in McClenny.
There was a time, Mr. Mixon, were you, Michael Jackson, Alan Wade, and Tiffany Cole were together, and you actually saw Frida Wade, is that correct?
Yes, sir.
Tell the jury about that.
After we dug the hole, we went back to Alan's house. His mama wasn't supposed to come home, but that morning she came home, and when she came home, she was cussing at me, and I don't think she was cussing, but she was yelling at Michael Jackson. She didn't like Michael Jackson.
Did she ever?
That's the first time I've ever seen them talk to each other.
That's the first time you ever seen?
Miss Frida and Michael Jackson talk, but she was screaming at him, telling him to get out of the house and all that.
And did y'all leave the house?
Yes, sir.
Because you weren't even supposed to be there, right?
Sir?
Y'all weren't supposed to be at her house.
Oh, me? She didn't care about me. She was surprised to see me. She was like, Bruce, where you come from?
But she didn't like to see Michael Jackson.
No, sir.
And y'all left.
Yes, sir.
And that's when you started staying in hotels.
Yes, sir.
Can you tell the jury, Mr. Nixon, what you have pled guilty to?
Second-degree murder and armed kidnapping and armed robbery.
And at one time, were you facing the death penalty? Is that correct?
Yes, sir.
And now you are not.
No, sir.
Tell the jury what your sentence range is.
52 to life.
52 years
Yes, sir.
to life?
Yes, sir.
Who will decide your sentence?
Judge Weatherby?
Judge Weatherby, this judge?
Yes, sir.
Have I promised you any sentence?
No, sir.
Has Mr. Plotkin promised you any sentence?
No, sir.
Has anyone in my office promised you?
No, sir.
So you can get a life sentence,
Yes, sir.
and that will be completely up to this judge.
Yes, sir.
You understand that?
Yes, sir.
Now, you do hope to some degree that your testimony helps you, right?
Yes, sir.
Why else are you here testifying? Obviously, you're wanting to help your sentence. But why else are you here telling the jury everything that you know?
Sir, what do you mean by that?
Well, do you feel bad about what happened?
Yes, sir, I feel bad about what happened.
Tell the jury about that.
Well, I felt bad for what happened. You know what I'm saying? Me and Alan got in this situation. We were young and we had bad role models at the time. We was hanging out with somebody we shouldn't have never been hanging out with. We supposed to have been better than this, supposed to have been going to school and staying out of trouble and just having fun, but somebody came into our life and messed up our life and got stirred the wrong direction. We wasn't even supposed to be going through this. We supposed to be on the street right now, having fun, staying out of trouble. But it seems like all the good people got locked up.
Do you understand, Mr. Nixon, that there is a pretty decent chance you could get a life sentence in this case?
Yes, sir, I know it.
And you were going to be okay with that if you get a life sentence?
No, I'm not going to be okay with it, but I'm going to have to face it.
You understand you could get it?
Yes, sir.
That's all the questions I have. I'll defer to cross-examination.
All the good people get locked up. Is that what you just said, sir?
Yes, sir.
All. You consider yourself a good person?
Yes, sir.
May I approach, Your Honor? Sure. Sir, you picked up this shovel, didn't you?
Yes, sir.
You picked up this shovel up, didn't you?
Yes, sir.
You picked this big shovel up, didn't you?
Yes, sir.
You picked this shovel up, didn't you?
Yes, sir.
You did that. Alan Wade didn't do that, did he?
No, I did it.
Tiffany Cole didn't do that, did she?
No, sir.
Michael Jackson didn't do that.
No, sir.
And sir, you were familiar with Georgia, weren't you? You grew up and were taken on a school bus past that road up there, weren't you?
Yes, sir.
You picked that gravesite out, didn't you?
We all did.
You knew it, didn't you?
Yeah, I knew it.
It was right across from where you used to live, the fire station, wasn't it?
Yes, sir.
You went in that house, didn't you, sir?
Yes, sir.
You had duct tape and duct taped their eyes and mouths and arms and legs, didn't you?
Yes, sir.
You didn't put it on real tight, is that what you're saying?
Yes, sir.
But you did it, right?
Yes, sir.
Anybody drug you to do that?
No, sir.
Anyone forced you to do that?
No, sir.
Anyone threatened you to do that?
No, sir.
You picked the Sumners up and put them in the trunk of the Lincoln, didn't you?
Yes, sir.
Anybody drug you to do that?
No, sir.
Anybody forced you to do that?
No, sir.
Anyone threatened you to do that?
No, sir.
You, sir, backed the Lincoln into the gravesite by the hole, didn't you?
Yes, sir.
You had your hands on the steering wheel, right?
Yes, sir.
You're backing, looking around by the bushes, aren't you?
Yes, sir.
Anyone drug you to do that?
No, sir.
Anyone threatened you to do that?
No, sir.
You went out there 2 nights before, right?
Yes, sir.
Did you feel sorry for the Sumners then?
I ain't know them then. No, sir.
You wanted money, didn't you?
Yes, sir.
And you wanted lots of money, didn't you?
Yes, sir.
Because you like money and you like girls and you like partying, don't you?
Yes, sir.
You remember a fellow by the name of Alec Griffiths?
Yes, sir.
He was at a keg party, wasn't he?
Yes, sir.
When you were drinking kegs or handstand or keg stands, right?
Yes, sir.
Did you feel sorry for the Sumners then?
No, sir.
Did you get to Sheriff Dobson and put your head on the shoulder and cry about it then?
No, sir.
When you were digging the graves 2 days before, did you have gloves on?
No, sir.
Was it easy work, heavy work? Were you sweating?
Yes, sir.
What shovel did you use? Which one of those four?
Both the middle ones?
Middle, medium-sized ones?
Yes, sir.
Were you sweating?
Yes, sir.
You're familiar with that area of Georgia, weren't you?
Yes, sir.
But you testified that the RX-8 with Michael and Tiffany was leading the way to the burial site with the Sumners.
Me and Alan was with them. They were driving. She was driving.
Right, but they've never been there before other than 2 nights before, right?
No, sir.
So they knew how to get there?
No, sir.
What time was it when you got there with the Sumners?
When we got there with the Sumners,
Yeah, when you banked the Lincoln up to the grave and helped bury them alive, what time was it?
about, not real sure, about 11 o'clock, 12 o'clock.
About what time?
I'm not sure. I think about 12 o'clock. 12 o'clock.
About midnight?
Yes, sir.
And if I recall your testimony correctly, sir, the trunk was opened at the gate or something like that, and the Sumners had managed to get free because you didn't put the duct tape on that tight?
Yes, sir.
And you got more duct tape and taped their eyes again, taped their mouth again, taped their arms again, and taped their legs again, didn't you, sir?
Yes, sir.
Made it tight, didn't you, sir?
I did it the same way I did it at the house.
And then you, sir, along with Jackson and Cole, buried the Sumners, didn't you?
No, sir.
You didn't lift one shovel and put dirt on there?
No, sir.
What were you doing?
I was up there walking with Tiffany Cole.
So you don't really know who buried the Sumners, do you?
No, sir.
At the gravesite, I think you told Mr. Mizrahi, that's when you finally realized the Sumner were going to die. Is that right?
No, sir.
I thought you just said that to Mr. Mizrahi.
I ain't say that.
You knew they were going to die?
Yes, sir.
At the gravesite, right?
Before that.
Before that?
Yes, sir.
You didn't go for help?
No, sir.
Nobody drove you, threatened you, or coerced you to do this, right?
No, sir.
Didn't go for help before?
No.
You didn't go for help at the gravesite, did you?
No, sir.
You're in a separate car, right?
Yes, sir.
Did you go for help when you got back to Jacksonville or McClenny?
No, sir.
Did you go for help when you were doing keg stands?
No, sir.
You only went for help on March 12th. Sir?
When I got in trouble for it.
March 12th of 07, when you gave a sworn statement in this case with your attorney, Mr. Chipperfield, who's in the courtroom, right?
Repeat that question?
You only went for help March 12th when you gave a statement against Alan Wade. Isn't that true?
Yes, sir.
Because that's going to help you, right?
Help me or hurt me?
But I already helped you, right? You were looking at the death penalty, sir, weren't you?
Yes, sir.
That's off the table, right?
Yes, sir.
Because you got a plea agreement now with this man right here, right?
Yes, sir.
And you didn't get convicted of first-degree murder. He let you plead to second-degree murder, didn't he?
Yes, sir. It don't really matter.
Doesn't really matter, sir?
I can get first-degree murder and still get 52 to life. I don't think the charge, I don't know how that goes.
You just testified to this jury. You pled to second-degree murder for 52 years to life, right?
Yes, sir. I don't see the difference between getting first-degree murder and get 52 to life. Same thing. It's carrying the same amount of time. I don't know about all that.
How old are you, sir?
I'm 20.
Okay, do you see a difference between life, never getting out, and 50 years? Do you see a difference to that, sir? No?
No, sir.
You feel you see a difference between life and death by lethal injection?
Yes, sir.
You don't want that, do you?
No, sir.
March 12th, 2007 is when you decided to get help, right, for yourself.
Yes, sir.
You gave a sworn statement, right?
Yes, sir.
And that's the same day you were allowed to plead to reduce charges and you signed a blue form, right?
Yes, sir.
And you stood in front of Judge Weatherby and you raised your right hand and you swore to tell the truth, right?
Yes, sir.
And you pled, sir, to 2 counts of second-degree murder, right?
Yes, sir.
2 counts of armed kidnapping.
Yes, sir.
2 counts of armed robbery.
Yes, sir.
And you got your deal, didn't you? 52 to life.
Yes, sir.
And that's to your advantage, don't you think?
Yes, sir. I ain't get the death sentence.
And you're hoping after all this is over And after all this testimony is over and you stand in front of Judge Weatherby, you're hoping that this prosecutor will stand up there and recommend a sentence of less than life, aren't you?
Yes, sir.
Doesn't matter who would be sitting in that chair, sir. You would testify against anybody to get a sentence better than death or life, wouldn't you?
Yes, sir.
I want to make sure I understand what you said about the ATMs and the Walmart and all that. According to you, this was after the gravesite thing, right?
Yes, sir.
The pictures, I think, he showed you some pictures from South Carolina, he says. You saw these pictures way before the gravesite thing, didn't you? The limousine and the champagne and all that.
Yes, sir.
That wasn't after this, was it?
No, sir.
Did you ever tell Frida Wade or Frida Gainey that you're going to get $40,000 for this crime?
No, sir.
And I think you said you lied to the police in the beginning. You lied to them a little more until you found out the other co-defendants were telling on you.
Yes, sir.
You didn't like that. That made you mad and angry, didn't it?
Yes, sir.
May I have a moment, Your Honor? I have one other question, Judge. Mr. Mizrahi asked you about these keys to the Lincoln, and I thought you said Michael had control of the keys, right?
Yes, sir. He was the one popping the trunk open.
And Michael pretty much had control of the whole thing, didn't he?
Yes, sir.
That's all I have, Your Honor. Thank you.
Was there a redirect to the trial?
There was, Your Honor. Mr. Nixon, Mr. Eller began his cross-examination by asking if anyone took you kicking and screaming into this crime. He asked you that a bunch of times. You remember those questions?
No, sir.
Anyone take Alan Wade kicking and screaming into this crime?
No, sir.
Anyone threaten him?
No, sir.
He did this as voluntarily as you did this, right?
Yes, sir.
Mr. Eller asked you if you would testify against anyone. Now, are you testifying against your best friend to get a deal? Is that why you're testifying against Alan Wade?
No, sir.
Well, why are you saying that Alan Wade's involved in this crime? Let me ask you this, Bruce. Was he involved in this crime?
Yes, sir.
Was Alan Wade with you the whole time?
This, sir.
And did he do it?
Yes, sir.
Or are you just saying that?
No, sir.
And Mr. Eller made a big deal about this deal or sworn statement that you got in March of 2007, right? That's when you gave me a statement, right?
Yes, sir.
Now, Mr. Nixon, when you were arrested back in July of 2005, did you tell the police that Alan Wade was involved?
No, sir.
In your statement that you gave,
Afterwards?
yeah, tell the jury what you told the police about who was involved in this crime when you were interviewed.
I told them Alan Wade, Tiffany Cole, and Michael Jackson.
Did you say anyone else in the world was involved?
No, sir.
Did you say Ricky Weisner was involved?
No, sir.
Was Ricky with you when you gave the police portions of the statement?
Yes, sir.
Now, Mr. Nixon, when you were arrested, you had no idea about what anyone else had said about your involvement in the case, at least specifically, did you?
What do you mean?
Well, did the detectives in this case tell you what they had found in South Carolina?
No, sir.
Did they tell you where the property was located?
No, sir.
Did they tell you about fingerprint evidence?
No, sir. They ain't say nothing about that.
And all they said is your people up in South Carolina say you were involved.
They played me what they said and stuff.
Now, when you told them about Alan Wade, you were the person that brought Alan Wade into this thing. Is that right? At least you mentioned his name, not in connection with this crime, but you mentioned his name.
Yes, sir. After they played the statements, Tiffany Cole and Michael Jackson's statements and stuff saying, that's when I started talking because I wasn't going to say nothing. And then I seen that, you know what I'm saying, they were telling on me. So I was like, I'm trying to get out of trouble. So I'm going to start, you know what I'm saying, try to flip on them.
They never played you any Alan Wade statements, did they?
No, sir.
They only played you Tiffany Cole and Michael Jackson's.
Yes.
Mr. Nixon, you very easily could have told the detectives that just Tiffany Cole and Michael Jackson were involved in this case, correct?
Yes.
You could have kept your friend out of it.
Yes, sir.
Would that have been the truth?
No, sir.
Michael Jackson was in control of the Lincoln keys before the gravesite and at the gravesite, correct?
Yes, sir.
But then you and Alan Wade left the gravesite in that Lincoln, correct?
Yes, sir.
And Alan Wade was driving that Lincoln.
Yes, sir.
And then there were some court questions, Your Honor. I'll just read these as court questions. This is a court question from a juror. Regarding drugs and/or alcohol, were drugs and/or alcohol involved prior to the robbery or kidnapping?
Yes, sir.
Can you be more specific?
We smoked weed and we drank Lord Calvert.
How much money were you promised and how much was Mr. Wade promised?
Promised a lot of money, about $50,000, like somewhere between that. It's supposed to be split up even.
Do you smoke or did you smoke at the time?
Yes, sir.
What brand?
Are you talking about cigarettes?
Yes.
I didn't smoke cigarettes.
What about Mr. Wade? Did he smoke at the time?
I'm not sure. When he get messed up, he'll smoke, but he smoked Black and Milds and stuff.
You remember what?
That's what I smoked, Black and Milds and weed. That's all. I don't smoke cigarettes.
Well, we're talking about cigarettes.
No, sir.
Did Mr. Wade smoke cigarettes?
I'm not real sure.
Sir?
I'm not real sure.
All right, would you dig the hole? Why would you dig the hole without ever asking why you were doing it?
Because I knew I was getting money for it, so he said, "You want to dig a hole for money?" I was going to dig a hole for money.
Did Mr. Wade help you put the Sumners in the truck?
Yes, sir.
Did Wade, Cole, or Jackson ever explain to you why it was necessary to kill the Sumners after robbing it?
No, sir.
And then a follow-up on Cross.
Mr. Nixon, who promised you money?
Michael Jackson.
The court says any follow-up questions from the jury, their response.
That's all the questions in that. There's a couple other testimonies, Your Honor, that we're going to read in. Somehow my computer shut down. Unless Mr. Johnson has the, you have the reader? We're on page of the redirect examination by Mr. Mizrahi. You have that, Mr. Kelly?
Yes, I do. Thank you.
Mr. Nixon, Mr. Kurtz asked you a series of questions about what you and Alan Wade did. He kept asking questions. Did you and your best friend do this? Did you and your best friend do that? Did you and your best friend access the ATM card hundreds of times to get money?
No, sir.
Who had control of the ATM card?
Michael Jackson.
Who had control of the proceeds of this crime?
Michael Jackson did.
If you were the mastermind, if you were the killer, if you would have done all the things in your mind, would you have let anyone else have that ATM card?
No, sir. I would have tried to get as much money as I could.
Would you have trusted Michael Jackson to get your ATM money for you and then have your hand off whatever it felt like?
No, sir.
Now, you did at one time, you were talking about Alan Wade, may have told you about a couple in San Marco 2 months before. You said that in deposition.
Yes, sir.
And subsequent to that, have you thought that maybe that was a little bit too long of a time?
Yes, sir.
Do you have any idea how long before this crime that he mentioned this couple in San Marco?
No, sir. I'm not really sure. I was just answering the best that I could, but my memory ain't real good.
And when you answered that question 2 months, was that about 2 years after this incident?
Yes, sir.
All you know is he told you sometime before.
Yes, sir.
Mr. Kurtz asked you a series of questions about being a fighter. I want to make sure this jury is clear. Are you telling this jury that you participated in this crime because you're scared of Michael Jackson?
No, sir.
Tell the jury why you did everything in this case that you did.
For money?
Did you listen to what Michael Jackson said because you thought he would beat you up or hurt you?
No, sir.
Why did you listen to what Michael Jackson said?
Because I knew I had to listen to him because he was the one with the plan. I didn't know how I was going to get money from him.
When he was telling you the plan, did he seem confident?
Yes, sir.
Did he seem like he knew what he was talking about?
Yes, sir.
Did he talk a good game?
Yes, sir.
Mr. Kurtz asked you a series of questions about whether you actually saw Michael Jackson in that Reed Avenue house.
Yes, sir.
Tell this jury how sure you are that he was in that home.
I'm positive. I heard him. I know his voice. His voice is different from Alan's. He had an up north accent.
Where did you grow up?
Sir?
Where did you grow up? What city?
In Tampa.
Tampa, Florida?
Yep, Tampa, Florida.
And where did you move from Tampa, Florida? To McClenny?
Yes, sir.
How long have you been living in McClenny?
On and off since I was 13, 14.
Something I think that was unclear. Were you taping the Sumners' eyes so they couldn't identify you later?
No, sir, so they couldn't identify Michael.
Okay, tell the jury why Michael said he wanted their eyes taped even though the plan was to kill them. Tell the jury why he wanted their eyes taped.
He said it was a mind thing.
What does that mean?
Sir?
What does that mean, a mind thing? Tell the jury.
I guess he didn't want them to see him kill them, I guess.
Ricky asked you, you told Ricky about when you were leaving to go do this crime. Did he know about it?
Know about us robbing?
Yeah.
Yes, sir.
Did Ricky want to come with you?
Yes, sir.
What did you do?
I told him no.
Did Ricky Wisner do anything to help y'all commit this crime?
No, sir.
The shovels that were used, you know that a pre-dug grave, the two main shovels were used, correct?
Yes, sir.
And you testified that the snow shovel would not be good at actually breaking ground. Is that fair?
It's like plastic-like.
Do you have any idea what shovels were used to cover the Sumners in dirt?
No, sir.
Mr. Nixon, the snow shovel, would you hold that, please? You've dug holes before, correct?
Yes, sir.
Would you knock that against the ground? Do you think that snow shovel would be effective in lifting loose dirt from a pile of dirt onto something?
Yes, sir.
The fact this is the biggest shovel of all the shovels, correct?
Yes, sir.
If you were lifting a pile of dirt, you could lift the most dirt with this shovel.
Yes, sir.
In fact, this shovel has dirt on it, right?
Yes, sir.
Mr. Kurtz asked you a series of questions about whether or not the plan was to bury them alive. And that wasn't the plan. You never heard about burying alive, did you?
No, sir.
How did Michael Jackson tell you he was going to kill the Sumners again?
Medicine.
Give them some kind of shot?
Give them some kind of shot.
You don't know if that happened or not.
No, sir.
All you know is the Sumners were left in that grave.
Yes, sir.
The video that Mr. Kurtz played you, he played you a few seconds.
Yes, sir.
Right? Before he can tell you, before that, can you tell the jury what you were discussing with the detectives? Was it whether or not you wanted a lawyer or not?
Yes, sir.
Ricky came in when you were posing him, well, what if I tell them this? Are you saying that it's a story? What if I make something up?
No, sir.
Explain that further to the jury of why you're asking him in question form.
The detectives didn't want to answer my questions about going home, but they wanted to answer about everything else. So when Ricky came there, I asked him, what if I tell them this? Are they going to let me go home? I was asking him the questions because they wouldn't answer me.
What you told Ricky in there, first of all, did you know that you were being recorded?
Sir?
Did you have any idea that you were being recorded?
No, sir. I wouldn't have said nothing.
And were you whispering because you didn't want anyone to hear you? Is that fair?
Yes, sir.
When you're inquiring of Ricky, you're inquiring to see whether or not you should tell the police anything.
Yes, sir. I was asking, should I tell them? He was like, yes, tell them where the bodies are. And so I was asking him a question. I wasn't making a lot about it, you know what I'm saying, in the way to where if I tell him this, are they going to let me go home? It wasn't nothing like that. I was asking a question.
If you should actually talk.
Yes, sir. If I should talk to them because I didn't know what to do.
And that phrase when you said what happened, was that the truth?
Sir?
when you said that I was, what if I was at the grave and then walked away with Tiffany? Was that the truth?
Yes, sir.
Now, we've had meetings, correct, Mr. Nixon, before you gave your testimony on multiple, during your deposition and before your plea, and all things like that.
Yes, sir.
Have we ever had discussions about whether you were at the grave scene?
Yes, sir.
Have we ever had discussions about being at the grave scene and whether or not it would help or hurt your case?
Yes, sir. You told me that if I told them that I was there, it would help me more because I'm telling the truth, and they would know I'm telling the truth.
But you've never said you were at the grave scene.
No, sir.
Have you told anyone that you were at the grave scene?
Have I told anybody?
Yeah, have you ever said, I for sure was watching them being buried alive?
No, sir.
That's all the questions I have. Then we have one more. Mr. Johnson will start.
Good morning, Mr. Nixon. How are you, sir? 242.
242, thank you. All right.
Would you tell us your full name?
Bruce Kent Nixon, Jr.?
Mr. Nixon, are you currently incarcerated?
Yes, sir.
Where are you incarcerated?
Washington, at Washington, Chipley, Florida?
Washington Correctional Institute?
Yes, sir.
And you're serving what sentence?
45 years.
Okay, sir. Mr. Nixon, were you a co-defendant with Alan Wade in the murder case involving the victims Reggie and Carol Sumner?
Yes, sir.
And for what I understand, you testified during Mr. Wade's penalty phase. Is that correct?
Yes, sir.
Okay. Prior to your testimony in that penalty phase, do you have an opportunity to speak to Mr. Wade's attorneys? And by them, I mean just identify them. One would be Frank Tassoni, a fairly large fellow with dark hair, tall, and the other being Refik Eller, shorter, also with dark hair.
No, sir, not that I remember.
Specifically, Mr. Nixon, do you recall a conference in the holding cell in the chute at the old courthouse where Mr. Tassoni would have prepared your penalty phase testimony?
No, sir.
Now, prior to this case that you became involved in with Mr. Wade, how long have you known Mr. Wade?
Since I was 12?
Did the two of you grow up together?
Yes, sir.
In what city?
Baker County.
And how would you characterize your friendship with Mr. Wade since he was 12?
My best friend.
Did he make you aware of his relationship with his father?
Yes, sir.
And what was that relationship?
He ain't have one.
I'm sorry?
He didn't have no relationship with him.
You know why that was?
His dad lived too far away. I don't know. I really don't understand too much, but his dad really ain't have nothing. He really had no relationship with his father.
Now, you indicated you were best friends since you were 12. How often would the two of you do things together?
Always.
Would that be every bit day just about? Since you were 12?
Yes, sir.
You ever meet his father?
He never came around.
Okay. Did you know, did Alan Wade Jr. share with you how that made him feel?
I know it hurt him. He always used to be talking about it.
And how did he feel?
I know it killed him.
Killed him? Okay, and from a young age, Mr. Nixon, did you become aware that Alan Wade started using drugs and alcohol?
Yes, sir.
Okay, how young was Mr. Wade when he began using drugs and alcohol?
We were young.
How young is young?
12.
And we were talking about drugs. What kind of drugs did you know Alan Wade to use?
We smoked marijuana and stuff.
Anything else that he graduated to stronger than marijuana?
Got older.
Yes. What was that?
Cocaine.
What else?
Pills. Popping pills and stuff.
What kind of pills?
Methadone, Xanax, Oxycontin, all types of pills, Lortabs, Percocet.
Do you think if he had some stronger parental supervision that he may have been able to keep him in line a little bit better?
Yes, sir.
What about his mother? What about his mother, Frida? Did she work a lot?
Yes, sir.
Did she ultimately come involved with another man?
Yes, sir.
Okay, did you come to meet a man named Michael Jackson?
Yes, sir.
Did Alan Wade ever relate to you an incident that occurred between him and Michael Jackson approximately 2 weeks before these homicides?
Yes, sir.
What did Alan Wade tell you about the incidents between himself and Michael Jackson?
He always told me somebody picked him up or something, threatened to put a gun in his mouth, talking about, I'm going to kill him, about his old lady.
You said that.
I found out it was Michael Jackson that did it.
I'm sorry. You said that Michael Jackson threatened him and put a gun in his mouth?
Yes, sir.
And it was involving Alan Wade's relationship with Michael Jackson's old lady?
Yes, sir.
Would that have been a woman named Carmen Massonet?
Yes, sir.
Did you ever meet her?
Yes, sir.
And was she a person who associated closely with both Michael Jackson and Alan Wade immediately preceding the events that y'all got yourself in trouble with? Did Carmen Massonet hang out with you, and not with you, but with Alan Wade and Michael Jackson immediately preceding these homicides?
I'm not sure. We were hanging out with him.
I'm sorry?
Me and Alan was hanging out with him.
You and Alan were hanging out with Michael Jackson and Carmen?
With the two girls.
Which two girls?
Carmen and Vanessa something.
Were they, and you knew them as having what occupation?
Strippers.
So you and Alan Wade were hanging out with Carmen Massonet and a woman named Vanessa who was a stripper?
Yes, sir.
Okay. Now, was any of this information that we're talking about told by you to Mr. Wade's attorneys?
No, sir.
Okay, now specifically, Mr. Nixon, during the homicides, during this 2-day or 3-day period in which Carol and Reggie Sumner were robbed and killed, was Alan Wade high on drugs?
Yes, sir.
What drugs was he high on?
Cocaine, alcohol.
To what extent?
Messed up.
When you say messed up, what do you mean?
He was beyond reality. He wasn't here.
He wasn't here?
No.
Was this a constant thing? I mean, was there ever a period during the 3-day period surrounding the homicides that he was sober?
No, sir. We were smoking and stuff, getting messed up the whole time.
And were you doing the same thing?
I wasn't doing the coke. I was doing alcohol and drinking, smoking and popping pills.
So you were smoking, popping pills, and drinking. He was smoking. Was he popping pills as well?
Yes, sir.
But he was also then adding cocaine to this mix.
Yes, sir.
Okay, with this information that you imparted to Alan's lawyers?
No, sir.
Okay. Now, one other question about Alan Wade. As kids and during this period from 12 to 18 that you knew Alan Wade, did the two of you engage in a game called the choking game?
Yes, sir.
What is the choking game?
We all used to do it growing up. It's when you breathe in and out and you stand up and you have somebody choke you out and you pass out.
And when you say that you have someone choke you out, is there pressure put on a particular part of the body?
The neck.
And then the pressure, when the pressure is put on the neck, what's the result of that?
Pass out. You black out.
Black out. And did you see Alan Wade engage in this game?
We used to do it all the time.
Did you ever see him pass out?
Yes, sir.
And when he passed out, what was the result?
Fall down.
Fall down on the floor?
Yes, sir. You black out.
Did you see him, you previously testified you saw him under the influence of alcohol and drugs. Did you ever see him lose consciousness when he was under the influence of alcohol and drugs?
Yes, sir.
How many times would you say that happened?
A lot. We used to always do that.
Okay, and just to be sure, this choking game, did this happen? How many times do you think that he was choked till unconsciousness?
I couldn't count. Used to do it all the time.
Okay, did you ever relate that information to Alan Wade's attorney or his guilt phase attorney?
Never talked about it.
Once you ended up accepting a plea of guilty to these charges in return for a term of years, is that right?
Yes, sir.
Okay. Did Frida Gainey, Alan Wade's mother, talk to you about that?
Yes, sir.
And did she recommend the plea to you?
Yes, sir.
And was she a person who helped influence you to take that offer?
Yes, sir.
I have no further questions.
Good morning, Mr. Nixon. How are you?
All right.
Good to see you again. The story that was related to you about the gun in Alan Wade's mouth was told to you by him or by somebody else?
By him.
Okay. Then you said you later figured out that the person he was referring to was Michael Jackson.
Yes, sir.
Okay, so he didn't tell you it was Michael Jackson. You figured it out later.
I didn't know his name at first.
Okay, and that incident took place before the several weeks leading up to this crime, correct?
Yes, sir.
Okay,
A couple of weeks.
so sometime before.
Yeah, sometime before.
Do you know how long before?
I'm not exactly sure of the exact date.
It wasn't at the time you were planning the crime.
What do you mean, planning the crime?
Well, when you got involved with the process of planning this crime.
It was a couple weeks before then.
Before then?
A couple weeks before then.
A couple weeks before, okay. And Mr. Wade was still hanging out with Mr. Jackson at that time.
I don't know.
Well, when the four of you did this crime together, y'all were hanging out together.
We weren't hanging out together. I wasn't hanging out with them.
I know you were just there a couple of days before the incident, but in that brief 36, 48-hour period of time, the four of y'all were together.
We were together, yes.
Okay, you talked about the drug use that you and Alan Wade were doing at this time. Was Tiffany Cole and Michael Jackson also consuming drugs and alcohol to your knowledge?
Michael Jackson was. I don't know about, I think the girl was drinking and smoking.
Okay, and despite this alcohol and drug use, you were able to accomplish many things in this case that required you to have your normal faculties. Is that fair?
What do you mean by that?
Well, for example, you were able to drive, correct?
The girl was driving.
Well, you took the Lincoln Town car. It was you that was driving, right?
Yeah.
And Alan actually had to drive that car as well, right?
Yes, sir.
Because if my recollection is correct, you were at the grave site and you couldn't get the car back to the grave site, and it was Alan that had to come do it for you.
No, you got it mixed up.
I got it mixed up. So Alan's the one that drove all the way out to the grave site.
Uh-huh, yeah.
Okay, so he was able to accomplish the task of driving down Interstate 10 for 30 miles until you got to the grave site, correct?
You saying like because we can't drive it don't mean you messed up?
Well, you may have been high or drunk, but you were still able to accomplish certain tasks like driving, right?
Well, it's easy to drive, make thoughts to try to think about what's going on at the time. It's easy for me to get in the car and make a decision.
Okay, but nevertheless, it was Mr. Wade that drove first to the gas station to get gas and then out to the pre-dug grave, right?
Yeah.
Okay, but then he wasn't able to get the car back to the grave site and you took the car back there.
Yeah. Yes, sir.
You actually left about, what, 24 hours after this incident? You left the three of them, correct, and went back to Baker County?
Yes, sir.
And you took some money with you, correct?
Yes, sir.
And then the three of them, you don't know what happened to them.
No, sir.
Okay, do you know if you suffer any mental disease or defect based on your participation in this choking game?
I'm not sure. I don't know.
Okay, how are you doing in prison? Are you taking classes?
Taking what classes?
I'm asking you, are you taking anything in terms of,
I'm not doing nothing.
you're not trying to get your GED?
For what? Nothing.
Okay, so you're not taking advantage of anything the prison has to offer?
Nothing. I sleep. That's what I do.
I'm sorry to hear that, Mr. Nixon. That's all the questions I have.
Does that conclude the reading of the prior testimony? All right. Thank you, Mr. Kalinowski. Appreciate your time. It seems appropriate to take a short break. I'm going to ask the jury to step back in the jury room. You all will be in recess about 10 minutes. The remainder, please remain in the courtroom. Jury is in recess for 10 minutes. Mr. Johnson,
Yes, sir.
your first witness is going to be,
It'll be Dr. Lawrence Steinberg. It's an expert. It'll be fairly long. I have an opening statement to do because we reserved.
well, yeah, I mean, what you do. And I'm still awaiting your list of mitigators, whenever you have a chance to do that. I know this may seem, something about the barn door and the cows have all gone, but it occurs to me, should we consider invoking the rule of sequestration at this point, which no one ever did before, which is part of my, earlier issue?
The state's done, the state has kept detective and medical examiner out of the courtroom. Obviously, the family's in the courtroom. Defense counsel has me, I have no objection to their family members being in the courtroom. At this point,
And in that instance, I will trust the council to handle the matter appropriately. All right. Then we will also be in recess for 10 minutes.
so that was your first. Who's there? Remember that guy? Got one right here. Name down. What's that? Your name down. The answer was no.
Where the jury is returned, be seated, ladies and gentlemen. Mr. Madron.
Your Honor, the state of Florida is going to call two members of the deceased family for victim impact. The first is Revis Sumner. Mr. Sumner.
I call this, we're going to ask the board to read the instruction prior to the testimony.
Sure, I'd be happy to. Bear with, can somebody give me a current copy of it?
We have an amendment.
I gave him my copy.
I have it. With the two paragraphs that we discussed last week. Okay. Members of the jury, I read this instruction to you early on. It's the matter of the question of the victim impact statement, but please let me tell you, this is actually what I will tell you, the conclusion of this. You have heard evidence about the impact of this murder upon the family or friends or community of the decedents, plural. The evidence is presented to show the victim's uniqueness as an individual or individuals and the resultant loss by their deaths. However, you may not consider these as aggravating factors or aggravating evidence. You may not consider this evidence when you decide whether the aggravating factors are sufficient for the death penalty or when weighing the aggravating factors against the mitigating circumstances or when you make your final decision on the appropriate penalty. Sumner, please come and take a stand. I understand Mr. Sumner has a statement that he's going to read.
As Your Honor, we're just on the record what his name is and what his relationship is to Carol and Reggie Sumner.
My name is Revis Sumner. I'm Reggie's brother.
Carol's brother-in-law?
And I'm Carol's brother-in-law, yes.
You've prepared a written statement.
Yes, I have.
Thank you. Go ahead, Mr. Sumner.
My name is Revis Sumner. I'm the brother of Reggie Sumner. I would like to tell you about my brother and his wife, Carol. Reggie and Carol were the most innocent, kind-hearted, and wonderful members of my family. They were good neighbors, they were kind, and they were trustworthy. They helped those that were in need, and they had the gift of hospitality. Reggie would give you the shirt off his back if you knew you needed it. They were givers, they were contributors to society. We were raised in a large family. Reggie was the life of the family. He was a party of our family reunions. He was always funny. Telling jokes and keeping people happy was his trademark. He would always insist on paying bills at a restaurant, and he had a habit of showing up at your door unannounced with goodies and cheers. He was a wonderful brother. Reggie had it rough growing up in a house of 11 brothers and sisters. He was the 7th child of the Sumner family. He was the baby. Our father was killed in a motorcycle accident when Reggie was just 6 weeks old. At 32, my mother was a widow with 7 children. She remarried and had 4 more children. Mr. Clark, our stepdad, passed away in 1953, and as the older brothers and sisters were moving out, getting married, or joining the military, Reggie stepped up to the plate and became the father-like figure and helped raise the younger siblings. He was such a good leader. He always set a wonderful example for everyone. He was so loved by his siblings. Reggie was retired from CSX Railroad, and although he and Carol were in poor health, they loved each other. They loved staying together. The void in our lives would never be filled. We missed them so much. They were supposed to celebrate anniversaries and birthdays with us instead. All were left were just our memories. Thank you.
Thank you, Mr. Sumner.
All right, thank you, Mr. Sumner. You may stand down.
Your Honor, the next victim impact statement is that of Reverend Jean Clark, the sister of Reggie Sumner.
Reverend Clark, if you-
Hey, how you doing? Okay. My name is Jean Clark, Reverend Jean Clark. I am Reggie's sister and Carol's sister-in-law. This impact statement is a testimony of their lives, James Reginald Sumner and Carol Oxford Sumner. The positive thing about Reggie upon us was that he transformed our life, even as siblings and neighborhood young people. Also, Reggie and Carol impacted many communities, impacted upon their communities. The devastation, negative impact of the loss of Reggie and Carol upon his family, friends, and community. We grew up in Charleston, South Carolina, where we were raised by a wonderful, godly mother. My mother had 11 children, and when people would ask, well, actually, she had 12, but 11 living, who they were, all these children, she would always say they were cheaper by the dozen. My mother had very much humor. Many times when I would see like mother ducks or mother chickens, I would think of my mother. She nurtured all of us with love and raised us in an admonition of the Lord. She had many little ones and loved each and every one of us in a special way. My brother Reggie was number 7 out of 11 children. My mother would always say he was a Sumner baby. I was the Clark baby, and my little brother Oral was the Craven baby. Our mother instilled in us to give to others. During the holidays, my mother would have us go out and collect canned goods for the needy families. This impacted all of our lives as we were in need too and didn't even realize it. Reggie lost his dad when he was only 6 weeks old. That impacted his siblings during that time. His dad was killed on a motorcycle accident. Reggie was the meekest of all the 11 children that he grew up with. He was easygoing and never liked to fight or wanted to fight anyone. He was very gentle, tender, loving, humorous person. He cared very much about his younger siblings, Jan, my sister, me, and my younger brother, Oral. Reggie was like a father figure, and he was also known that way to the neighborhood children, neighborhood teenagers. If I can get my paper here. We've got to get it stuck together. Okay, here we go. He was like the neighborhood children the same way. Everyone loved Reggie, and he was meek, humble spirit. Reggie would load up his car and take us in many places he could on outings everywhere. He took us to the beach where we rode on his shoulders when the waves crashed against us. He took us to the drive-in theater to see good movies like The Ten Commandments. We would sit on the roof of the car and he would, or either the hood of the car, and he would buy us food to eat. He would take us like to this place called the Artificial Mountain, where we would climb up to the top and slide down on cardboard boxes. Reggie took us to Fort Moultrie, where we would explore the tunnels. We would be going through the tunnels sideways sometimes because it was so narrow. We walked on the sandy floor. There were openings at the bottom of some of the walls, and Reggie would disappear. And then suddenly he would reappear and grab our legs. We would scream, and oh, how we loved it, and would laugh. Reggie also took us to the Somerville Light, where back then was a scary place. A light would suddenly appear and disappear. We all thrived on these adventures, and they were so special in our lives. He also treated us by taking us to the fair. He bought our tickets on all kinds of rides and food, delicious food to eat. He did everything for us on our wonderful outings. He would also take us to the old rice mill, and where there was a pond and some would swim in it. Then all of a sudden, he or someone would yell "Gators," and everybody would run. We would run and scream, again, loving every moment of it. He would take us to the Battery in Charleston, and we would have a wonderful time during these excursions. It was a special place, and so was Hampton Park. We would go to these places many times, never, ever getting tired of seeing the same places. Reggie loved to help people. Let me go to these papers. He loved to help people and make their lives better. I was young and can't tell you all that he did for us, but he helped us make us who we are today. He taught me how to ride my first bicycle, and he rode me on a Cushman scooter. Reggie also had a car that he was going to sell and purchase to me, but unfortunately I had an accident. Reggie joined the Navy after graduating from high school in 1962. It was really hard on us siblings to see him go because we loved him so much, so dearly. I can remember when Reggie came home from being stationed in Japan, he seemed even funnier than ever. He was like a comedian. And when he saw the Christmas tree in the house, he said, in Japan, trees grow outside, not inside. He brought joy and peace in our lives and everywhere he went. As time went by, Reggie moved to Jacksonville and later bought me my first train ticket, and we rode together to Jacksonville. What a treat that was. I stayed a short time there and went to numerous places in Jacksonville. He bought my first flight on an airplane, on a plane back to Charleston. My siblings, my life, and the lives of others were enhanced through his life of my brother Reggie. Reggie and Carol dated in high school, and many years later, they connected and got married. They lived in Charleston, and by this time, we lived in Jacksonville. Carol was an easygoing person and a good cook. She kept Reggie well fed and enjoyed the good food and the good cook. She was the first time I visited them when they lived in Ladson, South Carolina. I spent a couple nights with them on that trip. There again, Reggie became the neighborhood big brother, dad, and friend. Reggie and Carol were only married a few years before they were taken from us. Reggie was faithful in supporting his church and also Save a Child Foundation. He reached out to people around the world in some way or another. His heart for mission, he had a heart for missions and went on 2 mission trips to Russia. He also went to other places. After becoming active in missions myself, he sponsored me in many missions around the world. Let's see if we stick it together. He and I wanted to take a trip together, but it never was fulfilled due to his health. In 2006, Reggie and Carol were taken from us. I had the opportunity to stay in their house and upkeep the place. During this time, many neighbors came up to me and shared their heart-touching testimonies, describing the kindness and generosity of Reggie and Carol. One of the ladies that lived across the street shared how Reggie would bring encouragement to her during difficult times through his words. Others received money for food and whatever else they needed. If a person had a need, the need was no more, as Reggie would take care of it without any hesitation or obligation. The death of my brother and my sister-in-law, Carol, has been very devastating on all of our families, even through these many years have passed. There have been many times that we've consumed with grief and felt like we couldn't handle our loss. I must say the loss of my brother and sister-in-law took a very heavy toll on all of us. We have never been the same since our loved ones were taken from us, and sorrow continues through the years. Sleepless nights with horrible visions and dreams tormented all of us and still affect all of us. We will never be the same. As a minister, I could hardly maintain, but I felt like I needed to be the strong one for everyone else. Many of us suffered loss in different ways through the sadness or horror that our loved ones gone through. Many days, months, years, and grief and torment has plagued our lives. Looking forward to that grand reunion when Reggie and Carol to see in heaven as we hold fast to God. Excuse me. I know my brother and my sister-in-law are gone and will never return. Where are they now? Can I see them? Can I call them on the phone? No, I cannot. Can I send them a birthday card to wish them happy birthday? Yes, I can. Only to have the card returned stamped. No such persons. Address is unknown. Return to sender. James Reginald Carol Oxford Sumner, or both have been missed by more than just our families through the years. Their love for people, their humility, their generosity will be continued through the lives of those he touched now, but now is void in the communities and lives of others. The giving, quiet, peaceful, moral, kind, upright couple are not here to help those who are down and out anymore. Our family as well as the community has lost a valuable couple. To Reggie and Carol, I'd like to say thank you for all you've done, both done for helping mankind. To my brother Reggie, I would like to say thank you for all you did for me in my childhood and adolescent years. Thank you for loving me unconditionally. I still miss you and love you dearly, even though many years have gone by. You will always be the part of my heart. I still hold fast to the memories of your nurturing love in my heart and my memories. I hold fast until then, till we reunite in heaven. I want to thank you all for allowing me to share my heart with you. God bless you all.
Thank you, Reverend. Mr. Mizrahi.
The state reserves the right to call rebuttal witnesses as necessary. We have no further evidence at this time.
Mr. Johnson, I'm assuming that you would prefer to give your opening statement after a lunch break, or would you?
I think we prefer to do it now.
Prefer to proceed,
Ms.
and
Morris.
Ms. Moore, is that?
Yes, Your Honor.
Prefer to proceed now?
Yes, Your Honor.
All right, fine.
I will need a moment for you to-
Certainly.
Thank you. May I please report?
Yes, ma'am.
Counsel. When Alan Wade was 12, he stopped going to school. Not because he wasn't enrolled, but because there was no one there to take him. His father, not involved in his life, and his mother had over an hour commute to work each morning and just wasn't always there. Rita, Alan's mother, had to make the difficult decision as to whether she was going to make it to work on time to be able to put food on the table for her children, or whether she was going to see to it that Alan actually made it to school each day. Alan's well-being and his education had to give. Alan repeated the 6th grade twice. He repeated the 7th grade. And when he was 13 years old, his mother, Frida, was diagnosed with breast cancer. At this point, Frida is working a full-time job. She's trying to care for Alan. She's trying to care for Alan's brother, Andrew, who is autistic. And now she's fighting for her life.
Soon after, Alan begins 8th grade at Baker County Middle School, where he meets Assistant Principal Brian Dobson. Mr. Dobson sees Alan struggling and takes a special interest in him. Alan talks to him about how difficult it is for him not having his dad around. Alan confides in him how scared he is to lose his mom to cancer and that he may be left alone. Mr. Dobson listens to him, but begins to become concerned when Alan says, "I don't think that my mom loves me." Mr. Dobson tries to reassure Alan and tell him, "Your mother, she does love you, but she is going through an awful lot right now." Mr. Dobson tries to reassure Alan because there is nothing more important in this world to a child than the love of their mother. But after the second time, and then the third time, that Alan mentions to him that he doesn't think that his mother loves him, Mr. Dobson decides that he's going to try to help. He's going to try to clear this up. So the very next time that Alan mentions to him, "I don't think my mom loves me," he invites Alan into his office. He sits Alan down and he picks up his phone and he dials Frida's number. He puts her on speakerphone so everyone can hear. Mr. Dobson explains to Alan's mom his concerns that he doesn't love her, and he says, "I think that he just needs to hear it from you. Can you let Alan know that you love him so we can clear this all up?" "I can't say that. I can't say that." Those are the words that 13-year-old Alan Wade heard coming from the other end of the line from the most important person in his life and the only parent that he had left. She couldn't tell him that she loved him. Now, members of the jury, this is one small story. This is one tiny fragment in the story that is Alan Wade's life. And over the next few days here in this courtroom, we're going to tell you the whole story. Because you are sentencing the man that sits in this courtroom here today, the whole man. I submit to you that not all of Alan's story will mean something or matter to each and every one of you. And that's okay. But I suspect that if you didn't learn of Alan's whole story, and you voted for death, you voted for Alan to die, and then later on, when we're gone out of this courtroom, if you heard parts of that story that you didn't hear today, maybe about his childhood trauma, maybe about his sexual abuse or his drug addiction, I suspect that you would say to yourself, "I wish that someone would have told me that." Now, I want to be clear. Mitigation is never offered as a justification, an excuse, or a defense to the crime of murder. There is no such thing as an excuse or a justification to murder. Mitigation is a reason to choose life or a reason not to choose death. Mitigation does not have to be unanimously proven, and it can be unique to each and every one of you, and that can include your own personal sense of mercy. Now, the facts of this crime are horrific. That is absolutely undeniable. And the testimony that we have heard in this courtroom over the past few days have been difficult for everyone to hear because we're all human. But I can assure you that no one, and I mean no one, in this courtroom will ever suggest to you that what happened to Reggie and Carol Sumner was anything less than a senseless tragedy that should not have happened. Nothing that anyone can say, unfortunately, can bring them back. And nothing that we, the defense, do or say during this trial is ever intended to disrespect their memories or their family in any way. Nothing can undo the past and the pain that this crime has put their family through, and we acknowledge that. No matter what your verdict is after we're done here, everyone will understand the respect that you hold for Reggie and Carol Sumner and the deep empathy that you have for their family. Now, we, as a society and as our laws dictate, do not execute people based solely on the facts of the crime. If we did, then we wouldn't be here today. After Alan Wade was found guilty and convicted, he would have been immediately executed. Instead, the court's going to instruct you that you're going to hear both aggravation, the facts of the crime, and the mitigation, the reasons for life. Put more simply, the law requires you to consider not only Alan Wade's actions, what he did, but who 18-year-old Alan Wade was at the time of this crime. And members of the jury, you promised in jury selection that you would consider not only the circumstances surrounding the crime, but the circumstances surrounding what could have possibly happened in 18-year-old Alan Wade's life that could have led him to do this. So let's talk more about Alan's childhood and what you're going to hear over the next few days from us. Alan Wade is born May 22nd, 1987. At the age of 5, the family home that he was born into and spent the first 5 years in, it's foreclosed on, and the family is forced out of their suburban home at the end of a cul-de-sac into an apartment. Between the ages of 6 and 8 years old, Alan was molested or sexually assaulted by a babysitter, a family friend, and a member of their church. At the age of 8, Alan's mother abruptly leaves his father and moves the boys from the apartment in Daytona to a trailer in McClenny, Florida. Frida is now a single mother. She's working full-time, and she's trying to raise 2 boys, one of which is autistic. At the age of 12, Alan's father walks out of his life. That same year, Alan starts drinking alcohol and using marijuana. Alan struggles in school. There's no one there to take him, or encourage him for that matter. He repeats 6th grade twice and 7th grade once. At the age of 13, Alan's mother, Frida, is diagnosed with breast cancer. And Alan tells family members, who you'll hear from, that he's scared that she's going to die and that he will be left an orphan. Around this time, Alan begins using cocaine. Alan Wade's mother sent him to stay with his half-sister, Trish Page, in Connecticut during the summers when Alan was 11 and 12 and 13 years old because she, his mother, could not care for him. He does well during those summers with Trish because he has structure and he has stability. The day after Alan's 14th birthday, his mother has a mastectomy and then subsequently begins chemo and radiation treatment. Due to her cancer medications, she begins to have cognitive difficulties. She has trouble doing routine tasks like managing her bills. That same year, Alan attempts to commit suicide and is Baker acted. At the age of 15, Frida kicks Alan out of the house and he goes to live with a family friend named Teresa Roden, whose children he knows from school. He does well while he's at the Roden's home because he has structure and stability. Teresa asked Frida for financial support for Alan to raise her child, and Frida refuses. A few days later, Frida picks Alan up from Teresa Roden's home and moves them to an apartment in Jacksonville. At the age of 16, Alan's mother's cancer progresses, and so do Alan's struggles. Alan's committed to Gateway Community Service for alcohol and drug dependence. At the age of 17, Alan Wade's mother would not allow Alan Wade to move into a new apartment that she was renting, leaving Alan homeless. This same year, he meets Michael Jackson. Michael Jackson was 5 years older than Alan. He had already been to prison multiple times. And as Mr. Mizrahi said in his opening remarks, Michael Jackson was the brains of the operation in this crime. That is who Alan Wade meets at 17 years old. And while he's not living with Frida, she's still concerned. She reaches out to an Army National Guard recruiter and begs him to save Alan. This recruiter does what he can. He gathers paperwork. He sets up a physical for Alan. But unfortunately, Alan fails a drug test and is deemed ineligible for the armed forces. 47 days. 47 days after Alan Wade's 18th birthday, this crime occurs. So why does all this matter? Well, it matters because every single one of these events that I just mentioned to you contributed to the person that Alan Wade was at the time that this crime occurred. Dr. Eunice Castillo is a clinical psychologist, and she's going to walk you through everything that I just mentioned and more regarding Alan's childhood trauma. She's going to talk to you about not only the physical, but the mental impacts of those adverse childhood experiences. Dr. Castillo will talk to you about the effects of sexual abuse. She will talk to you about the effects of parental abandonment and parental neglect. You will learn that in certain cases, parental or abandonment can be more damaging than actual physical abuse, because while the body may heal injuries within a reasonable amount of time, emotional wounds can last forever. The nation's foremost expert on juvenile brain development, Dr. Lawrence Steinberg, will tell you that the juvenile brain does not develop until closer to the age of 25. He's going to explain that as juveniles their forebrain is still developing when they're young, that they can be vulnerable to negative influences, and that their identities are not fully fixed. He's going to tell you that since their forebrain is still developing, which controls their impulsive decision-making and their judgment, that all of those things have an impact on decision-making at that age. However, Dr. Steinberg is also going to tell you that because the brain is still developing, that juveniles have a greater capacity for change and a greater capacity for reform as they get older and they continue to mature and grow. Dr. Scully Danziger is a forensic toxicologist. A forensic toxicologist is someone who studies the interactions between the human body and foreign substances, such as poison or drugs. She will talk to you about why some individuals use drugs to cope with pain and suffering. She's going to talk to you about how early drug use in adolescence can interfere with essential hormones needed for brain growth and development. Dr. Joette James is a clinical psychologist and a neuropsychologist. And she's going to tell you why all of those things that I just mentioned, early childhood trauma and adverse childhood experiences, drug use, juvenile brain development, she's going to talk to you about how all those things directly applied to Alan Wade in the weeks and months leading up to this crime. She's also going to talk to you about how the Alan Wade that sits in this courtroom here today, not the same Alan Wade that he was when he was 18 years old. Ron McAndrew is a former warden in the Florida Department of Corrections and an expert in the penal system. He's going to talk to you about Alan's time in custody, Alan's good behavior, and how Alan can meaningfully contribute inside the prison system. Now, you will be instructed that mitigation, it can come from anywhere. It can be from something that you hear from us during our defense presentation, during the mitigation. It can be something that you heard in the state's case, Mr. Mizrahi said or presented. It can come from something that you noticed. It can come from a simple reluctance to take human life. Members of the jury, you can give life for any reason, no reason, or mercy alone. You will have to make an individual moral assessment about whether you will take Alan Wade's life. The state of Florida never, ever requires a vote for death. Not in this case, not in any other case, not in the worst case that you can imagine. The state of Florida is always satisfied with a life verdict. And you're going to be instructed that for a death verdict to be returned, all 12 of you must determine that death is the appropriate penalty. If one of you thinks that life should be the verdict, then life is the verdict. 11 votes to 1 in favor of death is still a life verdict. And even if you don't particularly agree with the law, it is part of the laws that we all share, and you must respect them. And you must respect each other and each other's decisions. Because this is such a deeply personal moral decision, it requires 12 individual moral assessments about whether Alan Wade lives or dies. Regardless of what you think of Alan, it's your duty and your right and your responsibility to make sure that all 12 of your moral individual assessments are reflected on that verdict form. And while there's only one foreperson that's actually signing the form, that foreperson is simply saying that all 12 of your individual moral assessments are reflected on it. If you've made the decision that verdict should be life, you can let the foreperson know, write down my verdict. I'm done. I'm ready to go. The definition of deliberate means to carefully consider, not to debate. And you're going to be encouraged by the court to discuss the verdict amongst yourself at the end when it's time. But you also don't have to. Sometimes when it comes to these deeply personal decisions, these individual moral assessments, like whether you're going to have children, whether you're going to practice a religion, what religion, how are you going to raise those children? Those are just things, members of the jury, that you know in your gut, and they don't have to be explained. And no one is ever going to ask you to explain your verdict or justify your vote. Now, in the first part of this sentencing, we heard from the state and their aggravation, the facts of the crime. And now, in this second part of this hearing, you're listening to us. You're hearing from the defense regarding our mitigation, the character and the upbringing of Alan Wade. But that third part, the final part, your individual assessment, members of the jury, that's about you. What do you do? How do you feel in your heart, in your soul, in your mind? At 17 years old, what Alan Wade needed was a parent. And what he got was a master manipulator and a career criminal, Michael Jackson. That's what he got. And make no mistake about it, members of the jury, he will pay for it with the rest of his life. He will spend the rest of his days in a concrete cage, and he will be carried out of the Department of Corrections in a concrete box. He will leave in a casket. The only question that remains now is whether he dies of natural causes or whether it's of lethal injection. At the end of this trial, you're going to vote on whether a man, a human being, Alan Lyndell Wade, whether he lives or whether he dies. And while some crimes do deserve the death penalty, some defendants do not. This is one decision that you will live with for the rest of your lives, and I'm going to suggest to you that you will never, ever regret choosing life. Thank you.
Thank you, Ms. Morris. Is now appropriate, Ms. Morris, Mr. Johnson?
Yes, Your Honor, I anticipate Dr. Steinberg is going to be sent out.
All right, so I would assume she would be. All right, ladies and gentlemen, we're at the point where it's appropriate to take a lunch break. Please remember my admonitions to you about not discussing the case amongst yourselves or with anyone else, not amongst yourselves until it's time to do so. Anyone else, never. Please be discreet about what you're doing at lunch. Please keep away from other people. You may leave your notes back in the back if you wish, or on your chair. It's just entirely up to you. In any event, I'm going to ask that you return at 20 minutes after 1 by the courtroom clock, which is right at an hour from now. All right, the jury is in recess. If staff and the participants will remain for a moment, please. All right, the jury has left the courtroom. I wanted to put on the record, go ahead, ladies and gentlemen. Note simply for record purposes that while after the jury had returned and we had begun, I received notification through the e-filing system that Mr. excuse me, that the defense had filed what I believe is the first written motion for Mr. Richardson regarding my disqualification. I have reviewed it. I'm not sure of the impact because I believe these are matters that we discussed on Thursday. That it was filed at 10 o'clock this morning according to the e-filing system, and I saw it about 10:15 or 10:30. In any event, I wanted to put that on the record. The motion is denied, but it is on the record. Right?
Your Honor, one thing I would say is that's what I was trying to report. No reason because the rule requires preservation, requires me to reduce it. You have full motivation.
Yeah, that's what I'm just not sure about the timing or anything. I will trust the counsel to make the appropriate arguments about that. It got into the system at 10 o'clock. I saw it 10:20, maybe, something like that. Okay. Like, I'm sorry. Oh, okay, that's fine, sure. No, that's fine. There's no reason to discuss that at this point because if you in fact establish these mitigators, it's going to be clear from the record in any event, so. That's fine. As I told you last week, I only need some guide because I know that in 3 days of testimony, I'm going to lose my place. frankly, so. That does then bring to mind the question I still would like to know about verdict forms. Maybe today's not the day, but I do need to discuss that at some point with counsel. Mr. Mizrahi, anything further from the state?
No, Your Honor.
Or Mr. Johnson? All right, we will be in recess until 1:20 by the courtroom.
Oh, no, I meant something else. Nothing that we.
Oh.
Okay. Because I was like, shit, it didn't.
Silly me.
But if he didn't, I was just gonna suggest a stipulation.
I have no idea how to do.
may be seated.
All right, we are in the courtroom. Mr. Wade is present. Are we ready to proceed, Ms. Morris? Mr. Mizrahi. All right. If the jury is ready, have them join us, please. All right, our jury has returned. Be seated, ladies and gentlemen. Ms. Morris?
This time the defense would call Dr. Lawrence Steinberg to the stand.
Dr. Steinberg, please. If you come to the clerk and take the oath. Just come up here. Let's Doctor. No. Here, come. Sorry. Right in front. There you go. All right, Dr. Steinberg, please join me on the stand. Ms. Morris, proceed.
Thank you, Your Honor. Good afternoon. Could you please tell the jury who you are?
My name is Lawrence Steinberg. I'm a professor of psychology and neuroscience at Temple University in Philadelphia.
Where do you currently work, Dr. Steinberg?
At Temple University
And how long have you been there?
since 1988.
And prior to 1988, where do you work?
Immediately before that, I was on the faculty at the University of Wisconsin in Madison, and before that, I was on the faculty at the University of California, Irvine.
And what is your educational background?
I have a bachelor's degree in psychology from Vassar College and a PhD in developmental psychology from Cornell University.
Can you tell us what your primary field of study is?
Yes, I'm a developmental psychologist. That's the field that is devoted to the study of how we grow and change over time. And within developmental psychology, my specialization is adolescence.
And have you ever had any publication credits in this field?
I have.
Can you tell us about that?
Well, I've spent my entire career doing research as well as teaching and writing, and I've published to date about 500 peer-reviewed or 500 scientific papers and 17 books.
And what was the area of research that you were published in?
Well, it has varied over the course of my career. Most recently, it's been on how adolescents make decisions, and especially risky decisions. I've also done a lot of work in recent years on juvenile crime.
Are there any major honors that you've received?
I've received Lifetime Achievement Awards from the major professional societies in my field, like the American Psychological Association and the Association for Psychological Science. And I'm a fellow of both of those organizations and of the American Academy of Arts and Sciences.
And have you ever been qualified as an expert before?
Many times.
What about in the state of Florida?
Many times.
Have you ever been involved in filing amicus briefs with the United States Supreme Court?
I have. So an amicus brief is a brief that's submitted to the Supreme Court that encourages them to make a specific decision in a case that they're about to consider. In the case on the juvenile death penalty, which is called Roper, the American Psychological Association wrote an amicus brief encouraging the court to abolish the juvenile death penalty. And in order to do that brief, they put together a team of scientists, which they asked me to lead, to draft the part of the brief that went over the science of adolescent psychological and brain development. And there were two subsequent cases that were similar to that. They both were on life without parole, not the death penalty. And I did the same thing on those briefs. That is, I led the team of scientists that wrote the scientific part of the brief rather than the legal part of the brief.
What would you say is your specific area of expertise?
Well, it's adolescence, which is the period that goes from about 10 to about 20. And I'm interested in all aspects of adolescent development. I've studied family relationships and school achievement and peers, employment, but most recently my work has been on the study of how adolescents make decisions and what influences their judgment, especially in risky situations.
Your Honor, at this time I would move to qualify Dr. Steinberg as an expert in adolescent brain development.
Any questions, Mr. Mizrahi? All right, proceed, Ms. Morris.
Thank you. Dr. Steinberg, were you provided prior trial testimonies to review in preparation of your testimony here today?
Yes, I was.
Can you tell us how adolescence is defined?
Yeah, it's defined somewhat different ways by different people, but among scientists who study it, people like me, we usually think of it as the period from about age 10 to age 20.
What would you say are the most important behavioral characteristics of adolescents versus adults?
I think there are 5 main ones that are relevant to cases like the one today. The first is that adolescents are more impulsive than adults. The second is that adolescents are more focused on the immediate and don't think a lot about the future, so they often don't consider the future consequences of their actions. I should say, by the way, that anybody on the jury who's worked with teenagers or is the parent of a teenager probably knows a lot of this. The third is that adolescents tend to be focused on rewards much more than costs. And so when they're making a decision and trying to weigh the rewards and costs, compared to adults, they'll put more weight on the rewards and less on the costs. The fourth is that adolescents compared to adults are more susceptible to peer influence, to the influence of others. And the last one is that adolescents' personalities are still developing. They haven't quite hardened yet, whereas adults tend to be more the people that they're going to be for the rest of their lives. So I think adolescents are therefore more likely to change, or be able to change at least.
Is there research that associates these behavioral differences with the differences between adolescent and adult brains?
Oh, sure, yes.
Can you tell us a little bit about that?
Yes. Well, we know that there is significant development in different parts of the brain. The brain is divided up into different regions or structures, and there are important changes in the brain during the course of adolescence that make the adolescent brain different from the adult brain. And so if you go back to what I said about impulsivity before, the part of the brain that is important for impulse control is not as well developed in adolescents as it is in adults. And so scientists are able to connect differences between adolescents and adults' behavior with differences between adolescents and adults' brains.
In what areas or or systems of the brain are significant during adolescence?
I think there are three. The first is the prefrontal cortex. That's the part of your brain right behind your forehead. That is a part of the brain that's responsible for advanced thinking abilities and for self-control. The second is a system that's deep inside your brain. It's called the limbic system, and that's the part of the brain that we use when we experience emotion or when we're trying to understand the social world around us. It's also the part of the brain that responds to reward and punishment. And then there is, I guess I would call it a system, there's the connections between those two regions, between the prefrontal cortex and the limbic system. And that's changing during adolescence as well.
And how do the limbic system and the prefrontal cortex, how do they interact?
So if you think of the limbic system as a part of the brain that kind of gets aroused, it gets aroused by emotional experiences or social experiences or by the prospect of a reward or by the fear of a punishment. So it's this easily aroused center in the brain. And the prefrontal cortex, as I said before, is the part of the brain that's very important for self-control. So when our limbic system gets aroused, it makes us want to do something. It creates urges or impulses. The prefrontal cortex is the part of our brain that stops us from acting on those urges and impulses. And so when I teach students about this, one metaphor that I use is to say that the limbic system is like the accelerator and the prefrontal cortex is like the brake. And the problem with adolescence, what makes it such a risky period, is that it's a time when the accelerator is pressed all the way down to the floor, but there's not a good braking system in place yet. Because the limbic system gets very, very aroused during adolescence because of the impact of puberty on the brain. But the prefrontal cortex takes a long time to become mature. So you have this period of time during kind of middle and late adolescence where the brain is very easily aroused, but it doesn't quite have the capacity to control those impulses and urges.
I want to ask you about the difference between what's called hot cognition versus cold cognition. Could you explain that to us?
Sure. Well, I think you've all probably had the experience of having to make a decision about something when you were emotionally aroused, upset, angry, maybe even exuberant. And the kind of thinking and decision-making you do when you're emotionally aroused is affected by the fact that those emotions are running very hot, which is why we call it hot cognition. So hot cognition refers to the thinking that we do when we're in emotionally arousing contexts. We contrast that with cold cognition, which is the thinking that we do when we're not. So if you are, let's say, a student and you're taking a test and you're by yourself and you're just filling in a piece of paper and writing down answers on it, that would be an example of cold cognition. So I think that's a description, yeah.
When I started my questioning, I asked you about how adolescence is defined, and you gave me the age range of 11 through 20. I'm curious as to whether adolescents are subdivided into groups within those ages, and does those ages correspond with how they develop?
Yeah, I think I said 10 to 20, not 11 to 20. But because it is a wide range, and we know that, you know, a 12-year-old is very different from an 18-year-old. So we divide adolescence into three subgroups for purposes of research and how we think about it. Early adolescence, which goes from 10 to 13, middle adolescence from 14 to 17, and late adolescence from 18 to 20. And there are, you know, certain behavioral and brain features of people in each of those three sub-stages that make them different from each other.
And what are those different characteristics of those different phases of development in terms of hot and cold cognition?
Okay, so let's start with the youngest group, so the ones from 10 to 13. they're not as good as adults in either cold circumstances or hot circumstances. I mean, if they're tested, they don't perform as well as adults. In that middle group, from 14 to 17, they're pretty much just as good as adults in cold cognitive tasks, but they're not in emotionally arousing or hot tasks. And that group of people, their decision-making is more easily derailed when they're in an emotional situation. The late adolescents are better than the middle adolescents in hot cognition, but they're still not quite as good as fully mature adults. And so when people ask, do adolescents think as well as adults, it kind of depends on which age of adolescent you're talking about and what kind of thinking you're talking about.
Can you tell us when the brain completely finishes maturing or when it develops?
Well, that sounds like a simple question, but it has a complicated answer because the different regions of the brain, like the ones we've been talking about today, develop along different timetables and at different rates. But if I take your question to mean at what age after which there isn't a lot of significant development in any part of the brain, it's somewhere in the mid-20s. I think scientists might disagree about whether it's 23 or 25, but that's kind of the ballpark for where we think the brain has matured.
And how did you develop that opinion, or is that fact?
I'm familiar with the scientific literature on adolescent brain and psychological development. One of the books that I've written is a textbook on adolescence that's used on college campuses. Textbooks get revised in order to stay up to date. So as an author of one of those books, I have to stay up to date. So because it gets revised every 3 years. So I need to read the journals and stay on top of the field. And I've read a lot of articles on adolescent brain development and on when different parts of the brain mature.
Can you walk us through some of the history, research, maybe some of the developments in science that as it relates to middle and late adolescence?
Sure. Well, it's only really been since about the year 2000 that there was a field of adolescent brain development. And that's because that's the time when scientists started using brain imaging to look at the brain in living people while they were engaged in some activity. And that imaging is probably one that most of you are familiar with. Maybe you've even had an MRI exam on some part of your body. And so before 2000, we had to rely on the naked eye, really, to look at the brain to see how it differed from adolescence and adulthood. And one of the things that is sometimes a little difficult to figure out is that if you just held two brains up, you would see that they didn't look very different from each other between an adolescent and an adult, because our brain reaches its adult size by the time we're 10 years old. And so before there was imaging and we were able to look inside the living brain, it was very difficult to describe or identify the ways in which the brains of adolescents and adults differed. But starting in 2000, scientists began using a technique called functional MRI, or fMRI as it's called. And in fMRI, you have somebody in the magnet, in the capsule, you're lying down there on your back, and there's a computer screen that you can stare up and look at. And on that screen, scientists can expose the person to different stimuli, pictures of faces or words, or we use risk-taking tasks in our lab. And so you can get people to do these things or respond to those stimuli while they're doing something. And so we can look at somebody's brain activity, not just its anatomy. We can look at its activity and we can compare, how is it different if you're reading something than if you're being read something? And we can see what brain regions are active in those different activities. And so fMRI allowed scientists to see how brain activity changed over the course of adolescence. In the first wave of studies that started in about 2000, people were not studying individuals beyond the age of 18. They really wanted to, because the question that was being asked was, how do adolescents differ from children? But then as we kind of went through that decade and got closer to 2010, people started asking, well, how are adolescents different from adults? And in order to do that, people started extending the age range in these studies to go beyond 18 and to look at people who were in late adolescence, 18, 19, and 20, and beyond. And it was comparing those groups, the ones who were late adolescents and the ones who were beyond that, that led to the conclusion that the brain was still changing and developing during those late adolescent years.
Is there a significant developmental difference between an 18-year-old adolescent brain and a mature 25-year-old brain?
Oh, sure. They're very different both in terms of their anatomy and in terms of their activity.
And how does adolescence respond in a hot cognition situation?
Well, they have, difficulty. I mean, as I said before, when we adults can be in an emotionally arousing situation, and we have the capability of tamping down our emotions so that we can think clearly. Adolescents aren't as good at that. And so when adolescents are in hot situations, it undermines their decision-making and their judgment in ways that it doesn't do for adults.
And can you tell us how the brain deals with risk analysis or risk-taking behavior?
Sure. So if we go back to the beginning of your questions and you asked me what are the 5 most important behavioral characteristics, thinking about that helps us understand risk-taking behavior. So I said that adolescents are more impulsive than adults, which means that they act quickly in a situation even though there might be some risk involved. The second point that I made was that they're oriented toward the future and toward the present and not toward the future. And therefore, in considering whether I should take this risk or not, they're going to be thinking about how they're going to be affected immediately by it and not how they're going to be affected in the future by it. The third point that I made was that they're more focused on rewards than adults are and less on costs. And so whenever we make a decision, even though it's usually unconscious, we're always sort of weighing the risks and the costs of making a decision. And when adolescents do that calculation, they put more weight on the risks and less on the costs than adults do. And those things together, the impulsivity, the focus on the present, the reward sensitivity, leads adolescents to engage in a set of behaviors that psychologists call sensation seeking, which is going after exciting or new experiences that we think are going to be rewarding, even if there's some risk involved. And then the fourth point that I mentioned about the influence of peers plays a role in risk-taking too, because there's a lot of research, a lot of it done in my lab, showing that when adolescents are with their friends, they take more risks than when they're alone. And we've studied that in many experiments and have shown how being with friends or being with peers changes brain activity in the brain of adolescents and not in the brains of adults. And so as the consequences of all this, if you look at virtually any type of risky behavior, not just crime, it tends to peak in the late adolescent years, around 18, 19, 20, or so forth. And that's true for reckless driving and unprotected sex and self-inflicted injury and accidental drownings and many, many different risky behaviors. And we think it's because of this combination of being impulsive and short-sighted and focused on rewards, which leads kids to do, a lot of dumb things.
Now, I know that you touched on this, but what are some of the things that would make an adolescent more easily pressured or influenced by another?
Well, let's start just with the general observation that the adolescents are, in general, much more sensitive to social influence. There's a part of the brain that we call the social brain, which is the part of the brain that's active when we're processing the social world and trying to figure out what other people think and what their attitudes and opinions are and what they want us to do and so forth. And studies have shown that that part of the adolescent brain is just much more easily aroused than the adult brain. This helps to explain why kids are so concerned about what their friends think of them and are so easily influenced by their peers. Now, so adolescents in general are more subject to peer influence, more susceptible to it. I think who the peer is and what the relationship between a specific teenager and that other peer also plays a role. And so adolescents are going to be more influenced by peers and other people who they perceive as more powerful, or ones that they look up to, or ones whose admiration they want to get. And so you have to understand the relationship between an adolescent and a particular person to think about how that person might exert influence over the adolescent's behavior.
And when adolescents are in unsupervised groups of peers, are there specific behaviors that might develop?
Yeah, bad behaviors. I mean, it's sort of a recipe for adolescents to engage in risky behavior.
What if there's an older individual in the group that's acting as a leader? Are there certain characteristics that adolescents might exhibit?
They would likely be more influenced by that person, more likely to go along with what the person asks them to do, or to do something that they think will please that person.
Can you talk to us a little bit about positions of dependency, or why teenagers are so susceptible to other people's influence?
I'm not sure I understand the question, sorry.
What makes teenagers so susceptible to other people's influence?
I think it's, as I said, because their social brains are in high arousal state. And so they're just paying attention to the social world and to what other people think of them and what they believe other people want them to do. And that makes them more easily influenced.
In adolescence, are people more sensitive to rewards and less sensitive to the penalties?
Yes, I said that before, yeah.
And what in the brain's development causes that?
I'm sorry, I couldn't understand the question.
What in the brain's development causes this?
Well, the part of the brain that is sensitive to reward, which is in the limbic system, is much more easily aroused during adolescence. It has to do with the presence of a neurotransmitter called dopamine. Dopamine it's a chemical in the brain. It plays a really important role in our experience of reward. And so whenever we expect to be rewarded or actually get rewarded, there's an increase in dopamine activity in the brain. And one of the major effects of puberty on the brain, so puberty doesn't just affect the way we look or our sex drive or our sex organs. It affects the brain also. One of the effects of puberty on the brain is to increase dopamine activity in the brain's reward centers. And so there's more dopamine activity in the brain's reward centers during adolescence than there is at any other time in life. And so I think this is the biological explanation for why adolescents are so much more sensitive to reward than they are to costs.
How does a lack of brain maturity impact adolescents' ability to understand the concept of deterrence?
Well, to be deterred from something, you have to have an interest in thinking about the future, right? If you're about to commit a crime, and if you're going to be deterred from committing that crime, it's because you're thinking about what might happen to you if you get caught. All right, so you're not just focused on the present, you're focused on the future. And as I said before, adolescents are not very oriented to the future. And if you can't be oriented to the future, it's going to be very hard to deter you from doing something.
Can you tell us what brain plasticity refers to?
Sure. Plasticity is the concept that scientists use to refer to the brain's ability to change in response to experience. So our brains are always somewhat plastic. So if, tomorrow you remember what happened in this courtroom today, there will have had to have been a change in your brain, or there'd be no other way for that memory to be stored. So all of our brains are plastic. But what scientists now know is that there are two periods in development when the brain is more plastic, very plastic, much more than any other periods of time. And that would be infancy and early childhood and adolescence. And so the brain is very plastic when we're born. That's why infants learn things so quickly, because their brains can change quickly. And then it loses some of its plasticity. And then there's another burst in plasticity after puberty that keeps the brain plastic through adolescence. And then it declines in adulthood.
Doctor, can stress have an impact on brain development? Sure.
Stress is not good for the brain. It releases chemicals that impair the brain's development, and we know that stress has a particularly bad impact on the prefrontal cortex of the brain. And so children who've experienced a lot of stress and trauma growing up have slower development of their prefrontal cortex, the part that takes care of self-regulation. And the ultimate level of functioning in that part of the brain is also impaired. So they're slower to develop self-control, and the amount of self-control they're capable of is diminished because of the stress or trauma that they were exposed to.
Now, for our understanding of adolescents offending, are most juvenile offenders likely to become adult criminals?
No. I mean, that's been studied many, many, many times. If you, and I've done some research, my colleagues and I, on this very topic. We followed a sample of serious juvenile offenders. They'd committed felonies, some of them murder, a lot of armed robbery, when they were 15, 16 years old, and we tracked them over time to see which ones remained engaging in criminal activity and which ones didn't. And like most people, we found that only about 10% of the sample became chronic adult criminals. There's a peak in crime at around age 19 or so. And that's true for violent crime and for property crime. And then it declines. And very few people, even those who were committing crimes when they were juveniles, are committing crimes after their mid-20s.
Would you say that adolescents are still capable of change?
Sure.
Why is that?
Well, the brains are still plastic, and that's what makes us able to change. And the odds of somebody being able to change are going to be much greater when your brain is still plastic. This is why it's so hard to learn some things as adults that we hadn't learned beforehand. If you try to learn how to surf or ski or learn a foreign language, it's just much harder when you're an adult than had you learned those things when you're younger, and that's because your brain is no longer very plastic, so it's harder to change.
To talking about late adolescence, and I think you testified earlier, please, I know you'll correct me if I'm wrong, but that's 18 and 19, 20, is that
that's correct.
Ages? Okay. And I just want to be clear, the night before your 18th birthday, when the clock strikes midnight and you turn 18, there's not some magic that happens that you're not magically an adult and developed and mature the next morning.
No, the decision to draw some boundaries at 18 under our law was a decision that wasn't made because there's something magical about turning 18. It was made for other reasons, and we have other boundaries at other ages, right? I mean, we have the boundary at 16 for driving, even though there's nothing magical that happens then either, and we have the boundary 21 for buying alcohol, even though there's not something magical that happens then.
Are there ways in which brain activity and psychological functioning during this time period, the 18 through 20, that's more similar to younger adolescents than adults?
Well, yes. There's been a couple of studies that our group did where we tested self-control in a sample of middle adolescents, late adolescents, and adults. And we tested them both under cold cognitive and hot cognitive circumstances. And when we used the hot cognitive circumstances, the late adolescents behaved and their brains looked more like teenagers, the younger teenagers, than it did like adults. But under cold circumstances, their brains looked more like the brains of adults and their behavior looked more like adults than it did like teenagers. But, you know, as I said before, the brain is still maturing during late adolescence. But it has been maturing. They're more mature than, 16-year-olds, but they're still less mature than 25-year-olds.
So what about sensitivity to rewards versus cost in late adolescence?
They're still not calculating the same way that adults do. That is, they're still putting more weights on reward than adults and less weight on costs, especially when they're 18 or 19. In fact, in some of our studies, 18 and 19 is the peak age in reward sensitivity.
What about risk-taking behavior for those ages?
I mean, if you just look at the studies done in labs like we do, but just look at epidemiological data. When are people engaging in binge drinking? When are they engaging in reckless driving? When are they engaging in unprotected sex? All these risky behaviors tend to reach their peak in late adolescence. And it's because of this problem with the accelerator and the brake.
So is there a capacity for change in the late adolescence?
I would think so, because the brain we think is still plastic then. And if, you asked me before about when people stop committing crimes and how many juvenile offenders become adult criminals. Well, if 90% of them don't, then they're changing in some way.
Dr. Steinberg, are you familiar with Justice Kennedy's opinion in the Roper and Graham cases?
Sure, because I was one of the scientists who wrote the amicus brief that influenced the decision. Our brief and our research was cited by Justice Kennedy in the Roper decision.
What are the three characteristics of juveniles that Justice Kennedy described when he wrote that they were less culpable than adults? Your Honor, he contributed to those cited Supreme Court opinions. He can testify to his own.
Ask about his contribution.
Yes, Your Honor. Dr. Steinberg, can you tell us about your contributions specifically regarding those characteristics of juveniles that Justice Kennedy was mentioning in those opinions?
Well, a colleague and I wrote and published an article called Less Guilty by Reason of Adolescence, in which we discuss the fact that kids are more impulsive and more subject to peer influence and less hardened in terms of their personality. And that article was cited in the amicus brief, but it was cited in the court opinion as well.
You are aware that Mr. Wade was 47 days past his 18th birthday at the time of this offense, correct?
Yes.
Now, we've been speaking generally about adolescence, and would you agree with me that some 18-year-olds are more mature than other 18-year-olds?
Absolutely.
Okay, and can you talk to us a little bit about where Alan Wade would fall in that?
I have no idea. I wouldn't want to speculate. I think that to the extent that the trauma and stress that you described in your opening argument is there, I certainly wouldn't think that he'd be at the more mature end of the range, but I really can't say. I've never met him, never tested him. I have no idea.
But you have reviewed prior trial testimony, correct?
I have
You've reviewed prior trial testimony in this case?
Yes, I have. Mhm.
Your Honor, may I have just a moment? Thank you. Thank you, Your Honor. I'm going to direct you to the witness across.
Good afternoon, Doctor.
Good afternoon.
So I want to make sure that I understand that people in late adolescence, 18, 19, 20, that they are capable of empathy, correct?
Yes,
And they understand the difference between right and wrong, correct?
absolutely.
And they would intellectually be able to understand the concept of death
Absolutely.
and understand the permanence of death.
Absolutely.
And that they would have the ability to know that murder is wrong,
Yes.
which means Alan Wade would have had those capabilities.
Unless there's something wrong with them that would limit that intellectual capability, yes, he would.
Well, have you looked at any of the intellectual capabilities of Mr. Wade?
I mean, I believe from what I read, he's of normal intelligence, so, yeah.
There's no defect that you're aware of?
No.
Okay. So I want to be clear about this whole juvenile stuff. Juvenile is under the age of 18, correct? According to the studies that you've participated.
Well, juvenile is a legal word. It's not a word that scientists use.
I got it.
We call them adolescents, but we also call 19-year-olds adolescents.
Sure, I get that. So but I want to clarify your question about juvenile crime.
Ah, okay.
So when you were looking, I think you said 15 and 16-year-olds is what you're
In that study, yes.
And in that study, and I know that would not necessarily, well, let me instruct that. You found that in people, juveniles 15 and 16, that had committed crimes, meaning they were in the system, correct?
Correct.
And there was intervention by the system, correct? In other words, they were caught.
They were caught, that we got them because they had been caught. Now, not all of them were locked up. Some of them were, were on probation or in the community or whatever.
There was some form of societal intervention.
Sure.
Okay. And even with societal intervention, 10% of those reoffended significantly?
Yes, and that's a figure that comes from other studies besides ours.
Well, that's significantly higher than the population as a whole, correct?
Yeah.
Okay. So if you do offend as a juvenile, you're much more likely to reoffend as an adult than a person that did not offend as a juvenile, correct?
Yes.
Okay. And you said that life, that you actually filed, I think, amicus brief saying that life was, or life without parole was not an appropriate punishment with regard to juveniles, correct?
That was the Supreme Court's conclusion, yes.
And but you're not saying that life is not appropriate for this defendant?
It's not my role to decide what's appropriate for this defendant.
Well, I guess in basing your expert opinion and your trained opinion, it wouldn't be, because there's not a lot of difference between an 18-year-old, 19-year-old, and 20-year-old and a 15 and 16-year-old, right?
From a scientific point of view.
Right. Okay.
Yeah. Well, there's a difference. I think I did say that they're more mature than the 15 and 16-year-olds, but less mature than the 25-year-olds.
Okay, fair enough. I want to talk a little bit, because you mentioned the other, we allow people to drive at 16, correct?
Right.
And I think we could all, from our common sense and knowledge, that the possession of a couple of tons of steel is very could potentially be very detrimental to our society.
No, I'm in full agreement.
And so certainly we, as a society, have allowed 16-year-olds to do that fully, correct?
Yes.
And then you said something about alcohol having to be 21, correct?
Right.
Now, I think I read something that you've opined that, in your professional opinion, that the drinking age should be lowered to 19. Is that true?
I do believe that, yes.
So we talked about the differences, the impulse differences, and I understand that no in way, shape, or form is anything that you're saying here today really specifically imputed to Mr. Wade, correct? Because you never evaluated him or anything like that.
Yeah, my role is simply to educate the jury and the court about the science of adolescent development.
Okay. You talked about impulse control. Would you not agree, doctor, that a crime that has been planned for not hours, not minutes, not days, not weeks, but even up to months, that the impulse control of an adolescent would have far less of an effect than a crime that was a much more spur-of-the-moment decision?
Yeah, because I think by spur of the moment is basically impulsive, right?
Right. And that if you planned a crime over not hours, not days, not weeks, if you planned a crime for that long, that would be much more under, I think you referred to it as the cold cognition as opposed to hot cognition. Would you agree with that?
Yeah, but conceivably, you could be part of a group of people that committed a crime that was planned by somebody in the group, but that you didn't do the planning.
Of course, and that's for the jury to decide how much Mr. Wade knew or didn't know during the period of time. But certainly, if Mr. Wade was part of the planning for days and weeks, that would be much more in the cold cognition than the hot cognition.
Yeah.
And I believe you testified earlier that the cold cognition of someone 18, 19, and 20 is nearly identical to that of an adult, correct?
I said it was just as good, not nearly, but just as good.
Just as good, okay. Your words were better than mine, very good. I want to talk a little bit about the peer pressure, and I just want to clarify something, because you said something that if juveniles left unsupervised, bad things happen, right? I think you said that?
Yeah.
But also good things can happen if juveniles are together, right?
Sure.
I mean, I think we see the March for Life is organized by children, right?
Sure.
Okay. Sensation seeking. You're not saying that Mr. Wade had a sensation seeking to see what it was like to bury two human beings alive, right?
I'm not saying anything about Mr. Wade.
Have you heard of the statement that someone just got involved with the wrong crowd or around the wrong people?
Sure.
Is that commonly associated with arguments to lessen somebody's culpability?
Well, sure, if the wrong people did something coercive or put pressure, then sure.
Okay. And I think you've said some of these things, but I just want to go to the general, not with Mr. Wade, but just general limits to our scientific ability of understanding the brain. Okay, is that fair? So at this point in our scientific development, there is no way to look at a human being's brain and tell what type of behavior they're going to embark upon, correct?
The only exception, that's mainly correct, the only exception would be if there was an identifiable tumor or a lesion in the brain that was going to affect a certain kind of behavior, but not an uninjured normal brain, no.
With that exception, you would agree?
Yes.
Okay. And you would agree that there is individual variation in physical development of the brains among individuals, correct?
Yes.
And I think you said that's even manifested itself with regard to behavior, in that one 18-year-old may be very mature and another 18-year-old may not be.
Correct.
You would agree that scientifically, with the caveat of tumors and lesions and things that you can actually see like that structural and physical differences in a human brain do not necessarily equal definable behaviors.
I'm pausing here because I want to distinguish between what science is capable of doing now, which would make your statement correct, and what it might do. Right, let me just put it this way. Everything that we do has to have some brain related to it, right? I mean, there's no behavior that we engage in that isn't affected by what's going on in the brain or by the anatomy of the brain. Whether we can, your question was, can we do that at an individual level, I think, and we can't now, no.
Okay, well, I guess the main part is, although I think generally speaking, the science accepts the concept that the juvenile brain the adolescent brain is structurally different than a brain in the mid-20s or late 20s.
Yes.
But that doesn't mean that the individual 18, 19, 20-year-old will embark in a certain behavior or not because of these differences.
That's right.
Right, okay. And my next question, I think, will illustrate that more. Would you not agree, Doctor, that there are millions upon hundreds of millions of children that are able to control and modify their behavior according to societal norms, correct? Even with all these issues.
Sure.
Hundreds of millions of children are able to not go around killing people.
Yeah, absolutely. Thankfully.
Thankfully, I agree with that. Okay. Would you agree that there is no scientific line that could ever be drawn as to when a person should be treated as an adult or a child, correct?
That's a legal decision. That's not a scientific. I think science can help people who write laws make decisions, but that is a legal decision.
Well, I think you testified earlier that 23, 25, there's even some disagreement now about when it's fully formed, and certainly there's individual differences, correct?
Correct.
Okay. And then would you also agree that the brain goes through a structural or physiological decline, in the mid-40s, early 50s?
Yeah, I mean, certainly in some regions that guide memory, we know there's some decline there.
Right, so the brain in your field is in tip-top working order from 25 to 45. Is that fair?
For some purposes, if for other purposes it's in tip-top working order at a younger age. Like if you were giving people, if you were looking at memory,
right.
It's good by the time it's 16.
Got it, okay. And you would agree that a 17-year-old could be much more mature than a 20-year-old and vice versa, correct?
As individuals, sure.
Now, has there been any work in your field with regard to gender differences and brain development?
Yes.
And you, in your studies, you found out that women, obviously, I think the jury probably knows this, offend criminally at a much, much, much lower rate than men. Boys, correct?
Yeah, I mean, much, I think it's like now 1/4 of the rate or something like that.
And you would agree that the law shouldn't treat women and men differently, correct?
Correct.
To conclude, Doctor, that a person of this defendant's age would have intellectually appreciated the nature of his conduct, correct?
Yes.
He could have had the ability to conform his conduct to society.
Well, unless he was in a situation that he thought he couldn't extricate himself from.
Okay, well, the facts the jury will have to hear all of that.
Right.
I'm
Yeah.
talking about generally speaking.
Right. Yeah, definitely. Yes.
Based on what you know about the case.
Yeah.
That he could have strike that. And that even though he had the ability to do this, he chose wrong. Correct?
What took place was wrong. I think everybody would agree with that. I don't want to testify about this particular defendant, but if you're asking me, I think, do people who are 18 years old know the difference between right and wrong, and do they have the capability to choose to do the right thing? The answer is yes to both of those questions.
That's all the questions I have.
Okay, thanks, Your Honor.
Yes, Judge, we need more of this. That would be Pastor William Schwartz. Pastor William Schwartz. He's right outside. Oh, I'm sorry. There he is. Thank you. Thank you.
Sir, if you'll come to the center in front of me here, come on down and take the oath from the clerk, please. Just take a stand.
Good afternoon, Pastor.
Hello.
Can you please state your name and spell it?
My name is William Schwartz, Williamschwartz.
And Pastor, where do you currently live?
In Belgium.
And what brought you to Belgium?
I had a board meeting here, but also obviously the trial as well.
No, what brought you to Belgium?
Oh,
Not
brought
here.
me to Belgium, I'm sorry.
We know why you're here. What brought you to Belgium?
Yeah, I'm a missionary there. I serve as a pastor.
Okay, and so you're currently employed as a pastor?
I am.
Okay, how long have you been doing that?
In ministry, 28 years.
Wow, okay. Now, have you ever been a pastor in Florida?
I have.
And where was that?
I served as a youth pastor in Baker County, Florida, and subsequently became a pastor there as well.
Okay, and so for the jury, Baker County is also known as McClenny? Would that be
McClenny,
correct?
Florida was the capital city. Main
What
city.
church was that?
First Assembly of God.
Okay. And were you a youth minister there?
I was.
What years?
From 2002 to, I'm sorry, from 96 to 2002.
Okay. Now, while at the First Assembly of God, did you ever meet a woman by the name of Frida Gainey?
From day one, yes, ma'am.
Okay. From day one of you being a pastor there? Okay. Did you meet her sons, Alan and Andrew?
Yes, ma'am.
Okay. I want to talk to you very briefly about Andrew. Were you aware at the time, or have you since become aware of any problems that Andrew has had throughout his life?
Not at the time. I learned later that he's been put on the spectrum or diagnosed to be on the spectrum.
For autism?
Autism, yes, ma'am.
Okay. And so you didn't know it at the time, but you know it now. Looking back, your thoughts on that?
Oh, that explains a lot of things. Yeah.
Of Andrew's behavior?
Yes, ma'am.
Okay,
Yeah.
thank you. Now, what period of Alan's life did you have regular contact with him, with Alan Wade?
With Alan, from the time we got to the church, he was probably 9 or 10 years old, until the time I left in 2002.
So till about the age of 15, maybe?
I would assume 15, yes, ma'am.
Okay, and that's Alan sitting over there, right?
Yes, ma'am. I
Okay.
recognize him.
Now, how often during that time would you see Alan and his mom, Frida?
Well, our church activities were a minimum of twice a week.
How well did you get to know Alan during that time?
I think I got to know him as well as anybody else could.
Okay,
On the time that I had with him, yes, ma'am.
okay. Did he participate in events at church?
Yes.
Maybe tell me what he did at church. What
Well,
kind
we
of
had a
events?
youth center called The Connection, so it wasn't open just on our youth service nights. So he would frequent there when we were opened up for game days or whatever we were doing, as well as frequented our youth services as well.
Did he play basketball?
He did, yeah,
the
we had a
basketball
basketball league, right? Yes, ma'am.
At church, okay. Did you have the opportunity on a regular basis throughout those several years to observe Alan with other staff or members of the youth group?
Yes, ma'am.
And when he participated, how was his behavior?
Alan's always been very respectful. We never had any problems as far as those type of things, always respectful to adults and so on. I would say he was also withdrawn a bit.
Okay, and we're going to
As well.
talk about that in just a minute.
Okay,
I will get to that, sir. Did he get along with everybody?
yes, ma'am.
Okay.
Yeah.
And you said he was respectful and polite. Did it ever come to your attention when you were communicating with Alan and his mom that Frida was a single mother?
Yes, ma'am.
Okay. And so you were aware of that pretty early on?
From day one, yes,
Okay.
ma'am.
Did you ever have the occasion to meet Alan Sr. during that time?
His father,
His father?
yes, once or twice.
Just once or twice?
Briefly, this is Alan's dad type of introductions, yes.
Very short interaction?
Yes, ma'am.
Okay. I'm going to call him Mr. Wade Sr. or Alan Sr.
Okay.
And that means Alan's dad didn't participate with the church events and
No, ma'am.
things? That Alan didn't come see Alan play basketball,
No, ma'am.
anything like that?
No.
Never brought him? Yeah.
No.
Okay.
No, ma'am.
What were your impressions? I want to go back to Miss Frida Gainey, his mother. What were your impressions of Frida and how she was managing her family, including Alan and Andrew?
She was a hard worker, had a job, she did the best she could with being a single mom with growing boys. I definitely wouldn't say it was easy. It was certainly a struggle.
Okay. And I guess I jumped ahead a little bit. At some point, Mr. Allen Sr. was gone from the picture completely, right?
I've never known him to be in the picture, ma'am.
Thank you. So Miss Frida, she was struggling, trying to do the best that she could, is what you
Yes,
said.
ma'am.
Okay. Were you ever made aware of Miss Frida Gainey's cancer diagnosis?
Yes, ma'am.
Okay. And in fact, the church gave her some help, correct?
Yes, ma'am. I
Okay,
believe we did,
all right.
yes.
As much as you could to help her out?
Yeah.
Okay. But she had really no other support?
Not that I'm aware of.
No friends or other family that were helping her?
Outside of the church, not that I'm aware of.
Okay.
Yeah.
What can you speak about, or what can you speak to about the impact that Ms. Frida's cancer had on Alan?
I think it was hard on everybody. I mean, to be honest, there was no dialogue that I had directly with Alan concerning that event, but it certainly capitalized on the environment of the home that was already a challenge, I would
Right.
say, being led by a single mom.
Right. And so did you see Alan become more withdrawn
Yes,
around that time?
yes, ma'am.
Okay. Did you have any conversations with Alan Jr. about his dad leaving?
I had a conversation with Alan in regards to ping pong table that he wanted to.
No, I don't think you understood my question. About his dad leaving. Did you have any conversations just about the dad being absent?
My conversations with Alan about his dad being absent was the fact that he was absent.
Okay. And
Yeah.
it was hard for him?
Yes.
Something that Alan, from what I'm hearing, would talk about, but it was hard to talk about
Yes.
for him.
Yeah, he wasn't an open book by any means.
Okay. Now, tell us the ping pong story table.
Well, as I mentioned, we had a youth center. It was called The Connection. And Frida is a very generous person. And she said, we have this ping pong table at the house. It belongs to the boys. And I'd like to give it to the youth center to use up there. I learned that Alan was very upset about that. And
Why?
well, I went and talked to him about it and asked what the deal was. And he said, well, it's the last thing my dad ever gave me. And he was very upset that his mom was giving it away. So we certainly wasn't going to take it away from him. At that point, he eventually gave it to us out of his own desire to do so.
Alan did.
Alan did.
Alan Wade Jr.
Yes.
Okay, so let me go back. So ping pong table wasn't because Alan was being selfish.
No, man. No,
It was
he was
because
very
it was-
emotional.
He
To
was
the
very
fact that
emotional.
we sat in his front porch and he said, it's the last thing my dad gave me. Up to that point, I'm sure there's probably things after that, but at that point, it's something his dad gave him that was important to him.
That's all he had left of his dad.
I would,
An emotional attachment.
yes, ma'am, he was very emotionally attached to it because of that.
All right. And then you said at a later time, Alan decided to go ahead and donate it to the church so other kids could enjoy it.
Well, I think he came as well periodically.
Oh, so he participated as well?
I think so.
In the ping pong?
Yes,
Okay.
ma'am.
All right, great. I want to talk to you about the concerns that you as a pastor and a human being, do you have kids?
I have 2 adult children, yeah.
Okay. So being a parent, being a pastor, being around youth, at this time, what were your concerns about Alan?
Well, I was always concerned of how withdrawn he was. I was also always concerned as well. Anytime I saw Alan outside of our context, he seemed to be with, some young men who were probably a couple years older than him. Alan was always a follower. And some people are leaders, some are followers.
He was not a leader, he was a follower.
Yes, ma'am. In my opinion, he certainly was.
Okay. And when you saw him in these groups, what was your impression about what he was trying to get out of it?
I think Alan's always been looking for a mentor or father figure in his life at that stage of his life.
And just couldn't find one?
No. Our youth team, we talked about it often, our youth ministry team.
Specifically about Alan?
Specifically about Alan and others as well. What they're looking for. We're always looking for a connection on how to connect with young people.
So he's seeking approval?
Absolutely.
He's seeking a father figure?
In my opinion.
He's seeking support from anyone or
In my
anywhere
opinion,
he
absolutely.
can get it?
Yes, ma'am.
May I have a moment, Your Honor? Pastor, thank you so much for being here.
Nice to see you again, Pastor.
You as well.
So, Mr. Wade, the defendant in this case, spent a minimum of 2 days a week from 1996 until 2002 in your church.
We didn't count every time, but on an average, it would be 2 times a week, yeah.
And sometimes more, he would just come up and play basketball or play ping pong.
Sure,
like
certainly.
The church was open, I guess, during business hours for the youth to come. Is that
We
fair?
had days that we were open, yes. Yeah.
So that the 2 days, and I understand, if you've been out of town or been sick, I understand, but generally speaking, it'd be 2 or more days of it.
Yes, ma'am. Yes, sir.
Okay. And he did that from age 9 to 10 all the way to 15? All
Yes.
right? Okay. And so during this period of time, I assume you and your fellow pastors are doing your best to instill in all of your youth good Christian values. Is that fair?
Of course.
And you're trying to teach them the difference between right and wrong. Yes?
Yes.
And I know you tried your best. Is that fair?
Indeed.
And all the things that counsel asked you about being a father figure, you would have been willing to do that as best as you could, correct?
Indeed.
And during all the period of time that you were with the defendant, you never saw him doing risky behavior, correct?
Never saw him doing any risky behavior. Was certainly concerned with some of the company he was keeping.
Fair enough. And you never saw him actively wasted on drugs or narcotics, correct?
No, but I heard.
Okay. But in your interactions with him, he
No.
appeared to be sober.
Yes, indeed.
And that was all the way until he was 15 years old?
Yes, sir.
That's all the questions I have.
Yes, sir. Thank you for the questions. Thank you.
Members of the panel, any questions for Rebecca?
I didn't,
You'll write it up. Pastor Schwartz, two brief questions from one of the jurors. Did you know about no school since the 8th grade?
I'm going to have to say no to that.
I'm sorry?
No,
You did not?
I wasn't aware.
Okay. Did Mr. Wade's mother ever discuss drug use with you?
Yes.
Follow-ups, Ms. Abel.
Yes.
Pastor, can you tell me about?
The drug use?
Yes.
Just said there was suspicion that there was some usage. That was certainly closer to my time of departing.
Okay. But it was discussed with mom, and so mom was aware?
It was discussed with me from mom that there was a concern.
Okay.
That,
Okay, thank you.
Any further questions from the jury for Pastor? Thank you very much for your time. I have anything to
Yes, sir, is excused.
Let's stay at this stage. Who's the next witness going to be?
It's going to be Mr. Wade, Senior.
Okay. Maybe 10 minutes?
Yes, sir.
Let's take a short 10 minutes, ladies and gentlemen, from the jury. Let's step back. right, are we ready to proceed, Miss? Okay. If our jury is ready, have them join us, please. Oh, sure. All right, our jury is returned. Be seated, ladies and gentlemen. Mr. Richards.
The defense calls Alan Wade Sr., Your Honor.
Is Mr. Yes, yeah.
He's approaching, Your Honor.
Mr. Wade, if you come on up to the clerk in front of me and take the oath, please.
Please state and spell your name.
Alan L. Wade Sr., A-L-A-N, L middle initial, Wade, W-A-D-E.
And where do you currently live?
Ormond Beach, Florida.
Are you currently employed?
No, sir.
Are you Alan Wade Jr.'s father?
Yes, sir.
Were you previously married to Alan's mother, Frida Gainey?
Yes, I was.
How many children did you and Miss Gainey have?
2.
And that would have been Alan and Andrew?
That's correct.
Was your marriage to Miss Gainey your second marriage?
Yes, it was.
Did you have any children when you met Miss Gainey?
An adult daughter that was in Connecticut.
And her name is Trish, correct? Her name is Trish, sir?
That's her nickname. Patricia is her real name.
Okay. When you and Miss Gainey were married, what part of the state, or where did you and her live at?
Daytona Beach.
Okay. Did you and Miss Gainey eventually separate?
Yes, we did.
And about how long were you and Miss Gainey together before you separated?
Roughly 17 years.
Okay. How was it that you two became separated?
It was numerous reasons.
Okay. Did it have something to do with the job, going back to school or anything like that?
Yeah, part of it, yes.
Okay. Did there come a time that you came home one day and Frida and Alan were gone?
Yes.
Can you tell us about that?
I just came home and there was a note on the table and said, we've left.
Okay. And how old was Alan when he and Miss Gainey left?
Approximately 9 or 10, somewhere in that neck of the woods.
Did you know where she and the boys had gone?
Not for about 6 weeks.
So for 6 weeks, you didn't know where Alan had gone, is that correct?
I didn't know where any of them were.
Okay. Did you eventually find them?
By accident, yes, sir.
How did you find them?
I happened to call her sister's house and ask them if they'd seen them, and one of the girls that was there said, "Oh, Aunt Frida?" And they grabbed her, and I said, "I got them."
And where was Miss Gainey's sister's house at?
Glen St. Mary's.
Do you know if Miss Gainey and the boys stayed there long term?
I don't know the exact length of time, but it wasn't shortly thereafter they moved into a double mobile home.
And that was in McClenny?
That's correct.
Now, prior to Miss Gainey leaving, how would you describe your relationship with your son, Alan Wade Jr.?
We always got along fine. We went fishing. If I was doing something, he wanted to be in the middle of it.
And did you do other stuff with him?
Not as much as I should have, because I ran the roads. I was third-party maintenance for Litton Amacom, and we did Daytona, Orlando, and Jacksonville airport flight control stuff.
Okay. Now, after Miss Gainey took the boys to McClenny, how often would you get to see Alan?
It was very sporadic, maybe once every 2 or 3 months.
How would you describe your relationship with Alan during this time?
Kind of mixed emotions. He was there, but he didn't talk much. And then his older brother, Andrew, had told me that he was on drugs, and I quizzed Alan.
We'll get to that. We'll get that.
Okay.
And at some point in this time, did you move out of state?
Yes, I was in Savannah for 5 years.
Okay. And what were you doing for work during this time?
I was a third-party contractor delivering air freight.
Are there times you would drive down from Savannah to see them and the boys would not be available?
That's correct.
Why weren't they available?
Well, I got different answers. You know, Andrew would say he told Alan and Frida that I was coming, and they would say he didn't tell us. So I can't stand there and point my finger at anybody because I don't know what was going on at the time.
And were you able to speak with Alan on the telephone during this time?
Intermittently.
Were there times that you would get the answering machine?
I don't think it was an answering machine. It just kept ringing, and then finally I'd get Frida, and she said, "I'll tell them you're coming."
Eventually, did you tell the boys to call you when they wanted to see you and you would pick them up?
Well, there was a spat between them, and I couldn't point my finger, and Frida kind of turned on me, and I guess it was everything in, conjunction with what was going on. And when she turned on me, I figured I'll be the one in jail because this is her city and I'm out of town. So I told the boys, I said, I won't darken that door again. I said, if you tell me I'm supposed to come pick you up or come see you, we'll go to the mall or whatever. And I would say, if you're not there, I'm leaving. I said, if y'all want me, I'll come blow the horn, I'll stay in the street, and you can go with me for whatever length of time we're going to have.
Did you ever see Alan Frida smack one of the boys?
Both of them that same day.
And when I say smack, you mean hit them. I mean hit them. Is that correct?
She hit Andrew, the older one, and his glasses cut him under the eye. And Alan had sassed her about something, and she'd popped him in the mouth, and he had a little bloody nick on his lip.
Now, at one point, for a 2-week period, did you pick Alan up and take him?
Twice, I think.
Okay. Did you have to buy him clothes at that time?
The one time I did, yeah, I went to pick him up, and he had one pair of shorts, one pair of tennis shoes, and I think he had the socks and underwear he was wearing. So we went to Walmart when I got back to Savannah and dropped another $100 on clothes that he could take back with him.
When you came back to Florida, where did you live?
Well, I had a former partner and they had an extra room. I was going to sleep in my van, and my partner said, "No, you won't. We got 2 extra rooms. You stay here until you get set up."
And why did you do that?
I had nowhere else to go. Well, that, and I had a job offer to drive boats statewide, and it fell through. So I had what money was in my pocket and what gas was in the tank of the van.
Were you able to make child support payments during this time?
Intermittent.
Did you get in arrears in child support payments?
I had a slip and fall, and it was a little over 8,000, I think.
How often would you see Alan between the ages of 14 and 18?
I would say somewhere between once every 2 or 3 months, maybe.
And this is between the ages of 14 and 18 that you saw him?
No, not 18, no. He was 14 or 15, I think, was the last time, and it was about the time he gave the ping pong table to the youth group.
Okay, so between the ages of, let's say, 16, 17, and all that, you didn't see him, is that correct?
No, sir, I did not.
And you weren't a part of his life, is that correct?
No, I wasn't.
Now, during this time, you said that were you aware of Alan's substance abuse?
Just from what Andrew had said, and with him having Asperger's, I couldn't say it was true. And we went to court down there about child support, and Frida mentioned that to the judge, and the judge just politely looked at him and says, "We're not here about your personal problems."
So you didn't talk to Alan about this or do anything to try to get him off drugs?
No, sir, I didn't.
And you didn't put him in rehab or anything like that, is that correct?
No, I wish I could have.
Did you have the money?
No.
Were you aware that Alan was staying with other families during this time?
No, and I figured that was when I couldn't get in touch with him. I heard it later that, he was in, right after he got arrested.
How did you find out about your son's arrest in this case?
A friend of mine, well, actually, my stepson's wife had called my daughter, and my daughter said Nikki thought that Alan had gotten in some trouble, and it sounds like it's pretty bad. So a friend of mine told me, he says, "Well, go on Google his name and Duval County," and I did, and I fell right on the floor. I said, "This can't be my son." I said, "It's got to be wrong."
Why is that?
He never showed any of those things.
Did you ever visit Alan in the county jail?
I think twice.
Okay. And what was the reason for that?
Well, one, I didn't have the gas to drive up here, and 2, he needed money, and only one time I was able to give him $50 for, I think they called it canteen or something.
And were you ever able to talk to him weekly by phone, or did you ever talk to him by phone while he was in jail?
There was a while that he was calling me like once every couple of weeks or something, and we would talk on the phone.
Okay. May I have a moment, Your Honor? This is with the state, Your Honor.
Mr. Wade, you never reported any abuse that Alan would have suffered at the hands of your ex-wife, correct?
No, I did not.
And if you thought he was being significantly abused, you would have reported?
Yeah, well, like I said, it was just that one time that I saw the abuse. I mean, it wasn't real significant, but apparently with the frame of mind that was going on in that household, it might have been, and I didn't see it. I'm not a doctor.
I get it, but the abuse was as a result of something that Alan did, correct? He sassed, I think you said?
He sassed her or something. I came in kind of in the tail end of it.
And you never abused Alan, correct?
No, sir.
If you knew that Alan was being abused, you would have reported it?
Yes, sir.
Okay. Is it fair to say that you tried to do your best by your son?
With what little bit I had, yes.
And except for your domestic difficulties with his mother, you made it clear to Alan that you cared about him, correct?
Oh, yeah.
You made it clear that you were there for him if he needed you.
Yes, sir.
That's all the questions I have.
Follow-up, Mr. Richardson?
Looking back on your time with Alan, is it fair to say that you weren't there for your son even though you might have wanted to be?
Yes, sir.
Okay,
Members of the jury, do you have any questions for Mr. Wade? I don't see any. All right, thank you for your time, Mr. Wade. You may stand down.
Thank you, sir.
Ms. Abel?
Yes, sir. Maybe call me Craig.
Here.
Nikki, Craig.
Ms. Craig? Pray you will come on down to the clerk in front of me and take the oath, please. Please take a stand.
Good afternoon, Ms. Craig. Can you state your name and please spell it?
Nikki Craig, Nickikraig.
And you are a guest here in Jacksonville today, correct?
Yes.
Where do you currently live? Where are you coming from?
Westfield, Massachusetts.
Okay. Are you currently employed?
Yes.
What do you do for a living?
I'm a CNA.
How long have you been doing that?
About 35 years now.
Okay, and for members of the jury that may or may not know, can you tell us what a CNA is?
I
know.
A certified nursing assistant.
Okay, all right, very good. Do you know this gentleman, Alan Wade?
Yes.
Okay, how do you know him?
He was my ex-husband's brother, so he's my ex-brother-in-law.
Okay, and that would be Robert, was Mr. Wade's brother?
Yes.
And you were married to Robert?
Yes.
Okay. You're not any longer married to Robert?
No.
Okay. Do you also know, might be an obvious question, Miss Gainey?
Yes.
Gainey. Okay, and so you're familiar with her as well? All right. Now, I want to go back to Alan's brother, Robert. How did you all meet?
Through friends.
Okay, and did you all meet in Florida here?
Yes.
How long ago was that?
Oh, gosh, 30 years ago, give or take.
Okay. And how long after you met Robert and you all started dating did you get married?
We were about 7 or 8 years.
Then you got married?
Yep.
And then how long did your marriage last?
Not long, not even 2 years.
Why is that?
There were problems. He had developed some drug addictions, and I just didn't think that was a very healthy atmosphere to raise our daughter.
Okay. So he was doing, Robert, Alan's brother, doing illegal drugs?
Yes.
Did Alan look up to him?
Yes.
He was Alan's kind of a hero? He was Alan's hero?
I can't say about that, but...
Okay. Now, did you and Robert have any children?
Yes.
And what is your daughter's name?
Alyssa Jade.
Okay, and she's here in the courtroom today too, right?
Yes, she is.
Now, how long did you and Robert live together in Florida?
On and off about 7, 8 years.
At some point, you both moved to Massachusetts, yes?
Yes.
But Robert leaves after a year.
Yeah, about that, yes.
Why?
He wanted to go back to Florida. He had a side job there, and he ended up meeting or running into old friends. I'm not quite sure the exact circumstances, but he wanted to stay in Florida, and then he started, just like hanging out and doing drugs and everything, and he didn't want to come back to Massachusetts, and I really didn't want him there.
Because of the drug use?
Yes.
And how old was Jade when you all first moved to Massachusetts?
She was about 2, almost 2.
Now, there is somewhat of a significant age difference between Alan and Robert.
Yeah.
Robert's older.
Yes.
By how many years?
9 years, maybe?
Okay, all right.
I'm not really good with.
Robert was the big brother.
Yes.
Did Robert ever come back to Massachusetts after he left? To move permanently, I mean.
No, no.
And so then you all ended up getting divorced, right?
Yes.
Could the age difference between Alan and Robert be more than 10 years? 15?
Yes.
Okay.
I'm terrible with.
It's okay, I am too. So it's possible it could be 15.
Yes.
Did Miss Gainey ever visit you and Robert while you were living in Massachusetts?
Yes.
And did Alan ever come to visit?
Yes.
Did he come by himself one summer?
Yes.
How old would he have been on that summer?
About 14, I believe.
And while he was up there, he visited with other family, right?
Yes, his half-sister Trish.
Trisha, okay.
Yep.
She lives in?
Connecticut.
Right, so he's up there with you primarily for the summer, but he goes and he sees his half-sister as well.
Yes.
And did y'all have a good summer?
I thought we had a great time.
It was enjoyable?
Yes, my friend, they live on a lake, and we went out there and went out in a boat, and we did some other things, and all the teenage girls in the neighborhood were all coming around, and
because of Alan?
yes.
Okay.
Yes.
So you went boating, did outdoor activities?
Yeah, we went to the amusement park, and we went up to my girlfriend's in New York and went sightseeing and things like that.
And Alan always enjoyed himself when he was with your family?
I hope so. He seemed to have had a nice time.
He had structure, right?
Yeah.
Okay. He had people that cared about him.
Sure.
He had things to do.
Yeah.
Family to rely on.
Yes.
And family events, the things that you all did together as a family, right?
Yes.
Even though you all are not blood, related by blood, right?
Right.
Okay. I want to shift your focus to your daughter, Jade.
Sure.
What kind of relationship did Alan and Jade have?
They seemed very close. They were, she always took to him and admired him, and they were always giggling, and he was always wanting to play with her, and he was kind of protective of her, and just goofing off with her and making her laugh. And
okay. Was he loving with her?
Very, yes.
Was he gentle with her?
Yes.
I've heard a story, maybe you can tell it, about a stroller.
Oh, Alan used to love rollerblading. It was very athletic, and he used to put her in the her little stroller and strap her in and go up and down the street with her in the rollerblades, and she'd just be laughing, having a wonderful time.
So he sort of filled in like a big brother to Jade.
Yes.
Would that be a good?
Yes, sure.
Okay.
Yep.
Now, another thing about Alan and Jade, obviously you said they had a strong bond, but I think there was something that happened that probably made that bond a little stronger, something that almost could have been a terrible ending.
Oh,
with your daughter.
One time, my son, where the apartment building he lived, they had a built-in pool, and she was running towards the pool, and I'm like, no, the water's deep. And of course, she was being little, didn't listen, and she dove into the water, and Alan didn't even hesitate. He just jumped right in and got her right out.
Saved her.
Sure.
Okay, so he wasn't going to let anything bad happen.
No, he was very, very protective of her.
Okay. Do you have any memory of Alan having friends in the neighborhood when he was with you?
Well, he wasn't there that long, but one of the girls used to come over every once in a while and want to hang out.
Okay. Was that the only summer that Alan visited you in Massachusetts?
Yes.
As a child? Okay. And so after the divorce and after that summer, did you continue to have contact with Frida Gainey?
Yes.
Now, did Jade ever visit Miss Gainey in Florida?
Yes.
Summers?
Yes, she would go just about every summer and spend time with her.
Okay. Now, regarding Alan, when you were going through your divorce, did Alan do anything to help you out Were you struggling a little bit?
Yes, very much so. I was having a very hard time financially and emotionally, obviously. And at one point, him and his friend Tiffany sent money.
Okay, that was to help you with bills?
Yes. He was very upset that his brother would do that to me and his niece, who he adored.
Okay, so he was trying to help you all in any way that he could?
Yes.
Help keep the lights on, right?
Yeah, pretty much.
When you heard about Alan's arrest and the reason why we're here today, what was your reaction?
I was just shocked. I couldn't believe that it was that Alan I knew would do something like that or be involved in that. That was just very much out of character for the boy I knew.
Have you maintained contact with Alan throughout the years?
Yes.
You've written letters?
Yes.
Seen him in the prison?
Yes.
He and Jade write too, right?
Yes.
Tell me about, and I think we're going to hear from her, but tell me about your observation of the friendship or more than a friendship, almost brother-sister relationship, and when she would get letters.
Well, obviously she was devastated by her father leaving, and Alan was always like right there for letters, and she would get really excited to go, can we go to the P.O. box to see if Uncle Alan sent me a letter? And I was like, sure, and it would just like brighten up her day, you know, hearing from him, and he wrote her quite often, and it just meant so much that, you know, she didn't have her dad, but she had him and his support and love, and she could, you know, write to him about anything she wanted to, things going on in middle school with the girl drama and everything, just everything she could share with him.
And in fact, at one point when Miss Gainey was diagnosed with cancer, she called and asked if she could send Alan to you. Is that right?
Yes, and I didn't think that was such a good situation because I didn't think Robert was such a good role model for him. He was having his own issues with, you know, drug abuse and being in his own little world, and I didn't think it was such a good fit because I was, you know, just struggling trying to, you know, keep my family going, and it wasn't a good situation at the time.
Right. And back to Jade, I don't mean to skip around, but would you agree that Alan was more of a father figure to Jade than Jade's own father?
Yeah, even just through letters and her visits to Florida, seeing him, absolutely.
Never missed a birthday?
Never missed a birthday, never missed anything.
Never missed a holiday?
Never, not a Mother's Day, he never missed my birthday. He used to send beautiful artwork to us. I mean, frame-worthy, beautiful things that were just, yeah.
Still have them?
Yes.
May I have a moment, Your Honor?
Some of his artwork is incredible.
All right, just a couple more questions. And I appreciate you being here and coming all this way, Ms. Craig. Do you love Alan?
Yes, very much.
And will you continue to love Alan?
I love Alan with all my heart. He's one of my favorite people in the whole world.
Even if he spends the rest of his life in prison?
Yeah.
Okay, thank you. Really appreciate you coming.
You're welcome.
State may have some questions for you.
Sure.
Ms. Craig, during this long-distance period of time, I guess between 14 and 18 with regard to Alan Wade, did you know about any drug use?
I had suspicions. Rita called me once and saying that Alan's very paranoid and acting very funny, and I just assumed he was doing some kind of drugs. I didn't know because I wasn't there with him doing any, so I don't really know that for a fact, but I assumed so.
And so the summer he was with you, you didn't see anything like that?
No.
How old was he when he spent the summer with you?
I'm 14, and I have a son who's older, so I'm very in tune with what's going on with that. I'm very aware of people and their stuff, and I didn't see any sign of that when he was with us.
During that summer, did you ever see any antisocial behavior or any rage issues or anything like that?
No, he was very helpful. We'd go to the grocery store and he'd be very helpful and want to hang out and help me cook dinner, and you know, he was a pleasure.
And from your experience with him, did he know the difference between right and wrong?
Yes.
And all these conversations, obviously you had a relationship with Miss Gainey,
Yes.
and you trusted her so much that you would send your daughter down to be with her, correct?
Yes. Yep.
Did Miss Gainey have the best interest in what would happen to her son, Alan Wade?
Say that one more time, I'm sorry.
Did she have the best intentions for what happened to her son, Alan Wade? Did she love him and care for him?
Did she? Yes.
And you witnessed that?
Yes.
That's all the questions I have.
Members of the, I'm sorry, Ms. Abel, members of the jury, any questions for Mr. Craig? Ms. Craig, thanks for your time. You may stand.
You're welcome.
Ms. Abel?
Yes, sir. Call Brian Dobson.
Ms. Dawson, please.
He's outside. Okay, thank you.
She's going good.
Thank you, sir.
Mr. Dobson, if you'll come on in to the clerk in front of me here and take the oath, please. All right, please take the stand over here, Mr. Dobson. Ms. Abel?
Good afternoon, sir.
Good afternoon.
Can you state your name and spell it for the record?
Brian Gerald Dobson, BrianGerald Dopson.
Where do you currently live?
I live in McClenny.
How long you live there?
Lived there all of my life. I'm 57, except for a brief stint at college.
Okay. Are you currently employed?
I'm not.
You are retired, is that right?
Yes.
Congratulations.
Thank you.
You are retired as an educator, would that be accurate?
That is.
And how long were you involved in education?
My whole career, pretty much my whole professional career, so that's 30 years in the Florida retirement system, 30 plus.
Do you know Alan Wade?
I do.
When did you first meet Alan?
I met him at Baker County Middle School. I believe it was 2002 school year.
Okay, was he in 8th grade? Would that sound
It was in
right?
8th grade, I believe. Yeah.
And what was your position at Baker County at that time?
I was an assistant principal.
And as an assistant principal, what was your main responsibility?
Discipline.
Okay. That's at Baker County, right, middle school?
Yes, ma'am.
Sorry if I repeated myself. And you had started there just at the beginning of your career, right, 1993?
Well, I'd been teaching since I taught. I started in 1991 teaching, and then taught for several years, and then became an assistant principal at a high school, and then moved over to the middle school. So I was there 1 year.
Yes, sir. Now, how did you come to know Alan?
So when I went to the middle school, I wanted to be proactive. So in the summer, I took the time to go over all of the referrals that had been done the previous year. And I sorted out the referrals. If someone had, I think it was 10, it's been a long time, but I think, let's say 10 referrals, or there's some litmus test that I used. And if they exceeded that number of referrals, then I looked at those referrals. I tried to determine if there was anything behavior-wise in those, if it was just tardies or whatever. And so there was a group that rose to the top that I decided to speak with over the summer if I could, just to say, hey, we're looking at a new year. Let's do things as well as we can. Let's be good. I'm here if you need me to talk to me. Please, come by rather than misbehave or whatever. So I was trying to get them to think about the year. And I had a contract that I had drawn up that just said, I agree to behave, basically. And
Alan's a part of that group.
He was a part of that group.
Now, just because you say referral doesn't mean something violent or egregious, correct?
No.
It could be chewing gum.
Yeah, most of them were not anything on that level. If they were moved from that school.
Okay, so it could be like tardies.
Could.
Parents, they're not getting to school on time, things like that, right?
Could be.
Okay, specifically with Alan, nothing stands out that you recall that was particularly egregious about his referrals, just typical teenage stuff.
Yes.
Okay. And there were several kids that had 10 or more referrals, right?
Yes.
Okay. Did you ever meet with Alan and his mother, Frida Gainey?
I did. I tried to meet with every student and parent prior to during that summer. And to be frank, I don't remember whether I met with them in person or over the phone.
But you did meet.
But I did meet with them because I was trying to involve the parents.
And you're trying to be proactive, right?
Yes, I was trying to be proactive.
You're trying to set them up for success.
Mm-hmm.
And you're putting yourself in the position of, from what I can tell, I've got an open door policy. Come see me.
Yes.
You got problems? I'm your guy. Come to me. We can talk it out. I can help, right?
Yes, I would walk around campus too, be out on campus, as were the other assistant principals there too.
Right, and you're doing it for the benefit of the welfare of these kids, right?
Yes.
Okay. When you had that meeting with Alan and his mother, whether it was phone or I know it's been some time, phone or live, did Alan seem to have a good year that year?
He did, as far as I remember.
And you had a lot of interaction with him that year, right?
I had a good bit of interaction with him, yes.
So you became somewhat of a support system for Alan.
I would say so, yes.
Okay, and of course, next year he goes on to high school, right?
That's right.
Okay, and tell me, you made a phone call to high school, right?
I did.
Tell me about that. When
Well,
Alan went to high school.
I was leaving the school system and Baker County school system, and I called the high school because I wanted to make sure that, there was somebody that was aware that he was coming over there and that, if they could establish a relationship, that he gets a good start there. He had a pretty good year and wanted to see him go on and do
And
well.
continue having
Yes.
a good year, right?
Yes.
And then Alan goes, right, and you have no idea
Yeah, I didn't know.
what happened. Now, were you aware of anything in particular about Alan's home life?
I was.
Okay. How did you learn about Alan's home life?
I don't remember when that would have come up, but I felt that Frida, or remember her being pretty open as a parent. She talked to me. So we would have conversations early on, and I would have talked to Alan. I don't remember when I knew more about his home life, but that would just come if he would drop by, or my office was in a hallway where a lot of the kids walked by. And so
the busy part, right?
yes, it was a busy part of the school. And so I don't remember at what point this happened, but he came and talked to me about a concern that he had about his family.
Okay. And he dropped by a few times, right?
Yes,
Okay. He talked to you about his mother's cancer?
he did.
Okay. Tell me, when he talked to you about his mom having cancer, thoughts? I mean, how did he even broach that subject with you, and how was it affecting him?
Yeah, I don't remember, how he broached it. I just remember that he told me. I remember him being concerned about his mom, and I think that was the point that he said he didn't see his mom as much as he wanted to, or something like that.
That he was missing her a lot.
Yes.
Okay. And she was absent a lot.
Yes.
And he expressed that to you.
Yes.
And he expressed it most times, if not all, majority, if not most. When he went home after school, he was home alone.
He said that. It seemed like there might have been a brother or somebody that was there, but I can't remember that. I just remember he did indicate that he was alone.
Did you think he was isolated? I mean, give me your thoughts.
Well, yeah, I did. I wasn't sure really anything about his social, I mean, who he hung around with or anything like that. I thought the part about him being alone at home, especially overnight, was unusual for somebody that age.
Most isolated kid that you knew?
I would say that that's probably true at that time.
At that time, right, okay. Back to the cancer. Was he afraid?
I think so. Most kids would be. He was like most kids. What I saw in kids that had parents that were going through something like that, there's actually a tendency, it seemed to me, for them to withdraw a little bit themselves, you know. I don't know if it's a protection mechanism or what, but it seems like that's sometimes how that happens.
Was he afraid or scared of her death?
Yes, I think so. I mean, I don't, it would not have been a surprise to me if he was. I'm sure he was bothered by the situation. That's what I remember.
I'm going to skip forward a little bit, and I'm going to come back, okay? You've seen Alan since his arrest, correct?
Yes.
Okay, you see him in prison?
Yes.
A few times.
Yes, ma'am.
You also have written him letters?
Yes.
In support of him?
Yes.
To tell him what?
Just to remind him that God can love him even though he did this terrible thing, right. And that he's worth something, and that you know, I definitely believed God loved him, and I felt like I wanted to tell him and remind him that he's still valuable as a human being.
Even at his worst moment?
Yes.
So his worst moment, what you're saying, it does not define who he is. He's a human being and God's child.
Yeah, that's what I would say, is he's a human being. Yeah.
Yes, sir. Okay. I want to go back to a particular phone call that's, and I know you're nervous, right?
Sure.
We've talked about this, that you're nervous being here today. At some point, did Alan come to you and express his doubt of his mother's love? Meaning, I don't think my mom loves me.
Yes. I don't remember actually when he said it first, but he would have said it more than one time for me to make a call to his mom.
Told you several times. I mean, maybe not in a row, maybe not at once, but over.
Yeah, he could have said it twice. He could have said it 3 times. I don't know what it was, but probably if I would guess, I'd say 3 times. I don't remember.
And so, what was your response to that when you were talking with Alan?
So whatever point he said it again, repeated it, however many times that was, I said, well, Alan, I think, you know, I had talked to his mom, Frida, and I said, I don't think you're right about that. And I think that you need to hear from your mom, because she may be upset with you about how you're behaving, but I believe she loves you beyond that behavior.
Okay, so as an educator, someone that's been around children for years, I'm going to assume, and I don't want to put words in your mouth, that you never would have thought that a mother would not say to their child, I love you. Is that accurate?
I mean, it would be highly unusual.
If you thought that, you wouldn't have made the phone call, right?
I wouldn't have called her because I believe she did love him.
Right. So you give her a call, and Alan's in your office, right? And you, yes?
Yes, ma'am.
And you put her on speaker.
I did.
And it's a lengthy conversation, right?
I don't remember if it was that lengthy. I think what I tried to do as a preface to asking her this in front of Alan is to talk to her about where Alan was, what he had said, what he was expressing to me, and then try to differentiate between the feelings that a parent can have with a teenager that is not behaving the way that they should.
Frustration
Yeah, the frustration of a parent.
of a teenage boy.
Yes. Versus loving that person unconditionally beyond their behavior.
Two different things, right?
In my mind, it is.
Okay. And so you're acknowledging to Miss Gainey, you're acknowledging her feelings. Teenage boys, you must be frustrated. You're telling her you get it, because you do get it, right? Because you're there all day. But then what do you say? What do you ask her to do?
Well, I said, Alan, I think, wants to hear you say that you love him unconditionally beyond the behavior. And I told her that he was, admitting his own, that he was a teenager and that he was hard to, at times to raise that attitude like most teenagers do, or some teenagers. And that, I was trying to let her know that he saw his own behavior and that kind of thing.
He acknowledged it.
Yes, he did.
And so you said?
I said, so will you, I guess the question and not the how do you feel about him, his behavior, but he wants to hear you say that you love him
And there was a long pause.
And there was a pause.
And you did not expect the answer coming?
No.
And what was the answer?
The answer, as I recall, was, Mr. Dobson, I can't say that right now, or something like that.
Thank you, sir, for being here.
Mr. Dobson, as an assistant principal at that time, you would have been a mandatory reporter of abuse, correct?
Yes.
And you did not report any abuse in the Wade household, correct?
I did not.
Objection, Your Honor. Outside the scope of direct examination of what was asked of the witness, I never talked about abuse.
You could have called the Department of Children and Family Services if you did not think Alan Wade was being given what he needed to survive, correct?
I could have.
And you did not?
I did not.
Did you ever talk to Alan Wade or Frida Gainey about Pastor Schwartz and the wonderful things he was doing for the family?
I don't remember. I knew at some point, I think I knew that Pastor Schwartz was involved when I went to the previous testimony or whatever.
Okay.
So, no, I don't think I knew a whole lot about that aspect of his life.
And were you aware that up until about 15 or so, that Alan Wade was spending 2 or more days every week in the youth ministry of Pastor Schwartz's church?
I couldn't have told you.
In your interaction with Alan Wade, did it appear to you that he was significantly addicted to drugs or alcohol?
No.
And you would have done something about that had you known about it?
I think I would have done something about it, yes.
So my records indicate that Mr. Wade dropped out of school at age 16, which would have corresponded with his 9th grade year at Baker County High.
Yes.
Does that make sense?
Makes sense.
So what we're talking about happened when he was 15 years old, correct?
Mm-hmm.
Is that yes?
Yes, that is.
Just for the record. And you believe that Ms. Gainey loved her son based on your interaction with her, correct?
Yes, I did.
And the things that she was trying to do for her son, correct?
Yes, I mean, I don't remember, I wouldn't say that because I wasn't sure everything she was doing for him. I just knew that the conversations that I had with her, I felt like she loved him.
And she was at least doing her best to be involved with the education of her son, correct?
I mean, I couldn't answer that
Let me ask
question.
a better question.
Okay.
Sir. Thank you. So like, she would return your phone calls when you called?
Yes, yes.
And she appeared to be interested in what was going on with Alan in school?
Yes, when I talked to her, she was there. It was great.
And you have had the occasion to deal with parents that weren't,
Yes.
correct?
Yes, sir.
And parents that were, instead of working very hard to support their family and being absent, are absent because they're doing drugs or alcohol or any number of different bad things, correct?
That's right.
Okay, that's all the questions I have.
Yes, sir. Did you ever see Alan Sr. reinvested?
No.
Meaning Alan's father?
I didn't.
That phone call that you took,
Mm-hmm.
how did Alan react?
He teared up.
Burst out crying?
He was pretty emotional.
Was it obvious to you that Alan was a child that needed help?
Yes, I believe he needed attention.
Family support type of attention?
I felt there was a lack of overall family support.
And you wish you could have done more for him, right?
I mean, sure, anybody in those cases that I've dealt with a lot of kids, and you want to help them all you can.
After Alan had that reaction to the phone call, certainly didn't see him flourish much after that.
I really don't remember seeing him a whole lot after that, at all. Other than, obviously, later.
Right. May I have a moment? Thank you, sir.
Yeah, thank you.
Let me pose these questions to you from the jury. The first, what was the referral that Alan received that particular day? If you'll tell the jury.
Which day, I'm sorry?
I'm assuming we're talking about the day of the phone call to Ms. Gaines.
I don't think that was relative to a referral. I think it was him coming in and maybe expressing this concern.
Do you have any recollection of what his attendance history was?
I really didn't. There were so many students. He was just one of many, many, many students, and so I don't remember his attendance. I
I don't remember, normally there are processes if they're not attending, someone's attending to that, but no, I couldn't tell you.
Do you have any personal examples of Mr. Wade demonstrating empathy towards other people? Tell the jury.
Well, I do know that one of the things that that I asked him to do, a teacher expressed to me that he had been mouthy to her, or disrespectful, whatever you want to say, in the prior year. And I asked him to go and address that and apologize to her. And she came to me and said that he did that. So that was one. But I don't remember. I wasn't around him a lot, other than obviously the few times I met him in the office there, and so I don't know much about his interaction with people in that way. I do know he had an empathy for his mom. I do remember that he was sympathetic to what she was going through. He expressed that to me, and he had a, you know, he was disappointed in his dad, but as I recall, I think he said he was disappointed, but, you know, he also was appreciative of the times that he did get to spend with him.
Follow-ups, Ms. Abel?
Yes, which may just clear this up. So when Alan was in your office during that phone call, he wasn't there because of a referral that day?
I don't think so.
Okay, but he had referrals in the past?
He had referrals.
Okay, and we talked about this earlier in your direct, that nothing comes to mind that you can think of that was especially egregious out of any of those referrals?
No, but I mean, normally a student would be moved. We had an alternative school where people that were exhibiting really strong behaviors like that would be moved.
And Alan wasn't moved?
He was still at school.
Right,
so,
okay.
But I can't remember what the referrals were.
Mr. Mizrahi, you follow that? All right. Judge Dobson, thank you. You may stand down. Have a good afternoon. Ms. Abel, Mr. Richardson, Mr. Sorry? Sure. Do we need a reporter? Okay. Mizrahi. A point where it may well be, there's some logistical issues with defense witnesses that need to be addressed, and we may be at a point where if I call somebody else, it may slough over into later than what we would like. So I'm going to trust them to make the scheduling arrangements. So we're going to go ahead and take an evening recess. I am advised by counsel that there is a distinct possibility that most of the defense evidence should be over tomorrow, which means we should be able to conclude things on Wednesday pretty much as we had indicated to you before. There is still a, well, I'm not even going to say that. They're telling me that probably we should be able to be finished on Wednesday. So we are at the point where I'm going to give you my repetitive instruction about not discussing the case amongst yourselves or with anybody else. There has been, as you know, continuing presence of the press here, so please be discreet about your television viewing. Please have a pleasant evening. I'm going to ask that you come back and we will resume at 9:30 tomorrow morning. Okay? All right, the jury is in recess. If participants will please remain. All right, the jury has left the courtroom. Go ahead and be seated, folks. Who will be the first witness tomorrow, Mr. Richardson or? I'm sorry, Doctor? Oh, Castillo, okay. All right, well then, I would like to take a minute and share with you, this is probably to be categorized as thinking out loud, and I probably shouldn't do this, but I am mindful that you all need some indication. So I've been thinking about the matter of the allocution since last week, and I want to explain to you where I have gotten to. It is not definitive, and it's not binding on you, and it's not binding on me either. I had told you already that I believe that it was probably appropriate for Mr. Wade to have the opportunity to address the sentencer, because I believe in this instance that the jury is as close to a judge would be in our former system. So I believe it's appropriate for him to speak to the jury if he wants to. I have also come to the conclusion that the state should have the same opportunity after an allocution as it would have had in our prior system. And by that I mean that in a previous allocution, the defendant could tell me what he wanted to, and then Mr. Mizrahi would have the argument, have the opportunity to argue against whatever it was that was said during that consideration. So by the same token, I believe that Mr. Mizrahi should have the opportunity to comment on whatever the allocution is during the course of closing arguments. I have told you I am concerned about specific facts coming up during the course of any allocution, and I still remain in a position that I believe if those do come up, that it would be the right of the state to proceed to cross-examine, even though Mr. Wade would not be under oath, or bring in whatever rebuttal witnesses that he might want to do so. So that's the framework. It occurs to me that perhaps the appropriate thing to do is for Mr. Wade to provide a written allocution, much as we have under the victim's impact, different process, admittedly. But that would at least give me the opportunity to decide whether or not I'm likely to find that there are statements, and of course it gives Mr. Mizrahi the opportunity, to look at that too. So that's my thinking right now. I do not need commitment from counsel about that at this point, but.
I think that if you provide written allocution, you can do it next Monday.
We give it to
Well,
the state with the allocutes. I just don't give them this allocation ahead of time.
Well, you get the victim impact statements ahead of time. Why would he not? I'm going to want to. Okay, we can talk. I asked to talk. So I say it's okay that I like this. What opportunity does the state have to disagree? I mean, how is he going to know whether or not there's facts to which he might object? So I'm not.
You can say that the defendant should testify because they get a preview of Mr. Wade's testimony, and I think we're in agreement with everything the court has suggested. I don't anticipate his allocution covering anything related to the crime, to be honest. And so I have no objection to providing the court with the statement ahead of time and give it to the state, which is when, they would be hearing his testimony if he were to.
Ms. Miller. Yeah, I understand what you're saying, but this is my proposal. He either provides it in writing and I share it with Mr. Mizrahi, or he doesn't provide it and you wing it. Well, he gets up and starts talking.
What Your Honor is saying is that we're willing to, not just for trial, provide a copy of whether.
I'm willing to discuss it. I'm willing to hear arguments about it. I don't, I don't want to suppress anything, but what have I, I also don't intend to cut another major party out of this process. And if, if Mr. Mizrahi has, I'm imagining that Mr. Mizrahi is not prepared, or does not want to sit there and lay landmines for Mr. Wade. So why not, have everybody, I know Ms. Miller is leering at my comment. As I said, sure, I'm not expecting a commitment. That's my thought process right now. I don't think it would be fair for me to see the allocution and approve it. I mean, talk about taking sides. Comment not necessary. All right, that's where I am on that. Any further thoughts or comments about this proposed verdict forms?
You're asking that the court give the standard verdict form, the standard instructions promulgated by the Florida Supreme Court in 2018, as well as the standard verdict form are still. There have been approximately 11 capital cases tried since the decision. I think all but one that Mr. Mizrahi was involved in recently have used the standard instructions and the standard verdict form. In deciding pool, the Florida Supreme Court said, we're making these decisions as a matter of interpretation, but we're not commenting on the amendments to the statute the legislature made. The statute remains the same, right? The step process where the state is required to prove an aggravating factor or factors beyond a reasonable doubt, sufficiency of the aggravator, whether the defendants establish mitigation by the greater weight of the evidence, whether aggravation outweighs mitigation, and ultimately if death is the appropriate penalty. Those are also statutory and the statute.
Ms. Miller, I understand that. I just want to know what the form is. I mean, the last time I looked at one of these, when it came to the aggravators, there was an actual vote. We find the this aggravator 12-0 or 11 or whatever. I don't remember.
It doesn't have to split on it anymore. I don't have a problem for it to one to split. It just says we find this aggravating factor proven to exist unanimously beyond a reasonable doubt, and then the form lists the aggravator.
Okay, that's fine. I mean, if that's what the current form is, as I said, I haven't looked. I had no reason to. What about mitigators? Is there?
We are asking that the mitigators and the list that we've given Your Honor ex parte is tentative. I anticipate cleaning up to mirror the language as the testimony was produced. I understand, but it's pretty close. We are asking for that mitigation.
Okay,
In the instructions and
I'm gonna get. I told you already. I will give them all the mitigators that you established. What is the phrasing about? We find by a preponderance of the evidence that this mitigator was established.
Greater weight of the evidence.
Or greater weight. Okay.
Yes, and the case that I did hear with Mr. Mizrahi about a year ago, the state of Florida versus Russell Tillis, the state actually asked for all of the mitigating circumstances given on the verdict form. I'm paraphrasing, of course, but the state's argument essentially was that if a 12-0 death verdict was returned, the court to give weight, right, to whether the mitigating circumstances were established, the court needed to know what mitigating circumstances the jury found to exist in by what number. So it certainly provided the court that verdict form that had mitigating circumstances listed, and there was a split of some mitigators, but obviously doesn't have to be unanimous.
Okay.
I agree with the defense to the extent that the instruction should contain all 5 of the weighting factors.
No, I wasn't.
That's not in the state's standard instruction. The state has come to the conclusion, notwithstanding what I agree to, but subsequent to that, the statute only requires 2 jury votes. One is as to the aggravating factors, and the other as to the verdict form. The other weighing process are mandatory, but do not require separate jury findings. state's perspective, including all the mitigating factors in the verdict, it becomes very, very difficult to parse out exactly what the jury is supposed to find. Are they finding that the mitigators exist? In other words, has it been proven Alan Wade was innocent? Yes or no? And then the next question is that mitigated? So if you are going to include both of those elements, it becomes very unwieldy, difficult to parse out what the jury is finding, verdict form, understand. They're not required by law. Law requires aggravating factors and verdict form, state's defense is requesting a negative verdict form, all the mitigating factors, one or both of the findings, one proven, two or not. And then again, let me finish by saying, the problem with voting whether they're mitigating is we have no concept of weight. So I think if you talk, so I think it's very problematic to have those in the verdict form, even if we include in the instructions what mitigating factor is.
Why am I concerned about the weight that they assert if I tell them you can only do it by the greater weight of the evidence?
Because we're asking the jury to make findings that don't have to be made. It's like asking the jury to say, well, we find the defendant either guilty or not guilty, but we have to have separate findings about the credibility of each witness, or separate findings about the weight of the particular elements, or separate findings about what we found, ask yourself if there's or not something. Law consequences, the jury makes ultimate findings not based on the rating, based on first, the statement. The jury has to make findings, has to aggravate them. Why? Which the statute and Supreme Court says have to be made. That's what should be on the jury, as well as the ultimate findings of how the sausage is made. The state feels is too unwieldy, confusing for the jury, not appropriate to include those in the jury. Forms, albeit quick, argue them and need to be included in the instruction.
Go ahead. A couple separate issues. I think, Mr. Retrial, correct me if I'm wrong, we agree on the instruction. What is going to give the standard instructions of the 5-step process was the beginning.
I didn't ask you about instructions. I asked about verdict form.
Okay. So then there's two issues on the verdict form. Okay. We are asking that the court give the standard verdict form. The state is asking the court to modify the standard verdict form. On the standard verdict form, there is a 5-step process. And the 5-step process, I would respectfully disagree with the state's representation, is required by the statute. I'm referring to Florida Statute 921.141, subsection 2, refers to findings and recommended sentence by the jury. This subsection applies only if the defendant is not waived to deserve the right to a sentencing received by a jury. Skipping down, subsection E says the jury shall return findings identifying each aggravating factor found to exist. A finding that an aggravating factor exists must be unanimous. If the jury, colon, 1 does not unanimously find, blah, 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 then subsection 2, so we're now at 921.141 sub 2, sub B2 says unanimously finds at least one aggravating factor the defendant is eligible for a sentence of death, and the jury shall make a recommendation as to the court as to whether the defendant shall be sentenced to life imprisonment without the possibility of parole or to death. Recommendation shall be based on a weighing of all of the following. A, whether sufficient aggravating factors exist. B, whether aggravating factors exist which outweigh the mitigating circumstances found to exist. C, based on the consideration in subparagraphs A and B, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. And so the statute absolutely still requires jury findings. The state is kind of misplacing Supreme Court's decision in Poole was saying that the two separate rulings. And I can see the board saying, okay, I'll give the standard form, but not the mitigators.
That's what concerned me about, considering the number of mitigators. And let me go back a minute. I can see how the statute could be complied with by asking questions, which did not necessarily mean that I have to ask you, did you, and I'm not going to quote from your, we'll say mitigator number 6, defendant's mitigator number 6 that I have the list of. Are you suggesting the verdict form says yes or no? And do I expect them to?
Instead of saying yes or no, it was just, you find, I can give you, as we did previously, is that you find this mitigating circumstance proven to exist by the greater weight of the evidence, and it has a mitigator listed, and just put it underneath it. So some of them, for instance, in the case of Mr. Disregarding, would say 0 to 12, meaning the jury didn't find that mitigating circumstance, or mitigating circumstance found to exist. Some would say 12 to 0. Some would say whatever the circumstance.
But what do I care what the actual vote was if the jury says we find this mitigator to exist?
They can say that. I don't really.
That's what I'm saying. That's what I mean when if you ask the question.
Sure. Well, and so.
Not how did you vote it? Now we're talking. I'm talking about mitigators. I understand we're going to have some sort of specific revelation of the vote, if you will, on the aggravators, but.
You don't need the number on the aggravators because the aggravators have to be unanimous.
I understand. I mean, yes, we have unanimously decided in a case.
Well, and what's interesting is the state and I switch sides. So I heard Mr. Disregarding argue the exact opposite position a year ago, and I was objecting kind of because of what the court had said, the unwieldiness or the cumbersome list, and frankly, the statute doesn't assign a burden to us as far as burden of proof when it comes to mitigating circumstances. The first Supreme Court randomly did that when it came up with the jury instructions and the verdict. But Mr. Disregarding's point, which Judge Morello agreed with over my objection, was that if it is a 12-0 verdict for death, Your Honor could still sentence Mr. Wade for that shooting. And so there are some significant mitigating circumstances, some statutory, some non-statutory. And so how is Your Honor able to appropriately weigh the jury's verdict, right, to give it great weight in sentencing Mr. Wade to either life or death if you didn't know which mitigating circumstances the jury found to exist? Because you're bound by their verdict. And so you can't say, essentially, I don't find any mitigating circumstances. The jury found mitigating circumstances. And so the verdict...
But that gets back to why does it have to be a vote?
I don't care if it's not a vote. I'm fine if it's just a tally. The vote is what Mr. Disregarding had suggested before the prior case.
All right.
One other thing I would say as we move on, standard construction is not what this alcohol mitigation. Standard verdict says under paragraph C, mitigating circumstances. It says one or more of individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence, yes or no. That's the standard. So we're both modifying the standard.
No, we won the standard, and when the Supreme Court promulgated these standard instructions, they invited comment from a whole bunch of organizations about whether we wanted the specific mitigators, the defense bar, the FP, Portable Defenders Association, Factual, a bunch of different organizations submitted proposals about whether we wanted mitigating circumstances on the verdict form or not. And essentially, it was kind of left on a case-by-case basis. There were some defendants in their counsel who said we don't want it. There were some that said we do. But we're asking for the 5-step process, period.
All right, this is what we're going to do. Assuming, based on Mr. Johnson's representation earlier, that we might conclude tomorrow, then I would like by noon tomorrow, shall we say, each of your proposed verdict forms. And I will look at it, and Amanda and I will talk about it, and I will do something. Rightly or wrongly, I will do something.
Well, you know you're going to do something.
At least I'm going to do something. So, okay. All right. I have expressed my concerns about allocution and the jury verdict forms, what other matters does the council need to talk to me about, Mr. Mizrahi or Mr. Cooper? Anything from this end? All right. Shall we resume at, say, what, 9 o'clock? Well, I don't know. What are we going to? The jury's coming back at 9:30. Shall we reconvene at 9:15, just in case there are administrative matters we need to address? Okay. All right, then we is in recess until 9:15 tomorrow.